Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And how are you guys doing today? Man, I hope you're doing well. I'm doing fine. Thank you for asking. Goodness gracious. Super rude. Super rude. I'm very disappointed. Super rude, right? Super rude. I'm just kidding. Of course, I am doing very well. However, but it's time. It's time for this Kim Potter trial to continue. And oh my. Oh, excuse me. Yesterday was a little dramatic. We'll have to see if today is dramatic at all. We're expecting the case in chief of the defense to begin pretty much right away. So we're expecting the state to rest. And John, yes, I would love that clip. If you have it, if you want to send that over to me somewhere, I would appreciate that. That'd be great. Where is based Bronca? Right now, let me make sure. I'm pretty sure I sent out the invites, but we don't have anyone in the guest list yet, which is perfectly fine. We'll see if people join up. Whew. Oh my. Excuse me. I just woke up. Of course, it is also my birthday. Thank you to everybody who was up late with me last night. I appreciate that very much. But oh, we do have a guest. Hold on one second. Is that you? Weird. Okay. Let me welcome our guest in. Mr. Uncivil Law. Welcome.
Happy birthday to you.
No.
Happy birthday to you. Happy birthday, Nick Rekieta. Happy birthday to you.
Thank you. That was lovely. I feel awkward. Hey, what's up, man?
Nah, not much, man.
I do appreciate it. Thank you. Thank you. Oh my goodness. So what do you think about
The state finally rested?
Well, they said they expect to rest.
Oh, okay. That's way different thing. That's like the defense is going to begin today, but they haven't actually rested. They expect to rest, so that means they haven't rested, which means they'll never rest, and the hell continues.
The state can never rest. Ever vigilant.
Ever vigilant.
They will remain. No, they I believe they anticipated resting right away this morning. They probably wanted to reserve the possibility of reviewing yesterday and doing something else today. I think they may have a witness. Their witness list was so long, they've probably still got somebody they could theoretically call, but I think the idea is that they would rest right away, and then the defense's case in chief would start, and we'll see what happens. Oh, excuse me. I think we're in for some character witnessery right away, and
Yeah, I mean, the state's case continues to make very little sense as they press the case forward, and not only was the testimony repetitive, it was pointless because it doesn't help to make the case more any better.
Right.
And the experts they called, the answers were very predictable. It's like maybe I've watched too many cases or read too many decisions at this point, because it's like even for most of the experts, it's like I can predict the answers pretty well. So maybe I'm just an expert in all the things at this point because I like know the answers to a lot of it because I've seen so much of it. But yeah, it's exactly what you would expect. It's the situations are chaotic, the situations are difficult. We can't give out uniform guidance on all the situations because there's no possible way to do that. It's literally impossible. How are we supposed to categorize all the things? There's just too much dynamic. We have to give guidelines and best practices, and it's like, this is what's happening, and this is a good cop. She's been a good cop for 25 years, no history of problems. People liked her. She was attentive, responsive. She doesn't have a history of abuse or a history of neglect, went to the classes. It's like, so, there's just nothing here.
Yeah. They will have their use of force expert. They have a slip and capture expert. I think that's what it's called. That's when you screw up. That's your screw up expert, and why you screw up expert. Some sort of psychiatry. And then, yeah, they have the character witnesses. The interesting stuff, of course, revolves from yesterday, revolves around the defense's use of force expert, since they did not have their expert file and or their expert opinion from their expert didn't involve the use of deadly force, right? Like, so there's some contention over if their expert will be allowed to testify about that.
Yeah.
I do find it odd that they wouldn't let the expert address things raised in the trial specifically, but if they didn't brief it, they could possibly be excluded. And I do not know why that would not be included in the report.
Yeah, that seems very strange to me. It's like, why wouldn't you want both those grounds covered as the defense?
Because that was one of the first things I thought about the case when I sat down to actually analyze the legal aspect was, well, she might have been justified just killing him.
Yeah.
And so it's like, if I'm thinking that, I would think that, they and their expert would be thinking that, but who knows? Who knows what the strategy is? Maybe they thought they could get it in without it. We may see the mistrial motion happen for the expert witness's weird testimony about Dante Wright just being capturable later on.
Yeah.
That was
so
wonderful.
Since I hadn't seen the testimony from yesterday with the one use of force expert that they called, who apparently said that even a taser was inappropriate.
Yeah.
Did they say specifically why it was inappropriate? Was because it was in a car that was inappropriate, or was there some just because it was in a car?
Yeah.
And
so
they might lose control and speed away.
That's basically it. So the gun was inappropriate because either Sergeant Johnson was in the car and therefore in close proximity, so that made it inappropriate, or Sergeant Johnson was not in the car, so therefore deadly force was not justified. For the taser, hey, here we go. Welcome to the show, Mr. Branca.
Okay.
Welcome. Can't hear you.
He'll tune in eventually.
Hey, how's that?
There we go.
Yay.
There we go.
We're running a little late today.
Oh yeah, no worries. So we've got Kurt and I are talking about the defense use of force expert yesterday, and why he specifically said that the taser was inappropriate. Oh, do you have it now? He's working on his audio. So anyway, the taser use of force, or he said the taser was inappropriate because yes, I believe the conclusion was that the car was in motion or could be put in motion, which are two distinctly different things. So basically, the
All right, I'm
idea.
here.
Oh, hey, we're just talking about the use of force expert yesterday, talking about how the gun was not appropriate and the taser was also not appropriate. Apparently, the only thing appropriate would have been asking nicely for him to comply.
Not even a harsh word.
He did. I mean, he did say that the appropriate action was to use the appropriate amount of force. So
Which is what exactly?
He did not ever elaborate on what that was, and said that again, that Dante could leave, and since they knew who he was and where he was, that he could be easily apprehended later.
If you're the defense lawyer, I mean, you don't normally ask the question you don't know the answer to, but this might be an exception to the rule because you don't care what the answer is. If you ask the question, okay, so you said that wasn't the appropriate use of force. What is the appropriate use of force? Now, you just asked an open-ended question on cross that you don't know the answer to. So this is dangerous territory. But what is he going to say? I mean, if it's not the taser, if it's not the gun, what's he going to say? Well, you pull him out. Well, he's a gun. So you're asking the officer to put themselves into the car, which puts them in further dangers. So that answer doesn't make sense.
According to Frank, you're not allowed
and
to
if the answer is use pepper spray, well, now you're suddenly blinding him as he might be speeding away. That doesn't make sense. If the answer is nothing, let him get away. That answer doesn't make any sense. So none of the answers make any sense. So no matter what he says, you can criticize him and be like, all your answers are equally pointless.
Yeah, and that I think they did get there. I do think there were some mess ups on the cross on that witness. I think there was more to, and I'm trying not to criticize too much because Gray has been fantastic throughout this trial, but I think that witness. Ooh, here we go.
Test. Can you guys hear me?
Yep.
Yes.
Okay.
Yep.
For some reason, I'm not coming back into my own headphones. I don't know.
At least in my ear, you're a little bit soft. I don't know if that's true for you, Nick.
Yes.
Is that better?
Bit. Yes.
Test. Okay.
But yeah, he came across the witness came across very weaselly yesterday, evasive, and I think people are curious. I mean, when you say that the appropriate amount of force is the appropriate amount of force, I mean, you've created a completely.
Well, thanks for the
pointless
tautology.
statement.
Tautology is tautology.
Yeah.
Appropriate's not a thing. I mean,
That's
that's just an emotional take on whether or not you happen to personally like how much force was used.
Right. I do like his other cop in proximity standard for as disqualifying a use of deadly force, which doesn't make sense either.
Unless firing a gun is absolutely safe, which it never is, it's inappropriate.
The first rule of Tautology Club is the first rule of Tautology Club.
Let me hit a couple of these early chats. Caleb G says, first, happy birthday. Hey, thank you. Second, I need legal advice. A guy tried to end me this morning by telling all these Harry Potter nerds to reevaluate their life choices. Nearly choked going to work. Hope you guys have a great day. Or hope you have a great birthday. Thank you. Yes, and whoever said that sounds like a wise individual. Patriot Kane, I will check my email from Yellow Rose. Thank you. Great birthday show.
All right. Yes.
Mad8 says, I think you should put up a pre-stream poll, 1 late and gay, 2 normal and normal. That way we can have some more fun in the chat. Daniel says, happy birthday, Nick. None Your Business says that gut-wrenching feeling when you send a super chat question about someone on the stand, then realizing you're 30 minutes behind and the person had been off the stand for 15 minutes. A common problem. Angry Baneling says, happy birthday, Nose Man. May you live through 40 more of these. Now I was told there would be cake. Where's the cake? Ship me a slice. Thanks, fam. Sorry, my cake shipper, international cake shipper, Batman. He was bullied out of the Discord server.
Go and put your name on it. Your name on it. Go and put your name on it. Not even my birthday, but I want to blow those candles out. You know you want that cake.
What
cake,
is-
cake. I'm here with all the songs for your needs.
I like it.
Yes.
Billy Witch Doctor says, happy birthday. Also, did you hear Kentaro Miura died? Also, any Vic news? Also, has anyone ever beaten the brakes off of you? Yes, no, and never. None of your business says I jumped in late. Any hangover from last night after all that expensive booze? No. No, it's beautiful. Matt Hagan says, happy birthday,
Okay,
Nick.
please be seated.
Very important question. Who's your favorite chaos god? Corn. AA Ron says, good morning from Watertown, Minnesota. And happy
All
birthday.
right, good
Thank
morning,
you.
members of the jury.
And Yellow
I,
Flash says, happy
was
birthday.
pleasantly surprised that we didn't have the icy roads that we thought we were going to. So,
I see roll.
all right.
She has her hair down today.
Do we have any further witnesses?
She was at Nick's party last night.
Morning. No, Your Honor, the state rests.
Okay,
Oh, thank God.
Right.
members of the jury, I need you to step out for a couple of minutes, about 10 minutes.
Oh, man.
State is asshole for that. Wilder's Honey says, flappy birthday, old man. True. Abe Eckstein says, uncivil law, you're a great dude, but my ears are bleeding. Faust.
Right, please be seated.
They're bleeding from joy.
Okay, Mr. Ing, you had a matter that you wanted to bring up.
Your Honor, the state has now rested. The defense moves for a judgment of acquittal.
Oh, they did rest. Okay, thank
I
God.
realize that the facts are construed most favorably to a potential verdict and consistent with the guilt. On the other hand, the testimony is confusing at best. The theory advanced yesterday is that a taser was inappropriate to be used. That was an opinion of Mr. Stoughton. The testimony, though, has been that the taser was reasonable to be used. So the state has presented
What was that?
witness after witness,
Sorry.
either on cross or
Something in the
direct.
background.
Speaking of Peterson Lucky, for example, who've indicated that the taser was quite reasonable to use, should have been used. I think they were pleased that it was used, or at least something was done. So we have a sort of this discordant presentation. I mean, if the theory of the government is that the taser is inappropriate, then they've presented conflicting evidence to that opinion. If the theory of the government is the taser was appropriate, then the expert's opinion is inappropriate. And that also goes for the use of deadly force as well. I mean, we have Johnson's testimony and Fleshling's testimony, and we have Stoughton's testimony. So it's a confusing mess, really. And I say that in all due respect to my colleagues on the other side. When you denied our motion for the judgment of acquittal on the manslaughter count one, the opinion was, of course, thorough and well done. But it also commented how the probable cause standard is quite de minimis compared to the standard of proofs beyond a reasonable doubt. And so they still have to show that, at the moment, and it is a standard at the moment, she thought she was employing her taser. Everybody agrees to that she had a knowledge that she was about to commit a violent act, and with that knowledge, however obtained, disregarded that knowledge. That's really a high burden to meet under those cases we've been talking about. So while the probable cause was perhaps suitable to satisfy both charges, which are related to each other, really. I mean, the consciousness of guilt and the first degree standard are quite similar. The evidence in our view is insufficient. We request that you dismiss both counts, but particularly the man one count, which the court already discerned is quite weak. And nothing has happened here to make it stronger. I also want to make an offer of proof consistent with what we were talking about yesterday. I can do that now or wait on that. I defer to the court's discretion.
Okay, why don't we let the state respond to the motion for judgment of acquittal first?
Thank you, Your Honor. My understanding,
Sorry.
habits, yeah. Your Honor, the standard for taking a case from the jury's hands is actually quite high. I think the court has to basically issue a summary judgment that there's no way under the set of facts presented to the jury they could arrive at a guilty verdict. That certainly has not been met here. I take it from counsel's argument that the real challenge is to the recklessness or carelessness elements of the statutes. I know there have been arguments made about causation, and I'm sure will be made, but pretty clear the testimony that the court heard was that the bullet that Ms. Potter fired into Mr. Wright's chest blew up his heart and killed him within minutes. That's causation. The elements of recklessness, Your Honor, as you know from the jury instructions you've crafted carefully, talks about a reckless handling or use of a firearm for the first-degree manslaughter charge. Here we have a 26-year veteran of the police department who was trained every year in how to handle her firearm and had to qualify every year to handle her firearm.
He's using recklessness in the colloquial sense here.
And yet did not know she had her gun in her hand when she shot Mr. Wright.
If she didn't know, it's not reckless.
Facts bear that out on her statement alone, which the court and the jury has seen. But that is raises the issue of the recklessness of her act. She committed a conscious or intentional act in drawing the firearm. There was evidence that she prepared to do that. She pulled it out of her holster, pointed it directly at Mr. Wright, and fired it without knowing it was her handgun.
She didn't know.
Can only be said to be reckless in and of itself, and certainly is something for the jury to consider. The second-degree manslaughter charge has culpable negligence, which is that the defendant did not intend the act to be harmful, but that an ordinary and reasonable person would have recognized the actions created a strong probability of injury to others. That is an awareness of the risk and a disregard of it. Again,
But you do have to intend to create the risk.
With respect to the decision to use a taser and instead using her firearm, which really applies also to both counts. She has been trained multiple times over her 26-year career, certified as a taser user since 2002, received trainings that the jury has seen, the court has seen regarding weapons confusion. It was an issue known to everybody in law enforcement, was taught to her multiple times. She was aware of it, therefore, as the evidence. And by pulling her firearm instead, and acknowledging that she knew about weapons confusion in the sense that she had been trained on a taser. She knew enough to give a verbal warning for that taser, shows intentional conduct that was done with an awareness of the risk and a complete disregard for the risk. Those are the basic, as I understand the motion, contested elements. There's certainly sufficient evidence. The state did not present conflicting evidence. I think what counsel is referring to is the evidence.
These motions are never granted, by the way, folks. So
No.
don't be surprised.
It's exceptionally rare.
And if there are conflicting pieces of evidence, that's for juries to weigh. So the defense has not established a basis for their motion to be granted today because there is adequate evidence for the case to go to the jury. We would ask the court to deny the motion.
Okay. A judgment of acquittal can't be granted unless the trier of fact could not reasonably find the essential elements of the crime are established beyond a reasonable doubt. In ruling on that motion, all reasonable inferences and the evidence has to be viewed in the light most favorable to the state. That's the standard. And given that standard, I'm denying the motion for an acquittal. A couple matters from yesterday. I am going to allow the defense expert to testify about deadly force. Okay.
There you go. That's a win
That
for the
was a
defense.
topic that was extensively.
It would have been insane not to.
uh,
Deadly
by
force was
the
always a play here as an
expert.
issue. The state knew it. They were on effective notice.
State, obviously, to have the expert testify on deadly force, and there really are no surprises on what the expert's going to say. Then, Mr. Gray, I think you wanted to be heard on.
Should I go to the podium?
Yes, please.
All right, I got to run actually, but I might be back later this afternoon.
See you, buddy. Thanks
Happy
for the
birthday, man.
thanks for the happy
Good morning.
birthday
No
wishes.
worries. Have a good one, man.
Your Honor, I
Yeah, happy birthday, man.
gave
Thank you.
Exhibit, I can't remember the number of it. The exhibit is a
Once,
certified copy
Yeah.
of the conviction of Mrs. Wright, the first witness. You might recall, Judge, that before the trial, Your Honor ruled that we could bring up the fact that a felony conviction was, that she was convicted of a felony convictions, and the date of it was within the requirements of the law. Well, the state, in their presentation, said to the witness, well, you were convicted of a second-degree drug offense, weren't you? Something to that effect, which was not the judge's ruling. The judge ruled that you could just say felony conviction. And instead of embarrassing the witness more than need be, we refrained to get up, we restrained getting up and pointing out that the conviction was, I think, about a year ago, that she was convicted of this felony. Rather than do that, we decided to offer in the evidence, since they now have presented the conviction. The court knows that they can do that, or we should be the ones that can do it within the time period required by law, that we would have a right to show the date of the conviction, because the jury has no idea when this conviction occurred. So we waited until we presented our case. We obtained, excuse me, Your Honor, we obtained a certified copy of the conviction, which is admissible under the rules of evidence, and it's self-authenticating, and we offer it as in our exhibit. Thank you, Your Honor.
All right.
Excuse me, I'm sorry. For the purpose of showing that when she was convicted of the felony of drugs. If they're willing to stipulate to that, we don't need it. But if they're not willing to stipulate to the date that she was convicted of this, then we need it to prove it. Thank you.
Okay, you're not going to bring it up in your case in chief, obviously, are you?
No, I need that to show the date that she was convicted.
Okay. Does the state object?
Yes, Your Honor, the state objects. The court's prior ruling was that if Ms. Bryant was other than a spark of life witness, that she could potentially be impeached with an unspecified felony. That's how the court characterized it in the court's order. On direct, the state fronted the fact that there had been a conviction, which I believe was characterized as a felony conviction for second-degree controlled substance possession. That was fronted. Counsel had the opportunity to cross-examine on that point if it desired at that point, if the defense so desired. This issue was not raised at that time. Defense counsel essentially waived any right to cross-examine on that point. We fronted information that went beyond what was required under the court's ruling. That, however, does not.
She didn't say felony.
The court's direction, which was essentially that
Just said second degree drug charge.
under the rules, the court has already decided that extrinsic evidence or other unrelated information about this conviction is clearly improper here. Had counsel wanted to inquire about the date of conviction at the time, I don't know that we would have taken issue with it. But at this point, with no foundation,
Yes, you
with no
would've.
witness, they now want to offer evidence, extrinsic evidence of a conviction that has absolutely nothing to do with the issues in this case, is completely collateral, is completely improper at this point. And we'd object, Your Honor.
Well, Your Honor, itself authenticated. We didn't cross-examine her on it because we followed the court's ruling. And what we're doing is attempting to show the date, and the date is shown on that without asking her a question. I was actually surprised when the state asked her, were you convicted of a second-degree drug conviction? I thought that was a violation of the court's rule of they were convicted of a felony. But they did not. I would not know what she would say as far as a date because I didn't ask it because of the fact I didn't want to further embarrass her. But we have the certified copy of the conviction. If they're willing to stipulate to the date of
Feels like the defense just dropped the ball on this.
but if they're not, we have a right to present evidence.
You know, I don't know what good
The date of
having
the
this
conviction.
evidence in there would be for them.
It's not
Anyway.
impeachment.
Well, they would be able to talk about it on closing.
Yeah,
Your
that's
Honor,
true.
counsel had an opportunity
They already
to
kinda
raise
can,
this issue,
just
to bring
not the
this issue
date.
to the court's attention, to address any questions about date. I have not, I believe that counsel walked in with a copy of the conviction, showed it to my colleague at counsel table and handed it to the court. My understanding is that document, although I don't have a copy myself, includes a lot of information that clearly does not pertain to the date of conviction. I
Just
presume
stipulate
it
to the
has
date.
information about, plea and sentence and things that clearly are not within the purview of the rule that governs prior convictions. And I do want to point out for the court that the court's original ruling was that there was essentially very little room for defense counsel to even inquire about this. We fronted it because we wanted to do that out of an abundance of caution, the fact of conviction. But other than the fact of conviction, none of this is relevant, Your Honor. And we object strongly.
Oh,
Well, they brought it up, Judge. We have a right to show the date.
okay. You had the right to show the date at the time that you cross-examined.
Well,
That's
I
right.
could have asked you, but that would have been a violation of your rule about a felony. I wasn't going to violate your rule, even though they did.
I'm not going to let this in.
Could we have a stipulation that would be allowed to stipulate as to the date of the conviction?
Is the state willing to just acknowledge the date of the conviction?
No, Your Honor.
No, Your Honor. There's absolutely no basis for us to do that at this point in time.
And of course, the state is interested in justice like they're supposed to.
Okay. Yes. All right. The admission of this exhibit will be denied. It's marked 1007. Okay, Mr. Frank?
I'm being presumptuous, Your Honor, that I may address the court.
Yes?
I think, as you know, as a trial judge of many years, the certified copy of the conviction is used to impeach the witness if they deny the conviction. It doesn't go in as a substantive exhibit itself. So even the process.
Why are
here
you
is
arguing
completely
this? You
wrong.
already won it.
But I understand the court's ruling. I just want to point that out, that to me, it's somewhat disingenuous to say we didn't want to embarrass her then because they didn't want to ask her while she was on the stand and look a certain way. Now they want to do it. Anyway, I'm
Well,
sorry.
you guys, I think we spent way too much time arguing this point, which is totally collateral.
Thank you, Your Honor.
Okay.
I'm sorry. Your Honor, I indicated to the court yesterday that we would object to Mr. Imes testifying about deadly force opinion. I raised it so the court would be aware of it, that we would need time, but I do want to address it because I think it goes simply beyond what was raised yesterday about it. Your Honor, we received an order from the court. The court filed back in August, I believe. No, I'm sorry, June 2nd of 2021 with an expert disclosure deadline.
Yeah, I already ruled on this.
But I haven't had an opportunity to be heard, Your Honor, and I think we have an opportunity to be heard. That's why I
You were
fronted
heard
and said,
yesterday.
we need time this morning to address this. As you will also recall, well, maybe you don't know this, but Mr. Eng and Mr. Gray were going to meet with Mr. Imes last night. We have an additional disclosure. And so I want to address this because what we have here is flouting of the rules in the court's order. And the prejudice comes from not knowing what this witness is going to say, not what we know our own witness is going to say. So I would like to address that, Your Honor.
I'll let you continue. I didn't
So-
let you argue this morning on that point, but go ahead.
Thank you, Your Honor. The court's order required and cited to the rules of criminal procedure that require it as well, that disclosures of experts would be made by October 15th of 2021, and any rebuttal to those disclosures would be made within 30 days. The disclosure required all findings, opinions, or conclusions to which each expert is expected to testify, and the basis for their findings, opinions, and testimony. Purposes for that are obvious, so that there is notice to be prepared for trial, so the opponent can fairly meet the evidence that is going to be presented. As we recall yesterday, Mr. Gray objected because the witness had used one word, subjectivity or subjective, that he couldn't find in the report. And at that
Actually,
point,
that is what I brought up, not Mr. Gray. Okay.
he brought the objection up and the court asked that. And what the court had said at that time, if it's not in the report, you're not going to allow it for testimony. Your Honor, here is our expert's report. It's 52 pages long, single spaced. It's very thorough. It has captions, headings, opinions, explanations,
Not very
basis,
good ones.
all set forth in these 52 pages. The report that was disclosed to us was from Mr. Imes is a little over 2 pages long, Your Honor. The opinions in it are really encompass less than 1 page. Most of them, in fact, all of them are very conclusory and simply state in one sentence an opinion. No basis for that, no discussion of what they will testify to support that opinion.
But you've had this forever.
So you're familiar with it.
Oh, no complaining about it now.
To say the least, conclusory.
They
The
should have moved to
disclosure
exclude him.
that the defense provided, Mr. Eng signed and filed, says simply that Mr. Imes will testify that Officer Potter's decision to use a taser was appropriate and consistent with standard training and police procedure. Nothing about deadly force or the use of a firearm. Your Honor, before trial, when we met with our expert witness, this is a copy of what we disclosed to the defense. It's thorough, and according to Mr. Eng, painfully thorough, 4 pages long, single spaced, with a complete description of our conversation with the expert at that time. We're complying with disclosure requirements about what our witness will testify to. Last night, I received an email from Mr. Eng. He sent it at 7:24 p.m., but I didn't see it until about 9:30 p.m. because I have a home life, right? We all get to go home and have a home life. So I didn't see it till 9:30 last night. It contains 6 sentences, 6 numbered sentences. I'm sorry, one is actually 2 sentences, but in 6 numbered lines that are single conclusory statements about what Mr. Imes apparently is going to testify about. No explanation of the bases for that or what else he will testify about. So what we have, Your Honor, and yesterday, and I have
Well, that form was acceptable to you with his last report.
And so we have been given no knowledge, no information about what Mr. Imes is going to rely on to support his opinions. We just have these conclusory
His
statements.
expertise.
There's nothing in the reports or this follow-up about his basis for the deadly force opinion. We disclosed our expert's report that has 3 or 4 pages on deadly force back in October as we were supposed to. And they were clearly on notice then that deadly force was an issue. They requested a jury instruction on deadly force, and yet we're getting disclosures about a deadly force opinion on the night before this witness is supposed to testify in the morning. Your Honor, this relatedly, the defense intends to call Tim Gannon today. The disclosure we got from Tim Gannon, November 8th, is provided by defense counsel when they met with him. It's a page and a half, and it is woefully inadequate. And just sort of interestingly, like the very first paragraph says, we talked with him about his education, his law enforcement career, working relationship with Officer Potter, mentions that she was the union representative, and then just says, we're summarized. So rather than telling us what information they got, it just says that it was summarized. We didn't get the summary. It goes on, Your Honor, to present very conclusory statements. The close proximity of her taser to Mr. Wright was not concerning under the circumstances presented, period.
Why didn't you
No
file a
basis
motion
for
in
that
limine
opinion,
in
no foundation
November?
for that opinion. Goes on to say her assumed use of the taser was reasonable and appropriate. No explanation as to the basis for that opinion or
That's the
why
testimony, man.
he would offer
That's why you
that.
get to cross.
Then, Your Honor, we got a disclosure from an interview with Mr. Gannon on December 6th of 2000. So after trial had technically started, where he now offers, Mr. Gannon will offer an opinion about deadly force. Little to no explanation of the basis for that opinion, his foundation for that opinion. And so, again, what we're getting is they didn't have an expert talk about deadly force. Now they're trying to turn a former police officer who worked with Ms. Potter into an unnoticed expert witness who's going to offer an opinion in violation of the court's disclosure order.
Well, Chu's already allowed officers to talk about what officers know about.
To disclosures for such opinions, even setting aside whether it's appropriate for a
You asked your use of force
lay
expert to be a
witness
taser
offer
expert.
a legal opinion as an expert. We followed the rule in the court's order to disclose our expert. Now they're trying to slip in somebody because they didn't. What we're seeing, Your Honor, is a pattern of flouting the court's orders and the rules and trying to litigate by surprise, not doing proper disclosures, not doing full disclosures, and just putting up a witness without letting us know, being able to fairly meet that testimony. That's not what the rules provide. Your Honor,
Personally, I don't believe a defense should have to notice the state of anything in the trial at all.
Ineffective assistance of
my
counsel.
opinion.
I'm not concerned about that because this is strategic. This is tactical. This is effective assistance of counsel. They're trying to represent their client in a way that the rules don't provide, but which gives them an advantage. We are asking, Your Honor, to not allow Mr. Imes to testify at all because the proper disclosures were never made about the substance of his opinion, the support for his opinion, including the disclosure made last night that I, again, saw at 9:30 p.m.
When you saw it, it's irrelevant.
At a minimum, he should not be allowed to testify to anything, as the court said, that is not in his report. We don't expect that every word a witness says on the stand is going to be in the disclosures, but we expect the substance of it to be. I think the court recognized that yesterday in first raising the concern and then recognizing that the substance was there. And so what we're being required to do today is litigate without proper notice provided by the rules in the court's order. So we are asking you to prohibit his testimony, Mr. Imes, at a minimum to limit it to exactly what is the conclusions in his, the only disclosures we got. And with respect to Mr. Gannon, first of all, to not allow an expert opinion. We have objected in the past to allowing lay witnesses who are fact witnesses to come in and testify to opinions.
That's all you had.
I think the court's ruling was that they could testify that what Officer Potter did was consistent with their training. We still object to that, but we more strenuously object to allowing them to offer an expert opinion about whether it was reasonable.
Who was the former chief of the whole
Subject
police
to an
department?
expert opinion, as we have done.
What does he know
for,
about policing?
sneaking a witness in to do it.
Their expert was
Ask the court to
less than
not
5
allow
years on the force 15 years
Officer-
ago.
former Officer Gannon to testify to his opinion about deadly force. So that is our motion, Your Honor, this morning. And unless the court has questions, I'll leave it at that.
Mr. Ring, did you want to respond?
Well, we had a discussion about this yesterday in terms of Chief Gannon, former Chief Gannon. He's a lay witness. He's not an expert witness. He has more training at 25 years than Mr. Stoughton at 5 years. And, we met with him and the state finally gave us their voluminous jury exhibits. We showed him a couple more exhibits than he had. And we asked him, what his view of it was. And you've already ruled that he's qualified. If they have a problem with Mr. Gannon, they could have called him. I mean, he certainly would have interviewed with him. They didn't make any attempt. In terms of the Iams testimony, we believe in brevity rather than a 50-page report. Mr. Iams is not charging us anything. I gave a detailed summary. There was no objection to it. They never complained about it until today. We did meet with him last night to go over the Stoughton testimony on the points he would disagree with. And as we mentioned yesterday, an expert's entitled to listen to the whole trial, and he has listened to the critical evidence, namely Lucky, Johnson, the trainers, and Stoughton. The rest of it's kind of fluff, really. DNA, really? Firearms evaluation, really? And so he has, 98% of what I was going to ask him was about the Taser, but, they've opened the door here. The Stoughton testimony, and particularly the Johnson testimony, is critical. He was unaware of it, and so he's going to answer it. And it's not going to be extensive. But I find, there's no prejudice to them whatsoever. We just got 3 hours of Stoughton. I'm going to get a little bit of time on Iams. And again, if they had a problem with it, they should have told us about it beforehand, or at least called him. I mean, he's quite accessible, as you'll see. So, it's much ado about nothing, and we appreciate your ruling. It should stand. I mean, this is the pattern that the state repeats over and over again. They don't get a ruling. They spend 20 minutes lecturing you on why your ruling's wrong. And then here we are at 9:40 when we're ready to go. So we're ready to go.
All right. Let's deal with the expert first. I am going to allow the defense expert to testify about deadly force. Mainly because there's really no prejudice here. The basis of his opinion
Everyone knew.
are the facts in the case. And generally speaking, the facts in the case are really not in dispute.
I'm kidding.
So, absent prejudice to the state, and I think it's legitimate to have a defense expert respond to claims that were
Why don't we
made
have a jury?
trial. I'm going to let him testify as to deadly force. With respect to former Chief of Police Gannon, I previously ruled that police officers could testify that conduct was in accordance with their training. I also believe that the chief of police in this situation should be able to testify whether or not, under the facts presented, this was improper, inconsistent with Officer Potter's training, and unreasonable force. He's the chief of police. I mean,
Sounds like me.
I'm assuming he got that position because
You can't
I
know.
think we got a thing going on.
training and his knowledge of what is or is not proper to do as a police officer. Okay. Let's
A
get the
ludicrous
jury in.
proposition that the chief of police wouldn't be
Thank you,
able to
Deputy.
testify about what a police officer can do.
What would he know?
Oh,
A police officer in his department.
Can you tell the deputy to hold up one moment? Oh, okay, just one moment.
That he was contemporaneously
wanted to
police
cover
chief
one
at the
thing.
time of the action.
For her entire career, probably,
Ms.
right?
Carter, do
Most
you,
of it,
Do
yeah.
you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay, and you don't need any more time to think about that?
No, Your Honor.
Okay. All right, deputy.
Excuse me, for the record, we have talked at length about that.
Okay,
He wants to testify.
all right. Okay.
First or last?
Yes, yes.
Not first, I don't think. I think she'll go last.
Yeah.
Their expert's going to lead tomorrow, it sounds like. Or their use of force expert. They do have the slip and capture expert as well.
Right.
Faust IXV says, "Good morning, Boomer. Longtime viewer since the Vic case. My wife and I are having our first child, and it's a girl. Cheers, Nick. Any advice for a first-time father? Dude, just enjoy it, buddy. Kids are great. Congratulations. Thank you for building a family. It's an awesome thing. I
Make
guess
sure you get sleep. Get sleep.
My first advice is this, and this is the most important advice I can give to any first-time parent. Don't be afraid to set the child down and walk away for a minute. Like if you're getting frustrated or upset, the child's crying, you're stressed out, put the child down in the crib and walk away. Gonna be fine. Kid will be there when you get back. Promise.
Yeah, the stress is the worst part. Just and usually it's lack of sleep. Just
Yep.
So if you need help to get sleep,
Please be
do that. Get
seated.
sleep.
Members of the jury, I apologize for the delay in getting started this morning.
I mean, I don't have 12 kids like Nick, but
Legal issues. And I want to also explain to you that yesterday, there were some times that we had headsets on. We were discussing legal matters. We're not trying to hide anything from you.
Yes, you
You
are.
are.
I understand that, but it's
That's
very
rather the
Specifically-
point.
that you only consider evidence that is properly before you in rendering your verdict. So I know it can be frustrating, but I want to be careful and I want you to consider the right evidence. Okay. The state may, or the defense may call its first witness. Yes.
the
Come forward, please.
defense expert opens today. Use of force expert.
And would you stand behind the witness chair? And raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
Yes, ma'am.
Please take the witness chair and please remove your mask. State your full name and spell it.
Stephen Bradford Imes, Stephen. Bradford is Bradford, and the last name is James, Ijames.
All right. There's a court reporter taking down everything that's being said, so you have to follow certain rules. You have to answer yes or no instead of shaking your head. No, or If you don't understand,
Ooh,
the
I
question,
automatically
let the
trust him.
lawyer
He
know.
has the downslope
Only
nose.
one person can speak at a time. So wait until the questions
People with
finish
that nose are
before
very
you answer.
trustworthy.
And most importantly, if an objection is made, stop talking immediately. Do not answer the question unless I tell you to.
Yes, ma'am.
Counsel?
Thank you, Your Honor. Mr. Imes, how old a man are you?
I'm 64, sir.
Where are you from?
Springfield, Missouri.
Did you drive up here
Ooh.
yesterday?
Yes, sir.
Tell us about your education, your undergraduate degree and a master's degree.
I have a bachelor's degree in criminal justice and a master's degree in public administration.
And do you remember when you got those?
80s and 90s.
Okay. You've had a career in law enforcement, have you not?
I continue to be commissioned as a Class A peace officer in Missouri today. Yes, sir.
How many years have you been a police officer?
I'm in my 44th right now.
Wow.
Sorry.
Have you attended in the course of your career certain law enforcement
I
academies?
was 5 years on
Yes,
the
sir.
Could
force.
you tell us what those
Four
are?
and a half behind a desk.
Initially, the Missouri State Highway Patrol Academy, and then the Springfield, Missouri Police Academy, which is an
Missouri.
1,000-hour academy. As for basic police training, that's the two initial academies I went to.
Did you attend the FBI Academy?
I'm a graduate of the 186th FBI National Academy. Yes, sir.
I've taught
Tell
there.
us a little bit more about that. Where did that take place?
It's in Quantico, Virginia, and it's considered the premier training for law enforcement managers and commanders in American policing. We also do foreign countries. I think there's been 117 countries that have sent senior.
Indeed, it is. They invite me to speak
primarily in
there.
American.
They must be good.
police, finishing school for commanders.
Have you been to the DEA Academy as well?
Yes, we're a graduate of the DEA Academy also.
And what was involved in that?
That was a 2-week commanders academy simply for running drug schools, drug programs, basically a focused command effort to teach you to do a better job of doing safe and effective policing in a pretty complicated area of the drug world. And
How many
That's what we
papers
oughta
has he
say what the
published for
DEA
various
means in terms
organizations?
of
That's
those
the real
initials.
question.
sure,
What
Drug
is
Enforcement
DEA?
Administration.
I bet this guy doesn't belong to NAMBLA. Like
Let me
Statman.
ask you what your specific experience is in law enforcement. and a number of your other qualifications before we get to this case. Tell us about your law enforcement career. How did it start, and what did you initially do?
As with almost every police officer, I started as a basic patrolman, driving a patrol car, answering calls, just your general call for service. Promoted from there to a narcotics drug investigator, and then from there to just a general crimes investigator, your basic TV detective. I left a smaller department after 3.5 years, primarily to get my 4-year degree. I moved to Springfield, Missouri from Poplar Bluff, Missouri, and went back through the academy. Policing is unique, in some ways good, some ways bad, but it's not a profession by many standards. For example, when I moved from one department to another, I went right back to school. It wasn't like, since I had been a police officer, I just come to work. So in Springfield, regardless of my detective experience, I went right back to the academy for 1,000 hours and then 13 weeks of riding with a training officer.
So let me back up. Did you start out with the Poplar Bluff Police Department?
Yes, sir.
And then after a certain amount of time, you went to Springfield, the Springfield Police Department. Is that correct?
I was in Poplar Bluff for about 3.5 years, and then to Springfield, was there for 25. I retired there as the assistant chief. But the beginning is right back to the street. So I did several years as a patrol officer after the academy. I rotated in to work the jail for 9 months. We had a 14,000 prisoner a year jail booking process that if we were short on civilians, they would grab the low senior people. So I did 9 months in the jail. I dispatched for a while.
Isn't it
front
true
desk.
you
You just do
said
whatever
you
they
did
tell
9
you to
months
do in
in
the
jail?
early days, especially.
Did you advance through the department?
Yes, sir.
Tell us what your advancements were.
After several years in those assignments I just mentioned, I was transferred to an undercover narcotics role, where basically bought hand-to-hand drug buys off about 300 suspects. Ultimately promoted to a detective corporal, which is a plainclothes investigator, kind of what you see on TV, doing every type of post-event investigation, robbery, homicide, theft, that sort of thing. Ultimately promoted to sergeant in the detective division. And then in 1989, a catalyst event, a pretty catastrophic hostage-taking scenario, resulted in us creating a full-time SWAT team versus a part-time team that would not be as practiced and experienced.
What's a SWAT team for our own?
Special weapons and tactics is what the terminology references, but it's basically a group of officers. It varies by department, but for most, it's an elevated skill proficiency group that focuses on really critical.
Stoughton picked up the locker
out,
towels for the
drug
SWAT
search
team.
warrants, barricaded suspects, hostage takings. And we had an event that finished well, but it wasn't because we did well. We had a hostage taking that finished successfully, but because the suspect allowed the victim to be released. And the chief recognized after that that we simply didn't have the capability as a part-time team to solve it. And so he created a full-time team. I was asked to lead that team. And when I say full-time, just to be clear, most SWAT teams in America, about 98%, have collateral duties. They work in patrol, they work as a detective. In our environment, it was the only job we had, 10-hour training day a week, and nothing but search warrants, barricades, and rare hostage taking. So I had that team for many years.
Door kicker.
How many, remember?
As the direct supervisor, first line person, 89 to about 94. I kept it in my division as command almost to the last day I was there, but functionally, once you make captain, you're not an operator anymore. You need to allow line people to work. So once you're at that level, I stopped doing the day-to-day work with them.
And what other responsibilities did you have after that with the department?
But the other guys
when I promoted
wrote a
to
52-page
lieutenant
report.
from that division, I kept supervision of SWAT, but I also had narcotics. So you had all drug investigations, all special operations, K9, bicycle unit. Just
Judge Chu's going to slip this guy her phone number.
Ultimately promoting to a captain and took over the uniform.
She's making the little call me sign.
Which would be everything you
She'd
see
be
in
robbing the
uniform,
cradle, though.
from a DARE program, drug abuse resistant education, to uniform patrol, to a school crossing guard, just everything you think uniform policing. About 3 years later, I think I was promoted to major and took over all investigations, which would take you out of uniform, but then anything, plainclothes, narcotics,
The chat is seeing
robbery,
why
homicide, anything
the
that would be
prosecution is
more
scared
Yeah.
of this
effective
witness.
of a,
I'm just looking at the
plainclothes
comments
detective.
now.
And I had that role until I retired as the assistant chief.
Along the way, while you were at the Springfield Police Department, did you work with the United States Marshal's Office?
I was a commissioned marshal on a number of task forces at various times in my career. There's reasons why agencies do that to give you a
I love that
different
he's doing this
level
for
of,
free too.
authority. And there's also some
Drove
funding
up-
reasons
Are
why
we paying you? Are we paying you $95,000 to be here? No, sir.
things like that, but on a number of occasions.
And 95
drove
cents.
Did you also
up.
work
I
on
didn't
a
even
DEA
fly up. I
task force
drove
while you were
from
at Springfield?
Missouri
On a number of
into
my
an
truck.
ice storm to be here today.
You indicated that you were a licensed police officer for 43 years. Have you considered now retiring from active duty, so to speak?
As recent as 2 months ago, I was driving a marked patrol car for the State Park Police. The park I've done that for the last 3 years. Had some medical hiccups that have caused me to resign that commission, but I'm not sure what will happen after the first of the year. But I'm leaning more towards family stuff. But
Well, you
we'll
know,
see.
you've come up here in a car. Did you recently have heart surgery in Chicago?
Open heart surgery last week.
Which is one of the factors you're considering in retiring.
My wife's certainly considering that. Yes, sir.
Do you know what a critical incident is?
Definition varies from agencies. There's no national standard definition, but for most agencies, it's an incident that involves an enhanced potential for death or serious physical injury over your ordinary day-to-day call.
In your 43-year career, how many critical instances have you been involved with?
I couldn't begin to answer that. I mean, it'd be many, many, many.
Can you give us an estimate?
Hundreds.
More than Stoughton. 0.
And were some of those critical incidents involving guns and shots fired?
I would say the vast majority, not that you can't be in immediate deadly jeopardy with something besides a gun, but normally because the gun issue involves distance and capability, you can usually stay away from a knife person to some degree, but most of them involve guns because they're harder to control.
Do you have any teaching experience?
Beginning in the late 80s, I became a generalist and specialist instructor for the Missouri Department of Public Safety and began just teaching in Missouri, primarily drug-related investigations. And then as our
How to rip
SWAT
out throats.
evolved, began doing SWAT training.
Have you ever taught report writing?
Because
No.
we were the best, but we were busy and we had good outcomes. We were able to get the job done without anyone getting hurt. And in policing, you quite often look to others who are doing something that seems to be where you want to be, and you learn from that. So we began doing a lot. I began doing a lot of tactical training. There's an international organization called the NTOA. It's the National Tactical Officers Association, but it has 40 countries represented. Began teaching for them. In the late 80s, early 90s, we began videotaping virtually everything we did, which in American policing, that was just stunning, that you would videotape what you were doing. And many, many people question the logic in that. For us, it was primarily a critiquing, learn from training perspective, but because we had video, I mean, of operations, of things going well, things going bad, it greatly enhanced the teaching capability.
Someone just
So I
brought
could
up
show
this guy's
videos
been a
of
cop
actual
longer than the
operations.
other witness was alive.
One thing led to another, and I was asked by the director of the NTOA to be one of their 4 national board members. So once I became on the board, a key part of that was teaching for the National SWAT Association.
Well, let me interrupt you then. Let me list a couple organizations you've taught for, if I may. Have
Yes,
you presented for the United States Department of State?
In 33 countries, yes, sir.
Have you presented for the International Association of Chiefs of Police?
Many, many times.
You've made presentations in many states in the United States, have you not?
Yes, sir. I think pretty much everywhere.
You have made presentations on the international arena in Somalia,
Yes, sir.
Haiti.
Many, many times in Haiti.
You've made presentations to SWAT officers in London, Amsterdam, Brussels, Dusseldorf, Nuremberg, Belfast, among other places.
33 countries, yes, sir.
Remember, the other expert
You've
didn't
made
train
presentations
anybody
for the United
ever.
States Department of Justice in Bosnia.
Yes, sir.
You've also worked as an evaluator for various countries and how they operate their police forces and their SWAT teams. Did you not?
Yeah, not unique to foreign countries. I've actually done more evaluations here in the United States. That's actually a key part of what I've done, especially in the last 10 or 15 years, is do evaluations for agencies that would just like an outside external perspective. In some cases after a tragedy, a critical incident, but in some, they'll invite you in and say, hey, I've just taken over this department and it looks good to me, but I would just like an outside look, someone who doesn't have a
Doesn't
dog
need
in
to
the
be
fight.
said. This guy's
I do a
2-page
lot of
report
that
will have
here in the United
1,000
States.
times the
They have no
value of
problems.
Stoughton's 50-page
Well,
report.
let me ask you,
Yeah.
whether overseas you've worked with various countries, including Jamaica,
This guy's
Yes, sir.
qualifications
Canada?
embarrass the
Yes, sir.
academic.
countries in Southeast Asia,
Yes, sir.
Tanzania,
Yes, sir.
Greece,
It's going to list every country in the
Yeah.
world.
Yes, sir.
Kenya,
Can we just list the countries you
Indonesia?
haven't taught in?
and that's just a start. I can,
Been to a lot of them. Yes, sir.
okay. And you've also trained
I always go home to Missouri.
officers in terrorism and counterterrorism, have you not?
A key focus of the international training, not surprising when you consider the last 20 years or so, post 9/11 for sure. A critical focus of our U.S. government effort overseas that involves local police. A lot of individuals don't understand that much of the American policing effort overseas that the U.S. government funds is done by police officers, not the military. Nothing wrong with the military, simply that our government, I believe, thinks that it's best for police to train the police. And so post 9/11, especially, a key focus of what I've done is under what's called a anti-terror assistance training program, which is through Department of Justice or state, geared towards teaching concepts that just
Good
make
friend
our
of mine works for the
safer
FBI,
and
and
make
he
our
was
citizens
actually
safer.
embedded with the military in the Middle East to do their investigations when they would
enhanced
kick
risk
doors
management.
down and search for people. Because, of course, the military breaks
You
things
made
and blows things up. It doesn't do
representation with the United
investigations
States
per
Army,
se.
United States
Right.
Air Force, the New York City Police Department, and police departments in California, Wisconsin, Oregon, Utah, Colorado, Illinois, among other places.
Been here a lot of times.
All I keep thinking is this guy did all this
You,
in only 44
Are an
years.
instructor for tasers, are you not?
Not for Taser. I've never worked for the company.
Well, how does that work when you say you didn't ever work for the company? Tell us how one becomes an instructor on tasers.
Well, first I invented it.
Taser was invented in 1965. A man named Jack Cover, and it went through a number of different patents and owners, but ultimately the Smith brothers, Rick and Tom Smith, took over the Taser patents.
Ricky and Tommy.
90s, slightly varied to get around some technical issues, but in the mid 90s, Smith brothers created the current process that became the Taser today. And in 1999, they did their first instructor trainer program where they would create training to teach teachers. And that first program was done in my police department by Rick Smith, the
First,
in that class. And
By Ricky himself.
I always felt like that I had been training for a
Chat,
number of
someone
years
said,
up
first,
to that point.
I invented
that if
electricity.
you ended up appearing to be in bed with a company, if you worked for a company, that your ability to speak truthfully without people wondering what your motivation was would be an issue. So I just made a decision in the mid 90s to, though I was very involved in technical training, whether it was pepper spray, whether it was a plastic bullet, tear gas, I would never work for a company because I just felt like you kind of have to carry the party line. And so Mr. Smith allowed me to go through that class with the understanding that I would not be a Taser instructor. In the early 2000s, there was a lot of controversy with police departments being accused of being too tightly aligned with manufacturers, getting free things, basically using tools on citizens in scenarios that might be questionable. And so you began to have training crop up where individual agencies wanted teaching from outside of a company. They basically didn't want the party line. And so the International Association of Chiefs of Police, who I've been involved with for years, largest and oldest police organization in the world since 1897, had me develop a Taser program we actually couldn't use the term. It was Conducted Energy Weapon, CEW training program, to where we could teach agencies Taser process, but not be under the Taser banner.
And you have taught Taser courses.
Many.
Okay, you're familiar with the protocols for the current Taser, Taser 7.
Both the teaching and then what we would call your best practices policies that are out there. There's different groups that give models, examples of how they think the device should be used, not all in lockstep, but I'm very familiar with those as well.
Well, we're almost done with your qualifications, but I want to ask you just a couple more questions. Have you had any academic affiliations where you're taught policing and criminal justice?
I was the dean of Harvard for 10 years.
Yes, sir. I've taught seated classes at different universities. I mean, 3-day-a-week classes, and then I've done just adjunct faculty, things like that. I don't do anything like that now, and I don't anticipate it again.
How many officers over the course of your 43 years do you estimate that you've trained in the reasonable use of force, including tasers and guns? Give a sense of how many people you've trained.
It'd be thousands. I don't want to just guess. It would be thousands.
Have you received any awards during the course of your career?
Some, yes, sir.
Well, are you a member of the American Police Hall of Fame?
For the Medal of Honor.
Yes, sir.
And what is that?
That's just a national police organization that recognizes certain acts in police service.
Are you the recipient
the
of
bus
the
of children.
Silver Star for Bravery?
Yes, sir.
What is that?
It's an award given for actions that meet their standards to acknowledge, I guess, above and beyond the normal duty.
And what did you get the award for?
Rescuing a hostage in a liquor store holdup that had been shot, and engaging the suspect in that case and shooting and killing him.
Have you had any
Superman is to
publications
rescue a
during the
hostage.
course of your career?
Around 100 articles, chapters for books, peer-reviewed articles, some not, but I would estimate around 100.
Mr. Imes, I could spend quite a bit more time with your qualifications, but is the history of your career set forth in your CV, which is Exhibit 1001?
Yes, sir.
We offer 1001 for the defense.
That's 50 pages long.
We do, Your Honor. It's your site.
Resume, correct? The objection is overruled and the exhibit will be admitted.
His resume that he just testified to his CV. What's hearsay?
Did I contact you or the defense contact you for the purposes of your initial review of this case?
I don't remember.
Well, you were contacted. It doesn't matter who, but you
Yes,
were
sir.
contacted
I don't
to see if
recall.
you would review this case, were you not?
Yes, sir.
Okay, all right. How many cases have you reviewed for reasonable use of force, excessive force, that sort of thing in the course of your career?
A fair number would be between 2,000 and 3,000.
But it's
How
down to
many
have 30.
cases do you
Yeah,
have
30.
right now under your review?
Well, that's not all of them.
4.
Or at least
Of the
35.
4 cases that you have, how many of those are you testifying for or on behalf of the police officer or against the police officer?
This is the only one that would be considered, if that's the perspective, for an officer. The other 3, my opinions, would be against the officer.
Oh, gosh.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-90s, when this process began, I began asked to review cases that I would never take a fee in a criminal case, regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation. But I've stood by that, and
So you're not getting paid
if I continue to do
$95,000.
this, I'll continue to take that perspective.
Well, we asked you to review this case. Do you remember initially what you did review?
Yes, sir. It was a voluminous file. As I recall, our initial discussion focused around the a deployment of a taser. That was the primary focus. This case, and in no way am I diminishing, it's not a complicated case, the facts itself, but the focus initially was the issue of a decision to deploy and manner of deployment of the taser.
So you looked at the videos,
statements, various reports. I didn't review everything in it. I reviewed those things I felt were necessary to give me the information to render reasonable opinions concerning the decision to deploy and the manner of deployment of the taser. Yes, sir.
Which really centered on the officers on the scene, Mr. Wright's conduct, and the
And then
training.
some foundational stuff, issues concerning what an officer would have been taught, what would have caused them to think certain things, but almost exclusively it's the officers on the scene. Yes, sir.
Now, since the trial began, have you reviewed actual testimony that the jury has heard?
In the last week, within some limits of my ability in the last week, I was able to follow some things that were online that involved testimony. Yes, sir.
Did you, for example, follow the testimony of Officer Lucky,
Yes, sir.
Sergeant Johnson,
Yes, sir.
Sergeant Peterson in training?
The training.
While he was having open heart
and
surgery.
Also, Mr. Stoughton yesterday.
Yes, sir.
Okay. Well, let's start your review by your understanding of what happened here. Would you discuss
He watched
the
Unrecated
nature
Law.
of the stop and what you saw, and then I'll get you some more specific questions on the use of the taser. What did you initially see in your review?
Yes, sir. You've got an officer in field training, and
This guy
a
actually
recruit, for lack
invented
of a better
Recated Law.
term. And there's an initial assessment of the vehicle in front that has something hanging from the mirror. Your state, as with other states, has a statute that says you can't have anything between the driver and the windshield. And so I think that was the initial reference. Field training is a process of work. You want recruits to do things and test them and figure out that they understand the basic practices and protocols. So the license was checked. There determined to be some difficulty with, I believe, the registration tabs. So you had basically your statutory issue about something hanging between your eyes and the windshield, and then a license violation, and the stop was initiated from there.
Was the matter of a warrant for a gun of significance to you in any way? The fact that the officer on the scene found out that there was a warrant outstanding for the driver of the car.
Oh, yes, sir.
What was that? Was that significant for you in any way?
Yes, sir.
And how so?
Police officers aren't clairvoyant. The best way to indicate what might happen tomorrow is what happened yesterday. So we teach officers to act on reasonable appearance. And so if I find a person on a stop that has a weapons charge or a gun warrant, it doesn't mean they have a gun. It means they very likely could have a gun because they've had one in the past. So an officer would immediately take a different perspective, not that they would act necessarily differently, but they would begin to address this call for service differently because we have reasonable, objective information that a gun could be in play.
How about the existence of a harassment order? Did that have any import in your evaluation of the case?
Same basic thought process. We teach officers to look at the totality of circumstance, everything involved in this case. So if we have in this case, a female in the car, and we have a harassment reference as well, is that the person? What's the nature of the harassment? It just continues to elevate an officer's vigilance. And I want to be clear, it's not that we then use weapons or use force, but we absolutely look reasonably on appearance of the facts we learn as we move forward about potential danger, potential resistance, and then act accordingly.
Well, does the harassment order increase or decrease an officer's possible perception of dangerousness?
It would increase. I mean, it's certainly different than a felony assault, but it's also different than a shoplifting charge. So a harassment would indicate a personal interaction in a negative way, and it would just cause an officer to be more vigilant concerning that type of interaction.
How about the existence of the female passenger in the car? What significance was that to you?
The third party present, officers basically look at calls for service from a safety priority perspective. So that third citizen in there, not the focus of the event, increases your concern for her safety. but also what role, if any, she plays in that harassment charge. Is that the person named in that particular event? Have they made up? People do. It would be very relevant to continuing that investigation.
With a bench warrant outstanding for the driver, was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later. And your response to that?
Nope.
The objection is overruled.
Yeah, thank you.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested. And there's consequences if you don't. Some states, including mine, criminalize it. If you don't serve an arrest warrant, it's a crime. Not every state, but that emphasizes the seriousness of it. It's not a request. It's not a suggestion. An arrest warrant is an order to arrest, and that's what police officers do.
So in your view, Lucky, former Officer Potter, and Johnson had to arrest him?
Dereliction of duty not to.
As a supervisor, in Missouri, one of the leaders of the department, would you have disciplined an officer for not executing it or not arresting on a warrant from the court?
Beyond question.
That officer would have gone on to become Stoughton.
Well, I thought I should let him go. What was I
Lucky's
supposed to do?
behavior and his actions, you remember that he goes up to the car and asks Mr. Wright to step out. Is that correct?
Yes, sir.
Was that a correct police procedure in your view?
Yes, sir, it is.
Was it a correct police procedure in your view to tell him that he was once out of the car under arrest?
Beyond question.
And why is that important to tell someone like Mr. Wright that he's under arrest?
It may seem obvious that we would tell people they're under arrest, but in my experience, it quite often doesn't happen. An officer knows there's a warrant for you, and they stand the person up and say, turn around and put your hands behind your back. But it is a critical aspect of that officer-citizen encounter at the time of the arrest to look right at them and say, you are under arrest. And so in this case, we had two officers that actually said it. I just want to make it clear that the assumption that that always happens, it really doesn't. And so it's critical because it basically removes all confusion. When we say you're under arrest, that's exactly what that means, and you're required to comply with that order.
But what does Mr. Wright do instead of complying?
He initially just stood there and fidgeted a bit, and then there was the attempt to cuff him, and then he ultimately tried to get back in the vehicle.
In your 43 years, when someone wants to not be arrested and are about to be cuffed, what usually happens?
First handcuff's where it happens. When you take a hold of that first hand and are applying the first handcuff, in my experience, and that's taught universally, but it's like at that moment when they make the decision is when the hand goes on their hand. And that appeared to be what I saw in the video. It's the norm, but he began resisting at that point.
And what impact did that decision that Mr. Wright made have on the police officers at the scene?
The objection is overruled. You may answer.
It changes everything.
How so?
In policing, our primary focus is to react to what others do. There are certain areas we're proactive, but as in this scenario, we are reacting to what the arrested individual does.
Not the cops who choose the level of force.
Authority. If he
The suspect that
complies,
chooses the level of
as
force.
almost every prisoner does, the handcuffs go on and the process works itself out. If they resist, then we will have to use that level of control to overcome the resistance and continue to work towards that lawful objective, which is effecting the arrest warrant.
Could the officers, in your view, just kind of let him go when he started to escape from the cuffing?
Objection has to answer.
The
No, what do you
objection
think?
is overruled. You may answer.
No, sir. Police officers are under authority. We're not military, but in many ways, police officers are structurally in a system where they do what they're told, and they are told to serve arrest warrants. And now, is there room for variation? Do some agencies do other things? Sure. But the legal obligation to serve an arrest warrant is unquestionable. And at the time he resists, their default is to overcome the resistance in a reasonable, safe way and get back to working on accomplishing that mission objective, which is to serve the arrest warrant.
Did you see from your review of the videotapes and the testimony that you've heard and watched that there were efforts after Mr. Wright initially refused to be cuffed to secure him?
Yes, there was an initial scuffle there at the driver's side. Yes, sir.
Was that a legitimate law enforcement technique?
Certainly. Grappling, soft empty hand control is the formal term, is the force used in about 90% of all resistance. I try to put a cuff on you, you begin to scuffle. I don't punch you, you don't punch me. We're just in a little bit of a grapple. And if I and my friends are able to overcome your resistance, the handcuffs go on, and that's that. Almost every time, that's what we do.
We've talked in the trial about control over a motor vehicle. Are you familiar with that phrase?
I am.
Control. Was at this point in time, or was this at this point in time, was Mr. Wright in control of his vehicle as he struggled to get back in it?
He was not.
Was he ever in control of the vehicle before the taser was shouted and a gunshot took off?
Not that I could tell from the video, no, sir.
What do you mean by control in police work?
Control literally means the ability to put it in drive and go. That's it. There's actually a Minnesota statute that references control in relation to DWI, and it talks about mechanisms of movement. That's not unique to Minnesota. Literally, control is just that. I'm in control and I can go do what I want, which in this case was likely to go forward.
We've seen a lot of body cameras in this case, and then we've seen still shots of what happens. When an officer is in a situation like they were here, do they see in still shot framing what has happened?
No, sir.
Well, why is showing a still shot of what occurs different from what an officer sees?
The format for body cameras is called QuickTime Player. It's 29.5 frames per second. And you and I can just envision how well we could take a 1 second sliced 29.5 times and accurately or effectively see and assess that slice. So the slice is helpful in some cases, for example, to show whose hands are on a gear shift mechanism, but to suggest that anyone, officer or citizen, sees and perceives something you see in a 1/29.5 second frame is just completely unrealistic.
This guy's answers are simple.
Compare what the body camera sees with what an officer sees when there is a struggle.
Sure. Officers, like all human beings, have varying processes physiologically, metabolically that apply to survival, stress, fear. And so, for example, you'd asked earlier, sir, about critical incidents. I've reviewed hundreds in which officers and citizens are talked with after a life and death scenario. And very common themes occur where vision is focused, very tunneled. Not always the same, but that's a very common theme where loud sounds are silent or not heard, where a quiet sound is actually magnified. So the video records exactly what's happening without any of the processes human beings go through. In my experience in critical incidents, almost no one, officer or citizen, can ever accurately speak to what happened in all areas because their body just can't record like a video exactly what's going on.
I'm going to object to that question and answer is beyond the scope of this expert's foundation.
Okay, no speaking objections. You may put your headset on.
State is not happy with this witness.
No.
He is brutally devastating their witness's expert testimony right now. I mean, his resume alone did it, but his answers are brief. They're to the point. They're crystal clear. They're stated understandably. I mean, What does it mean to be in physical control? It means to actually be able to do something with the car. Was he ever in physical control? No. How do you know? He didn't do something with I mean, he didn't say it that way, but that's what everybody's thinking. He was trying to go forward the whole time. When he was able to go forward, he did. Until then, he wasn't able to go forward, so he wasn't in control. It was magical to have that testimony, because the other guy talked about it for like 10 minutes on how he was in this car, and and he might go, and therefore a taser's not allowed, and all this stuff. We haven't even gotten to whether the taser being deployed was appropriate yet. But I think the jury's already thinking it was. But that's me. I don't know. I'm probably biased on this, but this guy seems far more effective than the other guy. G-Man says, happy birthday, Nick. Congrats on surviving another year and ever more difficult task. This is also your Christmas super chat, just so we're clear. Thanks. Thank you.
I just have to cancel a media appearance. I don't want to step away from this.
Oh, you had a media appearance in the middle of the day?
Yeah, sometimes the testimony is boring, and I can step away for 15 or 20 minutes, but this is not boring.
No, this guy's fantastic. And it's amazing just the difference between, I worked as a police officer. After about a year, they moved me to a desk. I sat there for maybe 4 more years, and then I went and wrote a bunch of papers to this guy who, I spent my time training the entire earth, building SWAT teams, inventing tasers. Well, when I was wiring in the investigative laptops into police squad cruisers when they were first invented by my son, who I trained, it's like,
when we first moved from horse patrol to automobile patrol in Missouri.
The objection remains overruled.
And Stoughton is just frozen mid-makeup watching this.
As he
his eyeliner
got back in the
dropped
car,
down
Mr.
his
Wright got
cheek.
back in the car and struggled. In your view, did he have control of that motor vehicle at that point in time?
He didn't, because he didn't leave.
The gears were not engaged.
Correct.
We've heard testimony yesterday about the differences of shooting into a car that's moving and shooting into a car that's stationary or in control.
Yes,
Is
sir.
that a distinction you make in your work?
It just depends on the circumstances. The key issue is balancing the need to use that extreme level of force with the potential consequences. You may need to do it if the vehicle's moving, if someone's about to die. And then you acknowledge there's potential consequences as it rolls. So it's not a black or white yes or no. It depends on the totality of the circumstances in each case.
You were asked to evaluate the decision to use a taser in this case and whether it was reasonable and appropriate. Is that correct?
Correct.
What is the standard that you're using to make that determination?
Quite often there's terms thrown around in American policing about standards, and to be candid, there are few actual standards as compared to other professions. By standard, I mean if you don't do it, there's action. There's something that follows. We have the Supreme Court, we have federal circuits, we have state statutes that provide standards that if you don't follow, there's consequences. But most of other policing is the result of organizational culture, training. There's 18,800 agencies in America that do many things to a degree of autonomy that is stunning to many people. So from a standards perspective, what I prefer to teach is what I call contemporary police practices. And by that, I mean, it's what most people do. It's not that they have to do it. There's not a Supreme Court ruling or a statute. There's not a standard that they're in trouble if they don't. It's what most professional, smart police agencies do. And so to talk contemporary police practice, you have to look for where that body of knowledge would likely be. For me and for most agencies, organizations like the International Association of Chiefs of Police, Every chief in America is a member. Been around since 1897. In 1987, they partnered with the Department of Justice to create the National Policy Center. And the National Policy Center was created to put together, their words at that time, models of policy on contemporary issues that agencies could use some help on. And so I served on the National Policy Center board for over 20 years and authored many of their policies. So if you were a chief in the mid 90s, when Taser first became common, what do we do with this thing? How do we use it? Well, the manufacturer says this, and many smart chiefs would say, I appreciate that, but I'd like to talk to some people who worry about what I worry about, not selling devices. And so the IACP has a model policy on the use of the Taser.
And what would that be?
Well, I wrote that policy. I created it for them. And it specifically speaks to basis or justification to use. And the general justification or basis is grounds to arrest or detain and a reasonable belief that physical force or resistance to that arrest will follow. That's not a mandate to use, but that's a general authorization.
He literally wrote.
Is that
the
standard
policy.
dependent on a proportionality of risk, or is there any concept like a proportionality? Sorry about that. In the standard that you've mentioned.
No, sir. The issue of proportionality in policing and force is a very lofty, worthwhile goal, but it's not a standard like objectively reasonable from the Supreme Court. To that degree, we want proportionality. We want to do things that are balanced and that make sense. But specifically, officers are instructed that their force has to be reasonable, which in some cases would not be the least amount of force possible. It may in fact be more than something else that you could have done, but that doesn't make it unreasonable.
So as a standard that we use for the reasonable use of force, objective reasonableness?
That's the standard I've always been instructed on, yes, sir.
So you've reviewed the Taser manuals in this case, the PowerPoints.
Yes, sir. Very familiar with
You're
that.
familiar with everything that was taught here.
Yes, sir.
So let me ask you the questions that you're here for. Okay?
Yes, sir.
Was the warning given by former Officer Potter, I'll tase you, reasonable?
Yes, sir. That's the standard warning. You just communicate in plain English.
It's a standard. That is what they're taught to do.
Yes, sir. I'll taser you. You just tell the person, and in many cases, someone submits. They'll raise their hands and say, I quit, and that's the goal.
Was the warning taser reasonable under the circumstances in this case?
That is specifically taught in the lesson plan. Number of reasons for that. It's really not for the suspect. It's more for the officers and others around the event to understand that a taser is just about to be deployed.
We heard testimony yesterday that the taser in this case was, or the assumed use of the taser was too close to Mr. Wright to be effective in its impact. Do you agree or disagree with that?
That's completely untrue.
Well, tell us why Mr. Stoughton's opinion is completely untrue.
Two key reasons. The first is the Taser
Love
7
the way he worded that
specifically is designed to have a very wide arc with the close range deployed probe. The standard arc deploys about a foot every 7 feet. And one of their corrective measures with the 7 was to figure out that many police confrontations with suspects were at close range. And that degree of spread was insufficient to get neuromuscular incapacitation. So number one, the 7 spreads wide at close range by design with the close cartridge. Independent of that, the physical positioning of a seated suspect changes everything.
How so?
Literally, as you or I sit here, if you envision a shot just below the chest or sternum area, which is a key aiming point for the upper probe, from that probe to the probe into a thigh is about 12 inches, which is marginal for neuromuscular incapacitation, as they say, as the crow flies. But on the body, it's about 36 inches. Because as you stand, the electricity takes the path of least resistance. It doesn't go through the air. it follows the body. And to connect one probe to the other, it goes down the side, down the leg. And so a seated suspect changes everything as it relates to probe spread because their body's bent and you end up hitting low and hitting high, not because you're at a distance correct for that, but because of the angle of their body.
What would have happened had the taser, an actual taser, hit Mr. Wright vis-a-vis his ability to drive that car?
The actual taser device, when it performs as designed and intended, is the most effective incapacitation tool I've ever experienced, independent of a central nervous system disruption. And I apologize for being graphic, a gunshot to the head, something that basically turns off the lights. The taser is the second best thing out there when it performs as designed and intended. In actual operation, it's a relatively fragile system. Things can happen. Clothing can be lofty. A probe maybe won't stick. The very best studies out there, the most recent, January 2021 with LAPD, is all excuses aside, the taser actually accomplishes overcoming resistance about 67% of the time. So to answer your question, if it had performed as designed and intended, he would have had a neuromuscular incapacitation, which is a very significant physical lockup. In my experience, some people can do a little better than others, but most, it's not a matter of toughness. It's a matter of electronics, physiology. They're pretty much locked up. To get to a shifter or drive would be very, very unlikely in my experience.
And to drive thereafter would be unlikely too.
Well, I'll let you answer. The objection is overruled.
As long as continuity exists, as long as the trigger is pressed or the cycle is energized, and both probes have continuity, it will in theory do what it's supposed to do. But the second that breaks, whether they're driving away and the cord breaks, it pulls free, many suspects literally leap back into the game because it's electricity. And when it stops, now some people, oh gosh, that really hurt, and they kind of pause and seem stunned. But the idea that this is like pepper spray that carries after, it is either you're getting the electricity or you're not. And so the answer, sir, is if the cord broke, if it pulled free, in my experience, most human beings no longer have NMI because the electricity is simply not there, and their ability to recover and continue controlling their body would exponentially be pretty high.
Yesterday, we also heard an opinion that given the location, the close location of the officers at the scene, that shooting a taser would be inappropriate in light of where they were. Agree or disagree?
I disagree with that.
And why is that?
Police officers have to deal with the circumstances presented to them. And in actuality, we fight in close proximity with citizens, suspects all the time. And so you have to work around those as safely and practically as you can. And there is a risk. You can make a mistake. One of the very last arrests I made before I retired, I had a fellow officer spray me with pepper spray in a fight directly in the face on the ground. It can happen.
This happened to me before. Somebody hit me with pepper spray.
You need to use that tool, the potential benefit of the taser, with the risk of what would happen if you'd hit the wrong person. So we shoot close all the time. You can make a mistake, but it does not prevent you from doing what you need to do in most scenarios.
This guy would just rub his burrito on his pepper spray and eat it.
At least in your review of the
This is the best expert witness you could ever get, though. This guy's amazing.
Mr. Wright were not detained by the taser.
Just what comes with a fleeing suspect.
Tell us more about that.
No one has a crystal ball again to predict what a person would do, but the very nature of flight and resistance brings with it danger to people in the path of the runway. Theoretically, danger to a person in the vehicle if they are subject to that harassment warrant, which you don't know. Many unknowns. But again, the reason we serve arrest warrants is to put that process in front of a judge and stop it right there, because few good things follow when a person flees arrest and gets away.
And one of the dangers here, according to the testimony, you
This
heard,
guy's a
was
chimp.
possibility of one of the officers being dragged.
I did learn of that last week. Yes, sir.
And do you have experience with officers being dragged?
We recently retired this year an officer from my department who was permanently disabled, having been drugged in a very similar scenario, and was medically disabled. He's done.
relevance of this.
I'll move on.
Yes, please.
Well, I object to that.
Well, I am going to advise the jury you should disregard that last statement.
Luck with that.
Why? Why would you disregard that statement? It's relevant. The question
In
is,
light of
are the
your
officers
review
in
and the review
danger?
of all the testimony that
I guess
you've
it's a
seen,
specific
was
instance, maybe.
Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped. Just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it, very, very likely in most cases.
The state must be
Is
like,
to
my
change your
fucking
opinion
God.
as to whether her perceived use was consistent with the standards you've described after
These are the
watching
standards you
video
wrote.
and Johnson at all.
No, sir.
What you didn't see in your initial review of the case was Johnson's testimony. Is that correct?
That's correct. So I saw that last week, I believe.
And he was the fellow who was reaching in to stop the car from getting into gear. Is that
On the
right?
passenger side, yes, sir.
Was he at risk of great bodily harm or death if he had not gotten out of that car as quickly as he did?
Had the vehicle been put into drive, beyond question.
If, let me assume a hypothetical, if we have the facts as we have them here and the officer sees Johnson in the car,
Yes, sir.
sees him struggling in the car and has a view of him. And further, that the individual is about to drive away, or at least attempt to drive away with an officer who's in and out of the car. Would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
I'll check your honor as calling for speculation and improper statement.
The objection is overruled.
Yeah, he's an expert. He's supposed to speculate.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force. And that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard,
I'm a lawyer, I know.
officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
So an officer seeing that could shoot.
It would meet that standard and an officer could shoot. Yes, sir.
May I have a moment?
Yes.
What more do you need?
Ugh, he could have shot her. She could have shot her. Wow.
Got her.
But he's right, though.
Proper.
If they go to cross, I'm going to have to duck off in a few minutes.
Sure.
Sorry about that.
All right.
No worries.
This cross is going to be good, though, because I want to see what the state does. This guy wrote the book on. What better witness could you get? The guy who wrote the goddamn policy.
Members of the jury, we're going to take our morning break.
Oh, come on.
So,
Oh.
How long you got to be off for?
15 minutes. It would have been
Oh.
perfect if they did it right now. Oh.
Oh man.
But you're probably going to get 20 minutes. It's a 20-minute break right now. But that's so true though, because I'm certified in Aspeton, not the pepper spray, and handcuffing. And they're right. It's the companies that train you, because it's a train the trainer program. So they train us, and then other police organizations would call me and say, "Hey, can you come train my guys in with Aspeton and whatever?" And they give you free stuff. So everything he's saying is textbook, exactly what happens.
Did you see this guy's resume? Were you around for that?
Yes.
I
was
mean,
listening. This guy, he got it. He's got his 40 years. Like everything he's talking about. Because I used to go to these conferences when I turned into a house mouse after my first 5 years. I was smart enough where they turned me into a house mouse. So I was doing statistics and investigations. But after that, you sit around and you go to all these trainings. And he's right. There are certain people there who, like him, he goes around to all these police departments, they work, and it's more of a practical thing. The guy yesterday, he's just an academic. He's some guy who's teaching at a law school who comes and says, I can do it. But he's not someone on the ground. And that's what it was exposed today. From a practitioner who was, up to last year, he was driving a police car, to someone who sits behind a desk and theorizes about this. So that's what you're seeing today in the battle of the experts.
Yeah, I mean, there's not much of a battle, in my opinion. First of all, his resume blows the other guys out of the water. It's embarrassing, but even his delivery and demeanor on the stand, he's not evasive with his answers. His answers are not complicated,
and they're direct.
Yeah, it's
they actually
just
answer the question.
Here is the standard that you would apply. I know because I wrote it. And the standard is this, and it exists in this case. And I still love his use of his physical control of the vehicle. Well, if you're in physical control of the vehicle, it means you have the ability to move the vehicle. We know he wasn't in physical control because he didn't move the vehicle, and he would have, because that's what he was trying to do. I mean, it's bam, 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 bam. Walk me down the sidewalk, right? One cement slab at a time. When I was a kid, I would always think progressing, past the next little mark in the sidewalk. And it was like a whole new thing. And that's what he's doing. Here's this part of the answer, this part of the answer, this part of the answer. And now you're at the grocery store. What do you need? And it's great. It's great to see that. And I love the fact that he's free. And he's free just doing this because, look, it's my obligation to do this. And also that in the other of the 4 cases he has going right now, this is the only one where he's offering testimony on behalf of the police officer. The others, he's offering testimony against them. Whereas the other guy, basically everything you've ever done is opposed to the police officer, isn't it? Well, maybe 1 or 2. It's like out of 30, 27 of them are for the police officer.
And it's a nice touch that he does all of these free. So not just this, like he's got some personal motivation or stake in this particular outcome, right? It's just his blanket policy.
Yep.
Yes. And that I think throws the most shade at the guy yesterday, because he's got less experience and he's getting $95,000, even though he's not. They're saying that's the retainer.
That's all the jury heard.
In that jury room. Not 95. And that was great cross-examination. Hey, you're getting, get top 50. Oh no, it's 95,000. Because now it makes you remember that number. So, these tactics are fantastic.
It's beautiful. And we see now, as the chat was pointing out, why they were so desperate to get this guy his testimony limited or disqualified. What they should have done was they really should have done it earlier if they were unsatisfied with the report that he provided. Because his report on this is only like 4 pages.
See, what a lot of people don't really understand is that the academics are very good for these expert testimonies, because that's what this guy does. He writes reports. He's on staff. So he's writing law review articles and things of that nature.
Right.
So he has a team. You have research assistants and things of that nature who are doing this for credit. So it's so easy for him to write a 40-page report, right? Because that's something he does all the time. But when you have somebody who is a practitioner in the field, they can't write 40 pages of report. But what you do in the police field is you do write. When you're writing reports, they have to be concise. So his thing was very, very concise. This is what it is. This is how it is. And it's 4 pages versus 100 pages, because it's 100 pages worth of nonsense.
Yeah. I can tell you when I do an expert report, it's 100 or 200 pages long, but then there's like an executive summary, like 2 pages at the beginning. What this guy did was he went right to the 2 pages. He didn't bother with the
Yeah,
100 pages
yeah,
that comes after
yeah.
that. He's going to testify to the 100 pages.
Well, I love the state. Our experts report has headings and citations.
He has footnotes.
It's like, so, I mean, again, you're not writing an appellate for the appellate court here. You're not writing a law review article. This is, you're writing the basis of your expert opinion and what your conclusions are to put the state on notice. That's what they have to do. They have to put the state on notice so the state has some basis to prepare for the testimony. They know he's going to testify that the taser is a valid deployment based on this policy, and they know that he's going to testify on it based on his training and experience that he's got in spades. So with that, you know, you don't need too much else. But I have a 52-page report. So which one do you think the jury's going to grab, by the way, in the jury room? Are they going to pick up the 52-page report to review the evidence? Or are they going to pick up the 2 to 4 page report while they're coming up towards Christmas time? If we get testimony wrapped up prior to Christmas Eve,
The prosecutors in the George Zimmerman trial used to do this. Their issues would come up, and the judge would ask for briefs, because you can immediately appeal to the appellate court there mid-trial to get a decision on an evidentiary question, for example. So the trial judge would ask for motions, and you know, now everyone has to stay up all night, right? Because they were in court all day, and the state would hand like this 100-page motion, because of course they have a team of lawyers back at the office to do this. And I'd actually start reading those and start like looking at their case citations, and they weren't on point. I mean, it was just fluff. It was weight. They knew that because they had more lawyers, they could deliver a physically heavier motion than the defense would be delivering. And the judge would just hold one in each hand and go with the heavy one.
But because I know that this happened to me when my first time, the page limit. Like I didn't, because first you have the state rules. So state rules were like 30, there's a 30-page limit. But then you have to look at the court specific in the judge. And this judge had a 15-page limit for motions. So I did the state 30 limit. And then so what the judge does is just everything after the 15th page, they don't read.
Yep.
So they literally, and it's on you to know the page limit. So, but this judge was nice though. This judge was like, listen, you're double the page limit, because here's it, and then allowed me to, but then you have to condense all 30 pages into something. And the funny thing is the judge doesn't even read it anyway, because I got in the court and the judge was like, you know what? I haven't had time to read it. You got 5 minutes argued now. And it's like, oh my God, you know, I did all this work and I still got to argue it down the fly. So I don't know. It's the difference between the practice of law and the aspirational academic thought of how you think law should be practiced. And that's what you're seeing here. You're seeing the difference between.
One with, you know, with this case, that's one of the things that has consistently come up, because as we've all been talking about this, because with Kim Potter, you've got this question on, she deploys, or she uses a firearm when she was intending to deploy the taser. And so this argument about justified use of deadly force in a legal and academic sense is this question of, does she lose the privilege to use deadly force by electing not to use it, right? Can she manifest the requisite belief that she's in imminent danger or whatever, if she chooses not to actually act upon that belief? So then is she privileged? That's a legal question. That's a whole lot more complicated than the jury question, which is more of a common sense approach. If she's privileged to use the gun and she uses the gun by a mistake, he had to go for a bit.
He had to go.
If she's privileged to use the gun in the first place, well, then her using the gun, I mean, that's not that big. You can argue in front of a jury that, yeah, I mean, she could have used the gun and she wanted to use the taser, but she ended up using the gun, and the jury can come to that conclusion. Whereas a judge or who's bound to apply the law might not be able to do that. Right. So it's that practical versus the academic aspect of it. A jury gets to go, yeah, this is common sense.
Yes. I agree with that 100%. But I think this is the difference between being an officer being able to use force and a civilian being able to use force, because civilians are generally only able to use reactionary force. Somebody's able to attack you and you can react to that, right? So there's no such thing as accidental self-defense claims, right? You're usually saying, I shot that person because that person was attacking me. And that's why you don't really have accidental self-defense claims, because self-defense is by nature is a defense. You're defending yourself against some type of action. But with officers, they are they are legally justified to use force. So in this case, when you have somebody's all arrests, we used to consider all arrests are essentially use of force, right? Because I got to grab you and put handcuffs on you. So technically, they're all use of force. I'm actually restraining you. So police are duty bound to use force. And now the amount of force. So it's not about whether they can use force or not. Where in the self-defense context is whether you're defending yourself. Here, the officer can use force, but now we're talking about the amount of force being proportional to the force being exerted by the defendant. And if the defendant is what determines how much force an officer is able to use. So if the defendant uses a knife, then I can go up to the gun because it's really I'm responding to what they're doing. But here, since her claim is not really self-defense, her claim is I'm effectuating an arrest, and in that case, then she could be mistakenly use the taser. Even though, she can mistakenly have used the gun instead of the taser and still claim justification. Where if she was just a regular citizen, I don't think she'd be able to do that because there's no accidental self-defense.
Yeah, that's a very good point. There is, while the
she has a
analyses-
privilege to use force independent of a self-defense justification, right?
Right. So the analyses come down to similar questions, but the underlying premise of the force use in and of itself is fundamentally different. And that's a good point. I hadn't considered really in this one.
Was this guy's badge number 007, by the way?
No, this guy's badge number is 001. He got the first badge ever created.
He's in the Hall of Fame too.
When he came up with the concept
in a
of
law
policing,
enforcement Hall of Fame.
someone in the chat asked if when he told God to create the earth that it was as Chad as his defense testimony here.
You couldn't have gotten a better expert though. Not paid,
No.
wrote the goddamn book on tasers with the other
Had
guys.
open
not
heart
even sure what the
surgery
taser
last
looks
week.
like. And I'm not taking a salary because I believe in justice over. It's like, of course, objection. I don't want this guy to say anything.
Yeah,
Anything that's gonna hurt my case.
Please, our guy was citing this guy in his his paper. You almost wish that this guy had like shoved Stoughton in a locker while he was a police officer at some point. Like, just get in there, nerd. Shut up.
Well, don't forget, this guy's got a good racket, though. This guy's got a great fucking racket. It's just, go and, read about all this stuff. It was a cop 5 years ago, and now you're getting $95,000 to go around the country and give an opinion, about something you did 15 years ago. If it's good money, good work if you can get it.
Oh, yeah. Yeah, everybody on earth should want to be an expert witness. It's a great job. It's a great job. You fly first class. They put you up in nice hotels. They pay you a whole bunch of money, and all you have to do is go sit down and talk. And then every case, win or lose, pads your resume. I mean, even if you lose 5 or your side loses 5 cases, right? Well, I consulted on 5 cases on this issue. Then after your side has lost 10 cases, well, I consulted on 10 cases on this issue. That's not your responsibility to win the case. Your responsibility is to deliver competent testimony, and you can do that and still lose. I mean, that, and the side can still lose. That isn't on the expert shoulders unless their particular performance or opinions are bad. In Stoughton's case, heck, he just, you can imagine the Chauvin trial got him this job. I mean,
yeah, for sure.
frankly.
Yes, for sure.
Right.
Yeah.
That's why he did that one for free.
Oh, he did. He do that.
Yeah.
He did that one for free.
Yep.
Yeah. He did Chauvin for free.
Yeah,
And
he
smart
knew.
play.
He knew.
It's
High
funny. I
enough-
made a joke that Stoughton had footnotes, right? And that's why his report should be more credible. Joking, of course. This guy, James Iams. How do you say his name? Iams?
Yeah, I am.
If he had a footnote, it would be to him.
Right. I don't need footnotes, Your Honor. I'm the primary source.
Yeah. I wrote the damn thing. Yeah. It's tough.
Undominant one. We're going to hear.
Okay, that's still the Fox.
I'll be right
The
back.
Fox has a lady attorney, Debbie Lang, on from Hallberg Criminal Defense giving her opinion. So I'm trying not to poach their content, just the feed. I like their setup of being able to see both people, and they've been pretty good about showing exhibits. So I'm sticking with the Fox feed for now, but I don't want to take their commentary. We have plenty of commentary here of our own. So
In 4 minutes, I got to knock off again.
no worries. You're welcome to come back afterwards
that was
if you're
just
available.
A sound check.
Sure. Is it a good media appearance? Should we tell people about it?
I don't know if it is or not, to tell you the truth.
Oh, okay. I won't tell him. I won't tell him you said that.
But yeah. But because I'm ambivalent, I don't want to say who it is. So I don't want to embarrass anybody.
Yeah, no. I was kidding completely. Mither and Emmer says, Nick, Weasel Boy didn't quite lie. Earl Grey asked the wrong question. Earl Grey asked if WB said they should have let him go. Oh, Weasel Boy said they should have let him go. He didn't. He did say they could have picked him up later. It was merely implied they should let him go. I think it was about no, but I think the substantive issue was the picking him up later. That's what the defense is arguing. We want to go after him saying that they could pick him up later. And
it was presented as a reasonable option for a reasonable officer, and therefore this other stuff was unreasonable.
Right. And that should not have been allowed to go unchallenged in front of the jury. With this witness testifying, I mean, I don't think it's going to be an issue. It's like the Rittenhouse thing. There's all this noise, and then when you get to the actual meat of the testimony on the facts of the case, I mean, it's clear as day for the most part. And one thing I was thinking about this morning was remembering that was the end of the state's case in chief, and you should feel apprehension about the defendant's chances at the end of the state's case in chief. If they've done their job at all, you should go, okay, there's a chance that this person gets convicted, or this person's definitely getting convicted. And then it's up to the defense to change your mind on that. So, the state put forth.
Okay.
Oh, you out of here?
Yeah. Sorry,
All
I got two feeds going on. I'll be back shortly.
Yep. What the state needs to do is to put forward their best case. And hold on, my brain got completely mixed up there. The state's job is to prove beyond a reasonable doubt. They should have done that by the end of their case in chief. And then the defense's burden is to raise that reasonable doubt. So the state did not put on a competent case so far. Their best day was yesterday, and that was at best, I think, barely above average. They came out on top on some motions. And then what ended up happening, though, is they lost out on their probably more significant motion of limiting the expert witness testimony today. So that's been good developments. With that, I'll try and keep up on the super chats, guys. I am 40 now, so that's why I lost my train of thought just a moment ago. I'm now too old to carry a thought for more than literally 1 second at a time. Where am I? Corn Pop, he's a bad dude. I remember when I was a lifeguard. David Payton says, happy birthday, Nick. Much love for you and all of your guests. Hey, thank you. Uncle Bear Bear says, deep within the womb of time, a creature thus be born, the seed of life is united with the egg of tyranny, gestates forth from within the womb of life for 3/4 and nigh a year. The creature thus be born, the creature thus be formed. Okay. Eric Johnson says, happy birthday, dude. With your age and your ankle injury, could ADA Lunchbox Kraus beat you in a race? Answer, no. Just drop a few Wonder Witches and walk to the finish line. Those are so good. Kyle Bogue says, why does the defense have to disclose anything? The state doesn't lose 20 years of their life if they lose. I agree. I actually do not think that the defense should have to make those types of disclosures to the state. I mean, obviously they do under the rules, but they should not have to as a matter of principle. How can the defense surprise the state? We're litigating by surprise. I don't care. You're the one bringing the charges. You're the one saying there's criminal activity. You're the one with the burden of proof beyond a reasonable doubt. I should be able to surprise you all day, because it's not actually in the interest of the defense to litigate by surprise, and it is in the interest of the state to litigate by surprise, because in theory, the way aspirational law works, as Nate was talking about. The idea is that the state should be seeking justice. And when the state is presented with some evidence of justice where they say, whoa, there's reasonable doubt here, they should, in theory, drop the case. If the state can't prove beyond a reasonable doubt their case, they should let it go. Does the state do this? Rarely ever. Rarely ever would the state actually drop a case, even if they think they've got a stinker. But if they can convince a jury to their side, they'll keep it up. That's not the appropriate way to go through it. And even, I would say, even the good prosecutors and the good attorneys' offices in various states or even the federal government, I think they have lost that definition as well. I think if there's reasonable doubt, they should drop the case, and they typically do not. Now, that's not saying all of them are bad or malicious or anything like that. I just think our perception of what criminal liability is has shifted away from the original sort of notion, this aspirational notion of proof beyond a reasonable doubt. I don't think that exists in the way it's supposed to anymore. So with that said, it shouldn't be in the best interest of the defense to litigate by surprise, because you should be able to say, by the way, we've got this expert who's going to just tear you up, and look at his qualifications. Here's his expert opinion. And the state should go, you know what? You're right. I think that's correct. We've got to drop the case. But they won't. They'll go, oh, we'll figure out a way to keep your expert from testifying. Our expert that we paid is going to give the right opinion versus yours. We're going to try and exclude this evidence. Whatever it is that they do. But so because of all of that, it's not in the defense's interest to litigate by surprise. And in my opinion, since the state bears all of the burden in this, and the loss by the state is nothing, the loss by the defendant is the loss of their liberty, there should be no required disclosures at all from the defense, in my humble opinion. He says, the state doesn't lose 20 years of their life if they lose, although Frank and Ellison should be bringing these bogus charges up without any real evidence, simply appeasing BLM. Michael Palmer says, Nick, you ever heard of a criminal defense attorney in Minnesota named Bruce Rivers? His motto is stop self-snitching. He always seems to be in line with your opinions. He knows these attorneys as well. I do not know of him. Sounds like a cool dude. If he agrees with me, I like him automatically because I know he's correct. Elizabeth Stoddard says, I got mistaken for a recruit one night. I had to stay in their barracks. They unlocked my door yelling. My only response half asleep was, I'm a civilian. Next morning, I found out they would have flipped my mattress. Dang. Girlfriend 66 says, what? This guy can't keep a job. Okay. Mean Sarton says, the fact the state used the expert they did tells you that competent experts like this guy refused to help or believe Potter was justified.
Shape of the taser.
Oh, God. This is starting to feel like a long break. I don't want to miss anything when they come back from break. That's why I'm monitoring that screen. Coltrane says, Super Saiyan RoboCop. I was there when the Romans killed Jesus. In my 2-page report, I found them to have used excessive force. Abe Eckstein says, can you get this chat on for free to teach the boys about good policing? Maybe. I don't know. I'll have to ask. The guy sounds very busy, right? He's copifying. He's running around the country, saving the world and providing expert testimony.
Bench, let's take you back inside the courtroom. Debbie Lang, thank you. We will be back during the lunch break a little later on.
That was on the screen was attorney Debbie Lang, I believe a criminal defense attorney in Minnesota. I forget the name of the firm she's from. They said it earlier. Mike Fenn says, Your Honor, after listening to Mr. I. James' service record, we are prepared to stipulate to anything he was going to testify to, but for the love of God, just get him off the stand.
You can come forward and take a seat.
Our butts hurt. Sincerely, the prosecution. Cathurga says, as a lifelong Midwesterner, the guy's cadence is so pleasant to listen to. I could listen to his testimony for 6 hours or however long the state would gish galop for. Synapse says, we need Virgin versus Chad memes on the prosecution and the defense's use of force specialists. DCV Titan says, in a use of force expert dick measuring contest, prosecutions doesn't make the table, defenses atomizes the table, proceeds to crack the mantle, and creates a new tectonic plate. Also, happy birthday and welcome to the end. Oh, thank you. Thank you. Where do we go? Chain Breaking Sage says he literally designed the first independent taser training course. GB says, just take my money, you magnificent Polak beast. Pardon the spelling. YouTube is YouTube. Mike the Dad Crosby says, expert versus Professor X. Defense called him today because they knew the worst part of the state's case for the defense was Professor X. Prosecution witness totally destroyed, in my opinion. No, I agree. Marie D says, wow, what a great birthday, Nick. State rests. Officer 007 is use of force expert. Now the state has to cross. And the cherry on top, uncivil law serenade. Happy birthday.
Please be seated.
And thanks for sharing it with us. Cheers. Thank you, Marie.
Mr. Frank, you may cross.
Thank you, Your Honor. Good morning yet, Mr. Imes.
Good morning, sir.
Thank you for being here.
Made it back just in time.
Talk to you a little bit about your CV.
Yes, sir.
Probably doesn't come as a surprise to you, right? You have been an expert witness before.
Yes, sir.
Let's see. Maybe the state knows something awesome.
If the, well, it really seems like you've really dedicated your life to law enforcement.
That's my only job I've ever had. Yes, sir.
Really immersed yourself in it, right?
All I've ever done.
I'd say it's been more than just a career. Yes, sir.
What has it been? More than a career, it's been a calling for you.
It has been.
Something you are completely dedicated to.
I am.
More than a 40-hour-a-week job?
For certain.
In fact, we know from, for instance, in your CV, your resume, there's a section where you talk about, I think the title is operational experience. You recall that section?
Yes, sir.
And you're talking there, I think that's about while you were working for the Springfield Police Department?
It may include some other times, but mostly SPD. Yes, sir.
Okay. And there was, you talk in there a lot about the work you did during that time period and all of the different things you were able to do as a police officer while working in that capacity, correct?
Correct. Yes, sir.
But even during that time, you were not just working for the Springfield Police Department, you were going out and doing other speeches, conferences, working in law enforcement for other agencies, consulting, correct?
For the U.S. government, yes, sir. For other entities, correct.
Yeah. In fact, during 2001 to 2007, which is the time when you were a major and a commander at the Springfield Police Department, right?
Yes, sir, I was.
During that time, with all those responsibilities, you also traveled really kind of all over the world to do other events for law enforcement agencies.
Yeah, yes, sir. The city of Springfield, not unique to the city, but they decided in the early 90s to partner with the Department of State. We sent 27 officers to Haiti in 94 to assist in creating their national police force. So our department and city were committed to allowing us to participate in things that seemed to be in the interest of the government. So yes, sir, I had that support. If you hadn't had it, you couldn't have done it.
Thanks for offering that extra bit. I just simply asked you if you'd done a lot of that, correct? I didn't ask you about the other officers, right?
That's true. You did.
Okay. So For instance, 2001 to 2007.
He's trying to say he
2001,
wasn't a
you went
cop,
to
that he
Canada to
was
speak
he was something
at a
else.
Chiefs of Police conference.
Probably more than one, but there may be one reference there if it was significant. Yes, sir.
In March of 2002, you went to Asia to speak for the Department of Justice.
You said Asia?
Yep.
Where in Asia?
Okay, Indonesia? Is that what it says?
Let's
I just don't recall the Asia. I mean, I don't think I would have been that general on my CV. It probably was Indonesia or East Timor.
Like Asia. He got him checking the CV. Check my CV, fool. Check the CV.
Frank, why are you just say, okay, yes, that's more
East
specific.
Timor.
East Timor. That sounds more like what I would have written. Yes, sir.
And that is followed by the word Asia.
Okay.
No geography expert. I can't tell you where East
Yeah,
Timor is.
continent versus country, but yeah. Thank you.
God,
Uh,
how do you look bad crossing on a
in
CV?
2002, you also went to Canada for the Chiefs of Police.
I'm sure I did, sir.
In 2002, you also went to
My
England
chief went
for
to that
weapons
thing too.
conference.
The chief police stuff.
Yes,
Yeah.
sir.
In November and December of 2002, you went to Africa for the Department of Justice.
Correct.
What is he doing? Bolstering
In
his resume?
October-
Like we
I'm sorry, in March and April of 2003,
Trying
you
to-
were in Africa for.
When did you
the
have
Department
time
of
to
Justice.
tase anyone?
I agree.
In October of 2003, Scotland for a weapons conference.
Yes, sir.
November of 2003 in Jamaica for a conference from the Police Executive Research Forum,
Correct.
law enforcement agency, correct?
It is like the IACP, but for bigger agencies. Yes, sir.
England in 2004, February of 2004.
Correct.
In
they're all
2004,
over
in
the place.
June and August, you were in Greece for the Olympics.
I was.
And in March of
He
2005,
policed
in
the
Yemen.
Olympics.
Correct.
June of 2005, back in Canada.
Agree.
July of 2005, back in Yemen.
Yes, sir.
May and June of 2006 in Uganda.
Correct.
June of 2006, Tanzania. October of 2006, England. October of
so he's
2006, Ireland.
bolstering his. I don't
Sounds
understand
correct.
Those are all for law enforcement purposes.
Exclusively, yes, sir.
And that was just what you did in those years while you were a commander at Springfield.
Correct.
That you told us about in your CV. You have, whether they were appointments or speeches, would you agree that the great majority of them are law enforcement groups,
I think they're exclusively law enforcement groups, sir.
such as the National Tactical Officers Association,
Yes, sir.
I don't think this is
International
going the
Chiefs
way
of
Frank
Police.
thinks it's going.
Yes, sir.
Department of Justice,
Yes,
I'm
sir.
trying to figure out where he's trying to go with this, right? Because
Executive
that's what it always is about. Where's he going?
Correct.
Association of Chiefs of Police, right?
Yes, sir.
The Armed Police Officers
Maybe
National
that
Training
he's biased for police,
Yes, sir.
but then they go to get that when he's or he's
Television Network.
testifying against some police.
Yes, sir.
So
That's
Yeah.
just exactly what it sounds like. Is a
It's a training process that gives televised training versus in person for law enforcement. Yes, sir.
International Association of Law Enforcement Firearms Instructors,
Yes, sir.
the American Association of Law Enforcement Trainers,
I was going to
Correct.
say everything he can with law
Illinois
enforcement in
Tactical
it.
Officers Association.
That would have been their annual conference. Yes, sir. I would have taught at that.
I'm sorry, I didn't hear you.
At their annual yearly conference. Yes, sir.
Institute for Law Enforcement Administration.
Yes, sir.
Let me just run through some of these, and I'll ask you a question then. The Indiana State Tactical Officers Association, the Ohio State Tactical Officers Association, the Massachusetts State Police, the FBI, Wisconsin State SWAT Association, the Oregon State Sheriff's Conference, the the Utah State Sheriff's Conference, the Colorado State SWAT Association, and the LAPD.
Yes, sir.
All groups that you have done things for frequently.
Yes, sir.
And in fact, there's only a couple of things on your CV that are questionable whether law enforcement. You've done some things for the Convoy of Hope.
Sure. I think that might be under a different heading. But yes, sir. Worked for Convoy of Hope doing overseas relief stuff in Haiti and Nicaragua, places like that.
I did
And,
charity in my time off.
Even with that,
Yeah.
you're still providing security and law enforcement function, correct?
It just depends. With Project Hope, no, that's exclusively leading teams at orphanages and things like that. With Convoy, I've done security assessment.
He's like, I'm dealing with orphans. With that one.
Overseas in that context is a group called Project Hope, and that's not been security.
My time off, I
You
help
did,
out with
some things for the Penn
orphanages
State
in third world
University Applied
countries.
Research Lab a couple of times, right?
That's law enforcement, though. I mean, the Penn State Research
Where's he
Lab
going
is
with
less
this?
lethal weapons technology.
That he's biased, I
Why
guess.
would he ask these questions?
But you
Maybe.
describe as your professional accomplishments are all from law enforcement groups.
Beyond question.
As Mr. Eng asked, the Hall of Fame for American police officers.
Yes, sir.
Fulfilling to be elected to the Hall of Fame, right?
Not in the context for what I got it, but understandable.
Okay. What could you mean by that?
It involved using deadly force against a person, and I didn't ask for that award.
The,
Wow.
the board of directors of the National Technical Officers Association.
Yes, sir.
Police Chief Magazine.
Is that reference to being on their policy, or I'm not sure when you say Police Chief Magazine, I've written for them, but I've also done editorial review for them. So I'm not sure what your statement there references, sir.
It's in your professional accomplishments section. So,
Okay.
those are all law enforcement organizations.
Yes, sir.
Any writing that you have done has been for law enforcement trade magazines,
Exclusively. Yes, sir.
including the International Association of Chiefs of Police. It's tough to say. The magazine for that group,
Yes, sir.
and the National Technical Officers Association's publications.
Correct.
So this is something you've really committed yourself to, 110% probably, law enforcement.
I would agree with that.
Career police officer.
It's all I've ever done.
You
All
have
I've ever
also
done.
been retained before to offer expert opinions on law enforcement conduct.
Correct.
And just clarify one point, if I could. You indicated on your direct testimony that you have 4 current cases, and this is the only one where you're testifying on behalf of an officer. Is that right?
I've got 4 current criminal cases under review. I probably have 20 civil cases, but only 4 that are criminal.
And this is the only one where you've been retained by the officer.
Correct. And the other 3, it's either an attorney general or a prosecutor would be, I don't know how to characterize it other than to say my testimony would not be supportive of the officer's use of force. That would be the best way to say it.
All right. So just I want to clarify that, because it's true you have been retained in this jurisdiction by another police officer on their behalf, correct?
From my perspective, this particular case from day one was to take a look at the issues, initially focusing on the taser, and just give my
When you say this case, what are you talking about?
the case we're sitting in right now.
Okay. I didn't ask you about that. You have been retained on behalf of an officer in another case in this jurisdiction, correct?
You mean, do I have another one right now?
Yes. You told the jurors you have 4 open criminal cases, right? You said this
I
case.
think I'm following you. I've actually got 5. I apologize if if I think where you're leading to. I am involved in another case that I just realized that would be more supportive of the officer. So I actually have 5 right now. I've not done an expert report. I've not testified. I may be on the wrong case, but I do have another one I just thought of that I've not done anything on as far as a formal report or anything. So it would be 5.
And I'm not interested in having you talk about the name of that case or anything about that case, but I just want to make sure that it's being represented correctly to the jurors. Okay?
Right. I would have a second case in this jurisdiction that would be, as you're characterizing it, in support of an officer. That's true. I would guess I was trying to focus on those I'd either done reports on or done something formal on, but I currently am involved in a 5th case, so it would be a 2 to 3, not a 1 to 3.
You did a report in that case.
Current case?
in the other case here,
Yes, sir, I have.
in a lengthy report.
Well, a report, yes, sir. I mean, longer than this one, yes, sir.
It's weird.
You have testified in court on a number of occasions as an expert witness.
Yes, sir.
These facts of being retained and having testified really not described in your CV, are they?
I couldn't hear the last part of what you said, sir.
They're not described in your CV, your resume, are they?
In my report?
In your resume, your CV, your curriculum vitae that Mr. Eng asked you about.
I don't understand the question, sir. I'm not hearing something, apparently.
I've been asking you questions about your CV, which is for the Latin term curriculum vitae.
Yes, sir.
I assume it's Latin. It's a fancy word for resume.
Yes, sir.
In that resume, you've listed a lot of your experience and your accomplishments and your awards and your trainings, right?
Yes, sir.
But you don't list in there how many times you've been retained as an expert.
I don't think in my CV, no, sir, at all.
How many times?
Generally,
10,000.
Yeah, but generally in CVs you don't. Well, you can, because I know I put my speaking engagements in there.
Only if you need to pad
And
it.
so you do
His
not
CV's already
recall
longer than this guy's resume.
sought you out or whether you approached the defense in this case or they approached you.
No, I don't think I approached anybody that I can recall ever that I can recall. I had a prior case with Mr. Eng, and I'm thinking the two overlapped. I just don't have a perfect recall of how we got together.
Okay. And you are doing this for free because somebody's liberty is at stake.
As I do in every criminal case, yes.
And that's pretty important.
It is to me.
You indicated in your direct testimony you like to get paid, but you're doing this for free, correct?
I think like most people, you like to get paid for your labor, but some things are more important than money. So that's the decision I made, right or wrong, a long time ago.
You have indicated you have 43 years of experience in law enforcement, correct?
Continuous commission, yes, sir.
You have been doing at least 25 years of evaluating police officers' use of force.
I think that would be fair. It didn't really begin till I was a supervisor, so late 80s, yes, sir.
Just started
Testified
from the late
as an
80s.
expert, been retained to
After the first Star Wars movie.
Many times, yes, sir.
You are familiar with the constitutional cases on police use of force.
Grand
I am.
Connor.
I'm not an attorney, but I'm familiar from a police perspective, yes, sir.
And you try to teach those concepts to others.
From a police perspective, yes, sir. Not a legal perspective, but a police perspective.
Those are very different things.
Yes.
Yeah.
And you
Substantively different.
indicate
You
you
think they
have
wouldn't be, but they are.
several thousand police use of force cases over the past 25 years, right?
I think 2,000 to 3,000 would just be a fair estimate of applications of force involving law enforcement I've reviewed, yes, sir.
And in this case, this present case involving somebody's liberty, you were asked by the attorneys to review the materials and offer expert opinions concerning the police practices involved, right?
Yes, sir. Not all of them, but yes, police
What
practices.
were you asked to offer an opinion on?
As best I can recall, sir, the initial focus was on the taser itself. Of course, to use the taser, you have to have a lawful basis to have your feet where they were. So that involves stopping the vehicle and then whether you would do things once you got there. But it was primarily focused on the stop and then the taser application.
And with all of that, you wrote a report, correct?
I did.
Your report is just over 2 pages long, is that right?
It's 2 or 3. Yes, sir, that's correct.
The opinions that you have, to me, seem to start about halfway down the second page.
I'll have to look.
Got Batman glasses.
Yes, sir.
So the sum total of paragraphs in which you have opinions would really be 3. Is that right?
What was the number you said? I didn't hear it.
3.
Sure. That'd be about right.
You express your opinions as you have today on the stand in terms of contemporary police practices. Correct?
In response to questions concerning that, yes, sir.
None of your opinions today or in your report have utilized the phrase an objective officer in light of all the facts and circumstances known, an objectively reasonable officer in light of all the circumstances known at the time, correct?
I'm not certain, but that could be.
Well, I'm just saying the way you have written your opinions, you did not use those terms.
Okay.
Is that true?
What term specifically, sir, am I looking for?
Whether a reasonable, an
You didn't use
objectively
He's
the
asking
word
about the gram factors
light of all the
and the
facts
gram
circumstances known
standard.
to the officer at the time.
I don't think I used those words in my written report, sir.
During your testimony today, you never used those terms to express your opinions, did you?
Well, they'll just ask them on redirect.
I don't recall.
Yeah. But that's
They'll
the,
just say,
it's the
you were
gram
asked about the
stuff.
magic words.
The jury doesn't know the
Well,
magic
I recall-
words.
And I don't believe you ever used those terms for your opinions. The only time you used it was in reference to a Supreme Court case, correct?
I don't recall exactly what you're talking about, but I'm
We did use
reasonably
them?
certain you're probably right.
In fact, when you were taking issue with the proportionality concept, you said it's a lofty goal to have proportional force.
Yes, sir.
You don't think that's something of a legal requirement?
I think there are cases that suggest that, but not to the standard of objectively reasonable behavior, which we have in Graham, which is the big focus.
And
Boom!
that, you said objectively reasonable in referring to a Supreme Court case, which Graham is, correct?
It is, yes, sir.
Gram is the standard.
Mr. Imes, do you have a copy of your report with you?
I do.
Did you actually write this report?
I did.
Okay. Did you write it before reviewing all of the materials?
I would have written it long before I reviewed anything last week. So I wrote it after I looked at the case that was supplied to me on flash drives.
Okay.
But certainly I learned things last week that would not apply to that report.
And you have a copy with you?
I do, yes, sir.
Your Honor, may I approach the witness to take a look at that? May I look at your pen?
Sure.
Wonder what he's getting at here.
If it's different, he'll object, right? He'll say the guy's using a version of the report he did not receive.
At the bottom of your report, below your signature, there are a few lines written there. One of the lines is, I need all of the records mentioned and easy access to the video, correct?
Correct.
So if you needed all access to the records, how did you write this report if you hadn't had them yet?
I don't even know what that is. I had Mr. Ing print this for me yesterday. So that would not have been on the report that I submitted back in September. I just I didn't bring a copy with me.
The report that was disclosed to us from Ms. Potter's counsel is exactly the same as the one you're looking at. It has that
Okay.
line on there.
I'm just not remembering what that was in reference to. I certainly need all the records mentioned, et cetera. I don't,
Well, why would that be on your report below your signature if you had reviewed all of the records before you wrote your report?
I would have reviewed everything sent to me up to September. I just have no recollection of what else might have been mentioned. To be candid, I don't understand what that suspended ? Engine status ? I don't really know what that is. So I'm at a loss to tell you.
Yep, so it also says they're suspended, question mark, correct?
Suspended with a question mark. Yes, sir. I really don't know what that is.
In your review of the case, are you concerned about or curious about something being suspended or someone?
I have no idea. Engine status. I mean, I really don't have any recollection of what that references to.
I do want to ask you about that one, engine status question mark, correct?
Yes,
This
sir.
is like from an
You told
email
the jurors
chain or
today
something.
that the whole issue of shooting occupants of a vehicle was not black and white, but
This is not in reference to the
it is
car
a
engine, you
concern
dope.
of shooting somebody who is operating a vehicle, right?
Or behind the seat in any capacity. Yes, sir.
So whether the engine was on in that vehicle would be a pertinent consideration, wouldn't it?
It'd be one step closer to movement. Yes, sir.
So at the time you wrote your report, you were still questioning about the engine status?
I just don't remember what that means.
Did you ever find out if the engine was running?
I believe that it was. Yes, sir. Keys in the ignition.
So he was building up to that moment.
That sounds like a tech error that they have been exploiting
In
or
your
that they're
review of the
utilizing
body-worn
here
camera
to
videos,
me, but
all Mr. Wright had to do was put it in gear to drive off, correct?
I'm not sure exactly how that vehicle works with brake and gear, but pretty close to that. That would be it.
Well, I think all vehicles require a foot on the brake to put it in gear, right?
I don't know.
Okay.
it's not an expert
fair
on
enough.
cars.
At the time of the shot, Mr. Wright's feet were on the driver's side floorboards, correct?
From my understanding of the video, yes, sir.
Now, it's your opinion here today that, and in fact, when you wrote your report, that Ms. Potter only meant to use her taser, correct?
That's my understanding. I've not seen anything to suggest otherwise.
And one of the reasons you believe that is she only pulled the trigger once.
That's a factor. I mean, it's not a significant factor compared to other things, but that's a factor.
Well, probably the largest paragraph in your report is just about that very fact, that she only pulled the trigger once.
I'm just saying there's other factors such as verbalization and
Sure.
things like that that are more reflective.
Okay. But you told the jurors it's not a significant factor, but it took up a lot of space in your just over
You
2
said it
page
wasn't
report.
the most
May
significant.
required a
factor.
few more words to explain that. Yes, sir.
And what you're explaining there is officers are trained, if you're going to pull the trigger on a gun to use deadly force, you pull it multiple times, correct?
That's not necessarily true. It's just operationally they do. They rarely pull one time only. In some scenarios, they're taught to shoot more than once, double tap. We don't teach to shoot in every case multiple times, but that's more common, of course, than just a single shot.
So when you were asked to provide a report,
Ask Amalu
the
Diallo.
attorneys who had retained you in this matter, you pointed out here that the number of times she pulled the trigger was a factor to consider, right?
Yes, sir. That's correct.
And
The
what you
taser,
said
can it fire
was
twice? Do we know?
firearms Training nationwide.
I think if
generally
you
involves
pull the trigger
rapidly
again,
pulling the trigger multiple
it
times,
activates the
and discharging
electricity
rounds is
again.
necessary to stop a suspect's threatening behavior.
Generally, as I said, yes, sir. Not in every case, but generally.
Taser training, in contrast, involves a single pull of trigger.
Press and release. Yes, sir.
So that was a fact that you put right up front in your report in your analysis of your
Yes, sir.
conclusions. And I mean, as you sit here today, as an expert, you agree that an officer's use of force is evaluated by the reasonable officer standard.
That's a segment of it, yes, sir, in the Graham case, the reasonable officer standard, correct.
But really for you, it's police practices and training. That's been the focus of your entire career, is training police officers.
Well, the reasonable officer standard is not some magical component of a police officer. It is the fruit of their training, their organizational culture, policy. They just don't raise their hand and get commissioned to become reasonable. We teach them. We try to prepare that. So,
But your perspective, your entire career has been devoted to training officers in their practices and conduct.
to be reasonable, yes, sir.
All right. So you must agree then by pointing out the number of trigger pulls that an officer's actual conduct can indicate what a reasonable officer knew at the time.
It would be one indicator, not necessarily everything, but certainly.
So you would have to agree then that because Ms. Potter only pulled the trigger one time, as with a taser, there's no reason to believe that a reasonable officer in her position at the time believed that shooting her gun was a necessary use of force.
I think I understand you're asking whether at the moment she fired that. I don't think I should try to interpret that. Could you just say it again, please?
Sure. You would agree that because, I mean, you pointed out the number of trigger pulls,
I did.
and you did that to support your opinion that she did not mean to shoot her firearm, she meant to use her taser,
It indicated less likely. Yes, sir.
and indicated the use of less lethal force.
Correct. Yes, sir.
And so you would have to agree then, since you're relying on it, that because she only pulled the trigger, she did not, a reasonable officer in her position would not have perceived a reasonable basis.
Same argument from yesterday. She used the taser, so that means
Lethal force.
deadly force is off the table.
Well, I guess I don't know. I've not read any testimony from her what her perspective was, but from what I've seen in the video and the assessment would be that an officer in her position was not perceiving the need to use deadly force. And so the use of the taser would have been the appropriate tool, and that's what she was trying to do. But I've not heard directly from her, so I just don't know that.
You agree, I mean, it sounds like you're kind of saying that this Mr. Smith gave you the opportunity to be the first taser instructor. Is that what you were telling us today?
I was in the first class
Okay.
of the master instructors. There were about 20 of us in 1999.
And proper targeting is a very common topic taught in taser training, correct?
That's the target or a topic that's common and important. Yes, sir.
And you agree that good probe spread is important to a taser achieving neuromuscular incapacitation.
That's the primary factor is probe spread.
That sounded like what you're saying is sort of in the same way as having to shoot somebody in the head to immediately stop them, correct?
That would be more likely than the body. Yes, sir.
Okay. But a taser deployment is not always effective at achieving neuromuscular incapacitation.
The best studies are about 67% of the time. From a practical, no excuses, did it work, did it not? About 67%.
So that's a lengthy way of saying no, it's not always effective, right?
I couldn't hear you, sir.
That's a long way of saying no, it's not always effective.
Not as long as Stoughton.
And I think your testimony was when a person is sitting down, you might be able to achieve a good probe spread just because they're sitting.
Because of the bend in the body, yes, sir.
But if the taser is only a foot or two away and pointed at the area of the chest involving the heart, that's not really going to, that may not achieve good probe spread.
It just depends on how far the heart is from the thigh. I don't know, but it may or it may not. If they're sitting up high enough that it doesn't get to the thigh and split the belt line, then the answer would be no.
But if an officer is trying to achieve that total neuromuscular incapacitation immediately, that's an important consideration, isn't it?
It's the key consideration for the taser to work. Yes, sir.
And you agree that one of the purposes of the taser verbal warning is to alert other officers
It is.
and to let go of the suspect, subject, whatever term you want to use.
I can tell you from a training, do you want me to just answer yes or no or to explain stuff?
Go ahead, tell me.
From a training perspective, the answer could be yes or no. The warning is designed for a number of things. One significant factor is there's been a concern about officers perceiving the pop as a gunshot and somehow reacting inappropriately. So that's one issue. The second is to make sure you're generally out of the path of the probes. If the officer saying that is there and I'm between you and that suspect, I would want to move. Generally, keeping a hold of a suspect may in fact be valuable, during a taser deployment. Taser specifically instructs controlling under power, which means handcuffing while they are energized. And so having a hold of them when they're hit, if it occurs safely, is really the best place for you to be, because then you then move to handcuffing and don't have to reach to re-engage. You just put them in cuffs while they're being energized.
But it wouldn't be unreasonable for an officer to let go of somebody who's about to be tased from a foot or two away.
It would not at all.
You testified a little bit about this distinction between operating and driving a motor vehicle. So I want to talk to you about that.
Okay.
You're familiar with, I guess, training or practice on shooting occupants of a motor vehicle.
I want to be responsive to your questions. I don't recall any specific training on shooting occupants of a motor vehicle ever in my career. We have training that involves concerns about that, but there's no block that says today we're going to do shooting occupants of a vehicle. So that's the best way I can answer that. I'm not familiar with that particular block of instruction. I'm familiar with many blocks of instruction that include unintended secondary consequences, like a person in a tree who gets tased and they fall. So I am familiar with training that speaks to what might happen if you shoot a driver.
Okay, so let me back up a little bit. It sounds like you're still talking about tasers, correct?
No, either way, I just gave you an example of secondary consequences of the shot itself.
An officer has to consider secondary consequences, collateral injuries, correct?
Not just with a taser or a firearm, really with everything we do.
Exactly. The example you gave, tasing somebody in a tree, they may fall out of the tree.
Yes, sir.
And you have tried to explain to the jury today, I think, about tasing somebody who's operating a vehicle.
Yes, sir.
So, but this general notion about using force on an occupant of a vehicle, right?
Right.
Comes from the very common sense and understandable concern that if somebody's driving a vehicle and you do something to them, the vehicle could become an unguided hazard, could become dangerous to others.
No question about it.
So is there training that police officers get and you teach about the dangers of shooting or incapacitating people who are driving motor vehicles?
I'm not familiar with any block that is specific to that, but I'm familiar with many blocks that reference it.
All right, maybe we're splitting hairs. It is a concern, isn't it, that it could cause collateral injury?
Any application of force when a person's involved with a mechanical conveyance, for an example, raises with it the collateral concern of the conveyance itself. It's different than standing in the street if you're on a bicycle. So all training, force application, involves collateral concerns such as an accidental fall down and they hit their head. I've never had a block unique to that, but all, in my experience, involves that.
Does the average officer on the street know this?
You said, does the average officer on the street?
You talk about contemporary police practices and training, and this has been your career. Does the average officer know about this danger?
Which specific danger are you asking me, sir?
Well, let me just rephrase the question.
Okay.
God. I like this guy's answering very respectively, and Frank's treating him like he's an asshole.
Center Police Department policy about shooting into motor vehicles?
I don't recall.
So you're not familiar with the policy that Ms. Potter would have been subject to as a Brooklyn Center police officer?
I'm just saying I don't recall it, sir.
In that policy,
This guy's a great
talks
witness.
about, discouraging. I'll be kind with that, my words.
Because it's not a blanket prohibition.
Vehicles.
Okay.
Now, would you agree with me that the reason for that is the potential for collateral injury when you disable the person driving the motor vehicle?
I just have to have you hand me the policy and let me read it to get the context. I don't remember it, so I just can't tell you.
But that general concept, do you agree with the general concept that that's the concern, is the risk that causes?
The greater risk that comes to my mind in the question you're asking would be concern about people close by, not the person driving off. So in the absence of reading the policy that apparently expresses the concern you're saying, I'd be guessing to tell you what they're trying to communicate to her in that policy.
Your concern is about others, right? I mean,
I'm saying you're asking me if it's the vehicle driving off. I'm saying my primary concern would be if there's passengers, someone close by would be more of a concern than the person driving forward.
if a vehicle that's being driven, if the driver is shot, it's not going to make them a safe driver, is it?
No, sir.
So that's the danger presented, right? That not only are you shooting that person, but you're putting others at risk because you've got a vehicle that's moving that could harm somebody.
It would depend completely, sir, on the circumstance. If we're in a downtown street compared to in the middle of a cornfield. So it depends on the circumstance. Which one of those would be a greater risk.
I guess, I think we're just arguing.
He's not arguing with
They're
you.
not arguing.
Spending far too much time on this, but
You're in charge of that,
I'm
Frank.
simply asking you is
That's
is
an objection, though.
concern
Objection argumentative.
for collateral injury if you incapacitate a person driving a motor vehicle?
If you ask it that way, the answer is certainly and quickly yes.
All right. So you draw the line then at a vehicle that's moving and a vehicle that's not moving.
Well, moving clearly is in a condition to go forward. If the vehicle's in park and the shot is effective, then the vehicle's very unlikely to go forward. So I would draw that distinction. Yes, sir.
So if a vehicle has a person in the driver's seat and all they have to do is shift it into drive, that situation doesn't present the same dangers at that moment as the vehicle that's already moving?
It does not.
Doesn't present any dangers at all.
That's a different question.
All
There's
right.
still danger. If they're immediately incapacitated and the vehicle's in park, it's going nowhere. If they're not, then it certainly presents a danger if they have the capability.
That was my point to Natalie the other
You
day.
expressed
Yeah.
some familiarity with Minnesota law about being in control of a motor vehicle.
I'd read, actually, I was curious and I actually searched the statute and there was a reference to operating. And it talked about feet, positions, conveyances, just I don't have it verbatim, but it specifically talked about what operating was.
What statute was that?
I can't tell you from memory. I just went to Minnesota statutes and literally Googled the word operating. There's a statute and reference, I believe.
You're the lawyer.
Car crashes or
Yeah.
intoxicated driving. They were just a reference to conveyances or parts of the motor vehicle that allowed its movement.
Could a person under Minnesota's DWI laws
Objection.
DWI for sitting in
Objection.
the driver's
Call for
seat,
legal conclusion.
keys in the ignition and their feet in the floorboards?
And calls for legal conclusion.
The objection is sustained.
Yeah.
Right on
He's-
point.
When you told the jurors that you read some statute,
Not an expert on Minnesota law
might
on
have been-
DUI.
well, was it the DWI statute?
I just don't recall. It was just a reference to operating, and I just mentioned that in the fact that Minnesota statute even talked about operating a vehicle. So that was the sum
When-
total of that.
Flustered Frank.
Yep.
Yeah, that flustered.
You used the
That's
term
that's Trump's
operating
nickname for
slash
him.
driving, correct?
Yes, sir.
We got a
You
little
went on to
flustered
use
Frank over
the
here.
next sentence,
Someone needs to bring Flank, his
Operation.
blankie.
slash driving.
His line is blanky.
Correct.
Yes, sir.
If you're drawing the line only at a vehicle that's moving, why did you feel a need to, in your just over 2-page report, add the term operational?
A 2-page report is eating your lunch, man.
Why didn't you just say moving?
Yeah.
I don't recall.
Well, could it be that you actually did realize a person who is in a position to drive a vehicle, just simply all they
just
all
gonna
they have
answer
to do is
no.
put it in drive?
Asked and
That's the
answered,
same
argumentative.
Concern an officer must consider when they're going to use force on that person.
That would not be true because it's not the same concern driving versus in a status ready to drive. It's not.
Not the same concern, but a concern.
I've not disputed that, sir. That is significantly concerning, but not the same.
And not a sufficient concern in this case when Mr. Wright is sitting in the driver's seat.
I'm having trouble hearing the question, sir.
Not a significant enough concern for you when Mr. Wright was sitting in the driver's seat with the engine running.
I don't understand the question.
All right,
What are you asking me?
I will ask you.
Ask me a question.
If a subject is sitting in the driver's seat, their feet on the driver's side floor, hands by the steering wheel, the engine running, should an officer take those facts into consideration when deciding to deploy a taser on that individual.
Sure.
Agree.
Yes.
Isn't this particularly true if giving the verbal taser command could cause officers to let go of that individual?
It would certainly give that individual a little more time. Yes, sir.
Now, it's your opinion that if Mr. Wright had been in a position to operate that vehicle, it was not unreasonable for Officer Potter to consider a taser deployment.
Agreed.
You used specifically the word consider.
Agreed.
Well, could she have considered not to?
Did I miss anything the first 15 minutes, or was it all like this?
No, it was actually him
It's
just
your opinion, though, that Mr.
going
Wright
through a
was not
litany
in
of
a position
achievements
to operate that vehicle.
that this guy has.
It's not my opinion, sir. He could have and proved that he could drive the vehicle. He did it.
He doesn't have any line of questions. He's trying to figure stuff out on the fly now.
This is
In your
not
report,
a
you
good place
state,
to be.
In the immediate case, Mr. Wright was not operating or driving the vehicle when the taser attempt was appropriately initiated.
Correct.
So is it your opinion that he was not in a position to operate or drive that vehicle?
He was in a position to operate it. He wasn't operating it at the time. That's my opinion.
Now, again, you have all this law enforcement experience, 43 years, correct?
I do.
Several thousand police use of force cases over the past 25 years.
Correct.
Right. You've been retained as an expert in civil and criminal matters.
I have,
Asked
sir.
and answered. Like, come on.
Right.
I have, sir.
You understood immediately upon being contacted about this case that an officer had shot and killed a man, correct?
I was aware of it. Yes, sir.
And her attorneys asked you to offer an opinion regarding the police practices involved, correct?
With the primary focus on the taser. That was our discussion, but the police practices involved with a focus on the taser.
Did they limit you to just the taser question?
Objection.
Work product, the objection is sustained.
Attorney
Yeah,
work
it's
product.
May I be heard of?
Privileged.
Yes.
Actually,
Can you be
Andrew,
heard? What's the question?
we really want to hear their work product.
Yeah, we want to know what they talked about in private preparing for this case.
Andrew, we were mistaken. There was something you missed. It was elicited on cross-examination that in his time off, that he literally goes to other countries to save orphans.
You're kidding.
No,
Yeah.
I'm not kidding at all.
No, he's not. See, the like, yeah, I deal with orphans. They're like in a law enforcement capacity. He said, no, just, I was helping, save the world.
Yeah.
This guy's amazing.
Do you wear a cape when you do that?
No, just a wheelbarrow to carry my massive testicles.
Wow, this guy not only blows their witness out, he's fantastic on cross because it's just like he's not. There's nothing here that I think they've even rattled him with. It's just like
The most
everyday stuff.
rattling
He's trying-
thing. The most rattling thing they've got, in my opinion, was he was forced to disclose that there is actually a fifth criminal case that he has recently been retained for that is in the jurisdiction of Minnesota, apparently, and is also favorable towards a police officer. So rather than being a 1-3 spread, it's a 2-3 spread. But
But I don't think
that
that
was
moves the needle though.
I don't think it moves the needle, but it was. I was worried about credibility issues as that line of questioning was happening.
It's
but
an unnecessary own goal. There's no reason for that to happen. I mean,
Yeah.
come on. He knows what he's working on. I mean, you're going to be asked about that kind of thing.
Right. And so for whatever reason that they went with the 4 versus the 5, or if it was just a genuine mistake, doesn't ultimately matter, right? Because the jury hears it. It's an inconsistency thing. It goes directly to his
The objection
bias.
remains sustained.
Yeah, you're not going to get attorney work product.
So with all of this
He's trying to get ask him about the use of force.
You did not at all address the use of deadly force.
I did not, sir.
But I tell you,
Did you review Professor Stoughton's report before today?
I did, sir.
And when did you review that?
I don't recall. It would have been in the last month or so.
There was a discussion in that report about deadly force, correct?
There was, sir.
You still did not notify Ms. Potter's attorneys that you had some position on deadly force.
The objection is overruled.
I didn't feel compelled to go opinion for opinion with them. My opinions were focused primarily on the taser, and I read that, and I just didn't feel I had any compulsion to go back and say, he has this, I have that. It wasn't that kind of report. I wasn't in an argumentative process with him.
So
I
it
just had to
wasn't,
focus on the taser.
I'm sorry. So it wasn't until the testimony of Sergeant Johnson was pointed out to you that you suddenly had an opinion about deadly force.
When I was asked specifically about it, yes, sir, after I watched that testimony, that was it.
Okay. And so it was counsel that approached you about providing a deadly force opinion based on that testimony.
After the testimony last week, yes, sir.
but that's concurrent with what they said before too, that they didn't come up until this guy testified. So that
Yep.
also goes to what the defense was saying.
People are saying that he's going to testify in one of the Chauvin the other officers from the Floyd case. That he's
That'd be
been recently
interesting.
retained for that. Well, their use of force is different than Chauvin's use of force, so they have very different claims.
Especially the guy who was there for 2 weeks. Like I don't see how you get him on anything because he's literally following orders from a commanding officer. Like, yeah, I don't say you get the new guy, but
And the guy not applying any force at all, but standing there doing crowd management. 2 towels.
Counsel,
yeah.
Before testifying today, correct?
Last night he came to the hotel. Yes, sir.
And you indicated that you then had an opinion about the use of deadly force, correct?
No, it's not last night. It was whenever the testimony occurred last week. I didn't see it live. I don't recall whether it was an email or a call, but he then said, hey, I want you to watch this testimony and give an opinion concerning the use of deadly force. This sergeant has introduced this. And I mean, we talked about it last night, but that wasn't the first time.
All right.
That's exactly what he said earlier.
Is it true that all you said last night was, given Sergeant Johnson's testimony, deadly force was appropriate? Is that all you told them about your opinion?
Are you talking specifically last night in lieu of any other conversation?
Correct.
Objection privilege, what do you call this?
That is privilege, yeah.
All right. I'm going to let you go a little further.
Okay.
All right.
Hold on.
You may-
Because he
you may
didn't.
ask your question.
Is all
they
you told
didn't.
them last night,
Failure to
given
disclose.
Sergeant Johnson's testimony,
Yeah,
deadly
I think that's
Notice.
that's a correction for that.
Uh,
She's letting him wide damn.
I just don't really recall exactly. I think I would have said a lot more than that.
Your Honor, may I approach the witness?
Yes.
He's going to try and impeach him on the fact that Paul Eng's email was concise and didn't elaborate the entire conversation, I guess.
Ask you to review the last line of that, please.
Right. It looks like Mr. Ng writes, given Sergeant Johnson's testimony, deadly force was appropriate. I think he was taking notes during a couple-hour conversation. I can't speak for why he reduced it down to one sentence, but I said more than those words.
Again, if he's going for a gotcha, this isn't really it, in my opinion.
He's here to be questioned. Just question him.
Yeah, he doesn't
Yeah.
want to ask him about the deadly force because he knows the answer. He just read it. Deadly force is justified based on Officer Johnson's testimony that he was stuck in a car and afraid for his life.
Now, Sergeant Johnson did not testify about a reasonable officer in Officer Potter's position, did he?
No, sir.
So the subtotal, and we have to assume, because I don't know what happened in that couple-hour conversation.
No kidding.
Like what you're saying today is that based on Sergeant Johnson's description of where he was at the time, that's what allowed you to then now formulate this opinion about deadly force, correct?
It wasn't just that, but that was a part of it.
He wants to draw a distinction between Officer Johnson's perspective and what their expert testified about Potter's perspective.
When you were asked to do the review you did, you had full access to Sergeant Johnson's body-worn camera.
I did, yes, sir.
And you had access to the dash camera from Officer Lucky's squad car.
I did, sir.
And you had access to Officer Potter's body camera.
Correct.
And Officer Lucky's body camera.
Correct.
And you also had the written reports from those, from Lucky and Johnson.
I did, sir.
And the opinion you formed after reviewing that, based on your training and experience, was that Sergeant Johnson was leaning into the car from the passenger side.
Correct.
And today, Mr. Ng asked you to agree that Sergeant Johnson was half in and half out of the car.
I don't recall him asking me to agree to that. I mean, I've seen the sergeant's testimony. I can't tell you exactly where he was. He was probably more out than in, but he didn't ask me to agree to that.
And so this fact that you claim from Sergeant Johnson's testimony, that was the first time you thought deadly force was appropriate?
No,
Which
it was only
fact
asked
are you
about the
saying I'm
taser.
claiming?
Well, when Sergeant Johnson testified about his position,
Correct.
and that only happened here during trial. It never occurred to you before trial.
I didn't assess this from a deadly force perspective in Sergeant Johnson. As I've said, I looked at this case initially and almost exclusively from the key factor from my perspective in my initial assessment, which was the issue of taser, a decision to use, and manner of use. I wasn't looking at it from a deadly force perspective, and so I wasn't trying to opine on every facet of this entire case. The crux of the case is the issue of the taser. And that changed when I was asked. I didn't just decide to do it. I was asked, based on apparently testimony that Sergeant Johnson did, to look at that particular issue, and then I did it.
Good answer.
Yeah. That fucked him up a little bit.
Your Honor, I would like to show the witness exhibit 63. This is the body camera from Officer Johnson. And I would ask that we put that or go to the moment of 2:01:59.
Permission granted.
Or more freeze frames. Of course, it's a dynamic fight, so people are moving in and out of vehicles, and
Yeah, and he skipped past the part where he's more in the vehicle.
yep.
But it's fine. Let him explain. Yeah, his arms are still in the vehicle. He's still in sweep of the door. He's still in the zone of danger to the car.
Yeah. The car can be put in reverse.
This is a cop who just had to retire an officer who had a permanent medical injury from being dragged.
But the jury won't remember that because the answer was stricken.
Right.
You can put it up.
It's amazing how judges can do that. That was
I don't know if we need
unsaid,
to
like a
fire up the
Jedi.
thing here, or-
You got to hand crank it, Frank. It's cold outside. Get that thing moving.
At this time, you would agree that this is the time, from your review, this is the time when Officer Potter is saying she will tase him. You would agree here that Sergeant Johnson has his hands on Mr. Wright's right arm, correct?
Yes, sir.
And this was part of Sergeant Johnson's testimony the other day, correct?
It was.
This exhibit was shown and he narrated what was going on here? You saw that happening?
I recall that, yes, sir.
Then if we can run this for another second, please.
Thank
You agree that at
Very good.
2:02:00 here, we can hear Officer Potter saying taser, one of the three commands taser in the background, correct?
I think so.
And here we see Sergeant Johnson's feet on the ground and his hands holding Mr. Wright's hand.
Yes, sir.
over to the right side of the passenger side of the car?
Correct.
Clearly
He's
not
still
half
in
in
the
or
car.
half out, is he? Sergeant Johnson, I mean.
Well, I don't know how you would classify exactly half, but as I think I just testified to, probably more out than in is what I said a moment ago.
Yeah, but he's in the car. You can see he's clearly in the car.
Yeah.
And within the sweep of the doors. So doesn't change
Yes.
anything. You got to go past reverse to get to drive, right?
And even in drive, he's at risk of the car
The door
turning.
could close on him.
Yeah, the car turns, the back wheels run over his feet, drag him. Door gets closed. He gets caught in a wheel well. He moves while the car moves. Anything can happen to bring him to keep. He's in a zone of danger.
That's the case law phrase, by the way, folks, the zone of danger, because there are like police interactions with vehicles where they're not in a threatened position, and it wouldn't be appropriate.
You testified on direct that when there is a warrant, an officer has to make an arrest.
That may vary by state statute, but in my opinion, yes, sir, that's an order from the court.
Well, you told us about a Missouri statute, right? Making
I did reference my state. I'm just saying it may vary some by state, but I think that is an order from the court. Yes, sir.
I'm not disputing you that a warrant authorizes an arrest. I'm not disputing that at all.
Really?
But you said it was a mandate.
It is in my opinion. Yes, sir. I don't see anywhere on there as a suggestion. It says an officer is to arrest.
And, but in making that arrest, officers still have to use reasonable force, correct?
Certainly.
Can't just shoot somebody because they decide not to cooperate with being arrested.
And I didn't hear the question.
If an officer is going to arrest somebody on a warrant and the person pulls away, the officer can't just shoot him.
Of course not.
You were asked about how many critical incidents in your career you identified. You tried to define that term. Basically, it's a very risky situation for police officers.
I think that's fair, sir.
And others probably as well, right?
In many cases, yes, sir.
And you've been in a lot of those situations.
I have been.
And you've been with other officers involved in those situations.
I have been.
And those are life-threatening situations for you and other officers.
Many are.
Officers were there to help you in those incidents, correct?
They were.
Where are you going, Frank? What are you doing, Frank?
When you kick down a door, does it just fall over or does it explode into splinters?
You testified on direct that you got some material, but you didn't review all of it before writing your report. Is that what you
Correct.
just,
Out
just decided what you'd seen enough, or how did you decide what to review and not what to not review?
The file had voluminous medical information, which was not relevant at all to my opinions. Not that I decide I have enough. I just try to commit time and energy to things that make sense for my opinion.
And so then you also testified that a warrant for a gun violation could make an officer more alert about potential danger, correct?
It should for certain. Yes, sir.
So don't dispute that with you, but could that include something like when approaching that person, unsnapping your firearm holster to make it more accessible to you quickly?
It may for some officers based on their training and experience. For most, the answer is no, but it may.
And that warrant, you're saying, is just one thing for an officer to take into consideration, right?
Yes, sir. Just one of many.
Still have to use reasonable force in making that arrest, correct?
Yes, sir.
An officer in making that arrest could also be derelict in duty if they use unreasonable force.
Yes, sir.
You testified about, I think the terms you used were initial scuffle. Do you recall using those terms?
Yes, sir.
But it's true that nowhere in the body cam videos does it appear that Mr. Wright has assaulted any of the officers.
I didn't say he assaulted anyone, sir. I said there was a physical scuffle and he got back in the vehicle. He struggled to control.
My question for you was, did you see in anywhere of the body camera videos that Mr. Wright assaulted any of the officers at the scene?
Okay, I didn't hear that question presented that way. The answer is no.
I love how he makes it look like
You
Frank
talked
is
about
making this
body cam
difficult
videos
for the
and
jury.
perspective.
Just
of
ask the
those.
question. I'll answer it.
And you said that, a slice is helpful to show whose hand is on something, but, right, you said that a slice of that video would be helpful to show whose hand is on the shift knob, for instance, right?
That's one example of where a freeze frame is helpful. Yes, sir.
But it may not be what an officer would perceive
Correct.
or would have difficulty perceiving.
Beyond question.
But the officer whose hand it is would already know their hand is on the shift knob.
Independent of the video, they would know that. Yes, sir.
And that officer, if they are preventing that shift knob from moving, would know that that vehicle can't be moved.
At that moment, if they're effective. Yes, sir.
Wait, I thought they were in operation of the vehicle, Frank.
What is it, man?
You torpedoing your case here?
It's like they're arguing both sides of everything. So they, before closing, they'll
You
pick and
told
choose
the
which
jury
version they
that
prefer.
The
They
model
absolutely
Taser
are.
policy is one that you wrote up, correct?
I authored the 2007 iteration up to about 2018 for IACP. Yes, sir.
And did you review Brooklyn Center's Taser policy for this?
I did.
case? It's not your policy. It's not the one you wrote.
No, it's not the IACP model policy. It's their own policy.
So the standards that you applied for your definition, there were two of them, are not in the Brooklyn Center policy, correct?
They're not that exact policy. Correct.
And in fact, what the Brooklyn Center Taser policy is that Ms. Potter acknowledged receiving and was trained on every year, right? You know that, right?
Yes, sir.
She's certified every year. She had to go over the policy as part of that training. You saw that in the records.
Yes, sir.
And that Taser policy plainly says that the Taser can be used when the subject is violent or is physically resisting,
Correct.
or the subject has demonstrated by words or action an intention to be violent or physically resist and presents potential harm to officers, him or herself or others.
That's the language I recall, sir.
Different than the policy you wrote up.
It has different language, and most agencies are more restrictive or add more information than a national policy. Yes, sir.
And you would agree that it is more restrictive in the use of a Taser than your policy.
Than the national best practices policy. Yes, sir.
Why is it the national best practices policy? Why do you call it that?
Because it's from the International Association of Chiefs of Police National Policy Center, created by the largest professional police organization in America that every chief's a member of, in partnership with the U.S. government.
In which you have been a member of for how long?
Damn.
I've been a member of the organization since probably the mid 80s and served on that policy board for probably 20 years in one capacity or another.
You took issue with Professor Stoughton's explanation about probe spread, right?
I just disagreed with it.
I'm sorry, I didn't hear
I
you.
just disagreed with it based on what I know about how tasers work.
Okay. You talked about the Taser 7. And
The other guy
It's-
shouldn't have even been testifying about probe spread. He's not a
as
taser
a-
expert.
well, it's true that the Taser 7 you can order with close quarters cartridges.
You can if you choose to.
And you were telling the jurors that the Taser 7 now has a close quarters cartridge that makes it more effective close up.
It spreads further if you have that cartridge, yes, sir.
But at, of course, 1 to 2 feet, still not going to spread much, is it?
I think it's a 12-degree arc compared to the standard 3.5-degree arc.
Did you investigate at all whether the Brooklyn Center Police Department and the Taser 7 that Ms. Potter was using had a close quarters cartridge?
I did not.
Did you, Frank?
Clearly not.
I'm telling you, this witness should say, "This is MAGA country."
As he rips his shirt off and throws the podium.
Even I know the Taser comes with those alternative cartridges for greater and lesser spread. I mean, I can't believe this is a surprise to anybody. It's a Taser case.
Yeah.
Just go to their website. It'll tell you that.
It is interesting that it hasn't been brought up. Which
I'm sorry, a little bit
which
out of
cartridge
order,
that was used?
But we were talking earlier about the testimony of Sergeant Johnson. It was suddenly very
Yes, sir.
important to you.
Can you call him Major Johnson, please?
Caused you to have this new opinion about deadly force, correct?
No,
New
sir.
opinion.
I was directed to look at it and asked to consider that. It didn't cause me to do anything different.
Have you, well, let me say it this way. You have not in any way tried to assess whether a reasonable officer in Officer Potter's position would have been aware of Sergeant Johnson's position at the time she fired her handgun into Mr. Wright.
I have not.
Did they elicit his testimony on deadly force
May I
anywhere?
have just a moment, please?
On direct, did he say, yeah, she would have been authorized? Yeah, I think so. Yeah. That was his opinion since Johnson's testimony.
Right.
Okay. No further questions?
That's all I have, Your Honor. Thank you.
Paul
Hey.
Lang on redirect.
Yeah, he's lunging.
With redirect.
He
That-
leapt
that-
out of that
that-
chair.
That cross
but-
didn't really hurt you, though. That cross didn't hurt him at all. It was like a bullshit cross.
Conclusion
Oh, but
with
it
your
provided some fertile
testimony,
ground.
I gave you a hypothetical where the individual in a case like this actually sees Sergeant Johnson inside the car.
Yes, sir.
Does that change your opinion as to whether or not deadly force could have been used by that individual?
My understanding in our discussion last night and today, I was just caught off guard by reading what was handed to me, was that was what we talked about was a hypothetical.
Right.
If it's assumed an officer in this position was aware of that set of circumstances, and that was the basis for my opinion. Yes,
The
sir.
opinion was that
If that officer perceived that that fellow officer was in immediate
And she's going to testify that she perceived it.
being drugged, then the answer
Yep.
would be correct. Deadly force would be justified.
and that would be in accordance with the objective reasonable officer standard that we've talked about earlier today.
In my opinion, it would be yes. sir.
What would have happened to Sergeant Johnson or Sergeant Lucky if Mr. Wright had put his car in reverse?
Objection, Your Honor. School.
Yeah.
The
It's not out of scope.
Sustained.
Oh,
my
come
goodness. That was ridiculous.
And we met last night at the hotel where you were staying, is that correct?
Yes, sir. We,
And I asked you to review Mr. Stoughton's testimony too, is that correct?
yes, sir.
And we've gone over what the areas were that you disagreed with today, is that correct?
I believe we did, sir.
The word retained was used a couple times for you. You were not retained in this case, is that correct?
Not by my definition of retention, no, sir.
Is it a violent felony to flee a police officer by accelerating a car away from them with a passenger in it?
No objection.
Objection, scope.
The objection is sustained.
Man, she really cares about the scope of Cross on today.
Yep.
No further questions.
Any recross?
just want to make sure I understand what you're saying. What was discussed last night, first of all, is not included in that memo, that email I showed you, correct?
That 7 or 8 words reduced down, apparently, that Mr. Ring said did not capture what was talked about in the entirety. No, sir.
But what you're saying here today, telling the jurors, is if there was a hypothetical where the person knew that Sergeant Johnson was in the car.
That's exactly how I characterize it back to Mr. Ing. If it is assumed this set of facts, then my opinion would be that deadly force was justified.
So you're not offering an opinion about the actual facts of this case. You're just offering a hypothetical.
I don't know the actual facts in this case. I've not heard Officer Potter testify concerning that, so that's correct.
Have you examined other facts in the case to determine that without regard to Officer Potter's testimony?
No, sir. I don't think I understand exactly what you're asking, but the answer is no.
So, for example, you use the number of trigger pulls to reach some conclusions about whether she meant to shoot a taser or a firearm.
This is beyond the scope, by the way.
The objection is sustained.
Yeah, got to play fair. This is all beyond the
So
scope of
that's
the
an
redirect.
answer as well.
So you are telling the jury here only that it's a hypothetical, force could have been used.
I didn't hear the last part, sir.
Force could have been used. Deadly force could have been used.
If that set of hypothetical facts were assumed, yes, sir, that's my opinion.
But really the question is, regards whether a reasonable officer in the position that Officer Potter was in, correct?
Correct.
And so then I want to ask you my own hypothetical. You would agree that if an officer in Officer Potter's position was not aware that Sergeant Johnson could not have exited that vehicle, deadly force would not have been reasonable.
That would not be consistent with my hypothetical, so I agree with you, sir.
And I want to get into a battle of words, but you said retained, that would be not be your definition of the word retained. You have not accepted payment for your work, correct?
Correct.
And that's what you mean by, you wouldn't use the word retained because you're not paid?
Retention to me is contracts. When people give you a contract and say, we're paying you to do this, this, and this. I get many of those in civil cases, but for me personally, retention is a retention letter and a contract, and that doesn't exist in this case.
But what you did here was at the direction of the defense, correct?
It wasn't at their direction. It was at a specific request to assess the facts in the case specifically about the taser. And I gave them the facts from my perspective, and that was that.
Sure. And what I meant by direction was simply they told you what they wanted you to address. But I'm not saying they told you what to say, but they told you what they wanted you to evaluate. I'm trying to define retained, Your Honor.
All right, I'll let you answer that question.
My best recollection is from the initial conversation. It concerned the focus of the case was the validity of the stop and the decision to use and manner of use of the taser. That was going to be the focus of my opinions.
That's the direction you took from them.
Yes, sir.
So whether they're paying you or not, you're doing that for them. You're providing that service for them.
Correct.
That's all I have, Your Honor.
Oh man, nailing the coffin on that one.
Redirect. Okay. All right. Members of the jury,
Lunchtime.
I'm going to let you go to lunch, and we'll start up again at 1:30.
Hey, how lucky are we that this Ames guy didn't decide to go into a career of crime?
Oh my god.
Who's the bad guy from Batman with the mask? That would have been this dude.
Bane.
Bane.
Okay, you may step down. Thank you.
Would that we all at 64 have the stature of the witness, whatever his name was, James or whatever. Be able to do active duty police work. Be able to save orphans in Haiti.
Drive
Haiti-
from Missouri to Minnesota to
Good
give
afternoon,
testimony in
everyone.
court right a week after open heart surgery.
So you saved orphans in Haiti. Well, Haiti and Uganda, actually. It wasn't just the one country of orphans. I saved the orphans of multiple countries. Like, goodness gracious. So that was interesting. You know, I think the direct examination was devastating. The cross was mostly not damaging, but there were some fumble points, you know, on that, the 5 cases versus 4 just should not have happened. Frank was trying desperately to impeach the reliability of his report based on the length of the report. But,
And I think that's pointless when you have the guy in the stand to testify.
right. Because, the jury is going to, you know, they can look at the report or whatever, but they just sat there and listened to this guy very eloquently and plainly state his opinions on the case. They don't need to read a 52-page report to figure it out.
And they won't, by the way. I mean, that was a great point you made. They may look
Yeah.
at this guy's 2-page brief thing, right?
Yeah.
You might do that if you're having a dispute in deliberations. You might say, but let's take a look at this real quick. You know, you're not doing that with a 50-page report.
Well, imagine the first time a jury picks up a 52-page report and they get down to this section and says, well, according to the Supreme Court, the Graham factors in use of force and effecting arrest are as follows. It's a 5-part test that you must determine this. And the jury goes, what the hell is this? Right? Like, they're not used to reading these documents. We are. They're not. So they, you know, it's not effective to write at an academic level for a jury that's non-academic. And so, you know, the one thing to bear in mind on this guy is that he has consulted in hundreds of cases in this way, in the way that he does. And he, you know, he seems to be very effective at what he does. So,
Well, 2 things.
That's that.
I think if you want to sum up who won, because really this win is not just about today, but it's about today and yesterday, because this was really the battle of the experts the past couple of days.
Right.
If you put it in context of that, whose expert are you going to really believe and trust their opinion? And I think today the defense's expert, just on qualifications, gave them a big plus. Now, no testimony is going to be perfect, but if you plant on not only how he testified, it was clear, it was concise. The direct was very clear, straightforward. Where yesterday the direct was kind of like all over the place and was trying to, you know, get a lot of stuff in. It wasn't as clean. So if you're asking me today who won the battle of the experts, I think it's a resounding yes. The defense won this battle of the experts.
Yeah.
But again, how is the jury going to internalize it? You know, we got one guy who's been doing this for 43 years, and we had one guy who did it for 5 years and then he went to become an academic. So that's really what you're talking about here. You know, who's the jury going to rely on for an expert opinion? And I would personally rely on this guy versus who the prosecution put up.
Well,
Yeah,
in fairness, I think Stoughton also goes to foreign countries for children.
The other,
I'll be back.
the other
I'm gonna eat. I'll be right back. I'm gonna eat because I don't want to eat on camera. Because I'm loving
Sure.
this stuff, and people are like, "Maybe eating." I'll be back.
The other issue that they've got is the prosecution's expert witness was asked, have you ever done these trainings? Have you trained anybody on this stuff? And he said, well, I'm certified. You know, I'm certified trainer. He said, have you trained any officers on use of force? No. This guy, contrary to that, has trained thousands and thousands of officers. He's written the training materials. He's written the policies. It was kind of like the state's taser expert prior to the use of force expert. This is a guy who wrote the department policy on tasers. He's the guy who did the training, and he's testifying in favor of Potter. The only guy who's testified against Kim Potter's use of, or perceived use of a taser, the only guy to do so is the Weasley guy with basically no practical experience, doesn't train anybody, hasn't written any manuals, but he writes papers on police use of force, and he writes them almost exclusively against any use of force.
Right. And it wasn't even an honest no when he was asked, has he trained anybody? It was like, well, I have certifications.
Right.
Well, that turns out to mean he took courses from other trainers in use of force. He's not a trainer himself. I've written reports on use of force events. Oh, I've written policy on, meaning he typed someone's policy, this probably Lexpol into a computer or something. It wasn't until you got past all that BS that he finally was compelled to concede, well, no, I've never actually trained anybody in use of force.
Right. Because, and first of all, why would that guy train anybody in use of force? I mean, from stature to demeanor to experience, he doesn't possess any of the perceived qualifications for training use of force. I mean, he doesn't come across as a use of force guy at all. He comes across weaselly, small, weak. He comes across as an academic, frankly, like the stereotypical academic. And whereas this guy is sitting there on the stand, he talks like a police officer. He speaks respectfully. He speaks clearly, and he's also got the stature and presence of someone who has actually, quote, seen some shit, right? Were you there for when he explained his induction into the Police Officers Hall of Fame?
No.
Okay, so Frank asked him about that. He says, "Oh, you were inducted into the Police Officers Hall of Fame," and he said, "Yes, sir." And he said, "That must have been nice or whatever." And he says, "Not under the circumstances which it occurred." He said, "Well, what do you mean by that?" And he's like, "Well, it was use of deadly force, and I didn't ask for that award." So he had to use deadly force. He expressed that, he was not reveling in the fact that he used deadly force, and he was inducted to the Hall of Fame because of it. He's like, under other circumstances, he would have been happy about it, but under this one, it wasn't. So here he is given this high honor accolade, and he's like, I really would have preferred not to have it for that, for anything else in my career but that.
And obviously his use of deadly force was lawful, right? Or we wouldn't be talking about it, which means it was in defense of innocent life. So he killed someone to save a human life and got an award for it, and he still wishes it hadn't happened.
Right. And that's the important distinction and failing of the state's case here with Kim Potter, in my opinion, she shows immediate remorse for what happened. And it looks for the world that she did not want to do this, but they have to make the case that she was so callously disregarding the risk to human life that she would do that she would cause the death of another based on her conscious disregard of the risk to the other. And that just doesn't manifest in the facts, but it also doesn't manifest in her reactions. And I think that's a critical psychological element to this. I mean, always a post-fact reaction cannot be determinative of the actual state of mind at the time the act was done, because a lot of people are sorry that they murder someone. That doesn't negate it, but it just goes to the overall mental perception of this case. And I'll bring it back to Chauvin. A big problem that Chauvin was going to have from the very start is a video where he's kneeling on a guy past the time where he stops moving. Whether you think that's justified or not, or that his actions are justified or not, or that he was railroaded, all of that is irrelevant. Yeah, it's all irrelevant to the jury who watches him kneel, basically deadpan face, expressionless for 3 minutes on a guy who has stopped moving. And with Kim Potter, it's the opposite perception. And we're seeing that in the way that other officers are willing to testify on her behalf over and over and over again. They have no qualms about representing that she was a good cop, that she maybe made a mistake, but that there was nothing inherently wrong in her actions other than the mistake that was made. So that I think that matters a lot in the eyes of the jury. And I think when we get when we get the testimony about it from her, I think it'll be very interesting to see how they work that out.
It all comes still back down to this recklessness. It's such a desperate overreach of the prosecution here. You have to have consciously disregarded a risk known to you or violated some legal duty explicitly. And none of that happened here. I mean,
Right.
the state's theory is basically, well, she reached for any weapon. She thought she was reaching for any weapon, meaning the taser. And that opens the door to all the possible downstream consequences of making any kind of mistake moving forward. She didn't consciously disregard the risk of having a gun in her hand, which is what was the cause of death.
Right. Yeah, and the state's theory is predicated on the idea that no use of force was reasonable. That none of the use of force options presented were reasonable. But they haven't presented an alternative. And while you don't have to present an alternative, and I'll take this from sort of a criminal defense appellate perspective, you're not required to prove that somebody else did the murder that your client was wrongfully convicted for. But it sure as hell helps if you can give the court a theory that there is actually someone else out there that is identifiable by some evidence to say, my client didn't do it. It's obvious that this guy did it.
Right.
Like that's not part of the appellate review. But if you put that in the appellate review and credibly do so, you increase your odds of getting a conviction overturned forever. Here, the state has presented no alternative theory for what she should have done because they're hesitant to say she should have let him go because everybody looks at that and goes, there's no way you can let this guy go. They wouldn't let me go. And if the police officers let anyone go who tried to leave, we wouldn't have a police force that did anything at all. So they can't take that position. But that is their ultimate position, is that they should have just let Daunte Wright drive off by virtue of him not wanting to be arrested. And that sets a really dangerous precedent. And of course, they prosecute people who do stuff like that all the time, and they prosecute them severely. And there's no consistency in that opinion versus their everyday practice. And the jury knows that too, right? Jury knows if they run away, they're going to get tased. They're going to get tased. They're going to get knocked down. They're going to get potentially shot. And the jury may actually even fear that from cops, even if they think that that's the wrong thing. And they're going to look at this and go, well, I mean, I'm afraid of getting shot by police, but they should have let Daunte Wright go, especially with what they know about his immediate criminal issues. But yeah, so the state's still, I mean, they're facing an uphill case here, and the facts have just not played out in the way that their, I'll say, knee-jerk charging played out or anticipated.
Yeah, and folks, just to be clear, because I see some comments that I think are a little unclear about how I approach these cases, and to be very clear, I don't predict legal outcomes. So I sometimes see people comment, "Oh, Andrew called this trial right or that trial right," because what I thought was the stronger legal argument was consistent with the verdict. I never predict verdicts because juries are dangerous and unpredictable creatures.
Mm-hmm.
What I do is try to evaluate the strength of the competing legal arguments to a reasonable degree of legal certainty. That's, in my opinion, what the verdict should be. What it's going to be, I don't know. And I always start in criminal cases, which is largely my focus, from the presumption that the defendant's innocent, which is what we're supposed to presume. And the state has to prove them guilty beyond a reasonable doubt. So every day I'm looking for the state to advance that argument, because if they don't hit that threshold, it's supposed to be an acquittal.
Right.
And when I see a case like this, they get up, the state finally arrests. I don't see a compelling argument for guilt on these charges beyond a reasonable doubt. And now the defense presents this expert witness who, let's face it, completely dominated the state's expert witness. And as Ang pointed out this morning, most of the state's other testimony was fluff. It was DNA analysis. It was ballistics. It was car crash.
Yeah. All irrelevant to the question of whether or not Kim Potter committed manslaughter against Daunte Wright. That's the thing. I mean, the car crash, they basically made the argument that the car crash is relative as a consequence of her actions, but they didn't charge her for the consequences of her actions against the people in the car. And they could have. Like we discussed the other day, reckless endangerment is something that they could try and pursue that theory if they thought they could prove it, but they didn't charge that out. So all of that by the state's election becomes reckless. And that's the most important thing to remember when looking at criminal defense cases is that the state is in charge of all of this. That's why they have the burden. But with that burden comes the benefit and the burden of directing the case. The state is in charge of how they prosecute it. And if the state inadequately prosecutes it, as we saw this morning, the defense can make a motion for a judgment of acquittal.
And all this stuff about the car crash, she should have known that if she used any force on him, he's in a position to operate the car might become a missile, blah, 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 blah. Unless there's evidence she was thinking that and disregarded that risk intentionally, that's not recklessness, folks. If we're just saying, well, a reasonable person would have known that was a risk, that's negligence. That's not recklessness.
Right. And the culpable negligence is gross negligence plus recklessness. That's what's in the statute. That's how the Minnesota State Supreme Court has ruled that this should happen. And frankly, that is the criminal negligence standard basically everywhere when you really get down to it, because we don't prosecute people and take away their liberty for aloofness. We prosecute people and take away their liberty for having what's called the mens rea is the Latin for it, but the criminal mindset or the criminal intent has to be manifested. And in only very rare and narrow statute specific circumstances is mens rea ignored. Stuff like possession of illicit pictures of children, stuff like statutory rape. Yeah, statutory rape. That's where the mens rea is ignored.
And it's very explicit. Now, there is a second way to get to recklessness, and that is if she had violated a legal duty. If there was, like the Taser policy, it said absolutely under no conditions ever use this on someone who's sitting inside a vehicle, and she had been trained on that, then arguably the state would have a path to recklessness from there. But all these Taser policies are guidelines. We recommend you don't do this unless you have a really good reason. And of course, she's going to argue, I had a really good reason. Myself and those officers and the woman in the car were all prospectively at risk.
Mm-hmm. Exactly. And that's the overlooked person in all of this is the passenger in the car. If Dante Wright escapes and takes off at anything greater than a reasonable speed and decides to ignore the stop sign that's coming up in half a block, he has put himself, the community, and his passenger at considerable risk, even if the officers are not.
Plus, they know about the order of protection, right? For all we know, this is that woman. This is a kidnapping. She's in danger.
Mm-hmm. Absolutely. So it's, again, from the legal side of this, I'm not seeing the state's case manifesting. I'm not seeing them proving their case out, certainly not beyond a reasonable doubt. And we should be watching the defense pull layups until the case is over. I mean, that should be it. It should be a matter of course at this point. They're ahead by a significant amount after the state's testimony, and it's theirs to lose. There's some risk in putting Kim Potter on the stand. I don't think that risk is all that risky in this case, but I mean, she certainly could get up there and start saying some wild stuff. Like if she gets up there and says, well, I've always hated black people. I mean, that's going to sink her case in a moment, but I don't think that's likely in this scenario. So we'll see how it goes.
It makes you nervous because you lose all control once you put her on that witness stand. So
Right. And if there is something in her past that somehow she didn't disclose to her attorneys and they were not able to turn up on the investigation into her background, but the state was able to come up with, or the state is able to appropriately spin, if she does have some use of force disciplinary actions in her past that could come out based on her testimony, that would be a significant factor in what happens going forward. But again, we can reasonably assume she has competent counsel. She seems to have glowing recommendations from her other officers. We reasonably assume that's probably not the case, but it is always possible. Brad Hobbs says, theory, she was processing 2 ingrained programs mentally at once, to use the taser and reacting to the deadly threat to Johnson and Lucky, so quasi-consciously followed grabbing the gun in accordance with that assessment. Now, we do have an expert who's going to talk about this. It's an expert on something called slip and capture, And that slip and capture is entirely around the mistaken use of force or grabbing the wrong gun, doing something under pressure that is adverse to training, adverse to your conscious decisions. And I think the multiple mental angle you're talking about is perhaps part of it, but I think a really big part of it is the fact that it's a high intensity situation and her left hand is occupied. I mean, frankly, I think we're going to hear significant testimony about the fact that in her left hand is a thing, which her brain then will automatically under pressure say she's not able to grab the thing with her left hand because there's already something in her left hand. And so she's going to reflexively move to her dominant hand. And I would be very surprised if that's not part of that expert's testimony. Because
listen,
that's just
I've had that
how it works.
experience personally under much lower pressure situations. So I spent many, many years shooting pistols competitively. A lot of times you go to training classes and you might have been doing something a particular way for 10 years or 12 years, magazine changes, for example, in a handgun. And you go to take a class because you've heard about an instructor who sounds pretty cool. And he has slightly different ways of doing things. He likes to do magazine changes a different way. Let's call it method B. So you go there to learn how to do that. And then he starts running you under stress drills. And I can tell you, man, you might have spent 2 days doing nothing but method B magazine changes, but you get under pressure and you immediately revert to the way you did it for the last 10 years. That's just the way your brain works.
Yep. That's how it works. There are other simple things that get missed too by experts. And they usually wind up in a funny video on YouTube. There's a video of a police officer talking to students in front of a high school classroom, and he goes to holster his gun. He ends up shooting himself like in the leg or whatever, because he forgot to redo the safety and accidentally trigger pulls on holstering. And then, boom. This is a guy who works with a gun, trains with a gun constantly, would never consider shooting himself in the leg as a reasonable outcome. And yet he does. He's in an environment that's slightly different than what he's used to. He's talking in front of a classroom of high schoolers. These types of accidents where your brain just short circuits from what you would do to either reverting to an earlier sort of programming as you're talking about, or to simply skipping a step or omitting a critical element of what you do because you get distracted. That happens all the time. For me, it happens when I get a phone call and I'm in the car, and I will immediately start, like if I'm driving into town, I will immediately drive to where my office was located. I'll just start taking those roads no matter where I'm going in town, because I'm on the phone and I'm thinking about something else. So my body goes into this muscle memory thing. But yeah.
So when we moved into our current home, we moved here from another house that was only about a mile away. And I can't tell you how many times I drove to that other house after the move and found myself pulling into the driveway.
Yep. That's how that's how our brains work, for better or worse. And it's rare that ends. Actually, it's probably not that rare that it ends up causing harm, but it's rare that it manifests in a police officer pulling a taser rather than a gun. But it's not out of the scope of possibility at all.
And by the way, while we're in lunch, I saw someone asking about the my upcoming lawselfdefense.com class. Folks, this is the Law Self-Defense Advanced class. It's a full day class on self-defense law. It's the equivalent of a law school seminar on self-defense law. Law schools taught this stuff at that level, which unfortunately they don't. It's the same course we teach for CLE for lawyers, defense lawyers, prosecutors, judges. Lots of law enforcement come, but we teach it in plain English, so it's perfectly appropriate for everybody. We only teach this class about once every year and a half. And we're teaching one soon, Saturday, January 8th. So if this is of interest, now would be the time to do it, or it's a year and a half wait. We do still have seats available, but they are going fast. So I would encourage you, if a mastery of self-defense law is of interest to you, this would be the opportunity to acquire that in a single day. It is taught live by me over Zoom. That's you can get more information about that at lawofselfdefense.com/advanced. So grab it before it's full. Once it's full, it'll be a year or a year and a half before we do this again.
And as a minor co-plug to that, let me just suggest that if you take this January 8th class, there is the real possibility that it will be attended by Thomas Claire Binger and James Krause, the attorneys in the Rittenhouse case.
They are both registered.
They are both registered attendees of the class, and so it is possible you will be on a Zoom call with them in taking this class. And so if that's something that is interesting to you and helps you make that consideration, I mean, what other class can you get that level of celebrity on self-defense put into it? None other than Andrew's class here. So
Somebody just commented that Krause actually needs 2 seats in the class.
It's got 2 cameras, half of his body in one and half in the other. Oh my gosh. 615 Bass says, hate to break it to you, Nick, but you're actually 41. Lol, your birthday marked the end of your 40th year. Now you're working on your 41st. Happy birthday, buddy. But I love you and what you guys do. Keep up the amazing hustle. Hey, thank you. Thank you very much. Next, we have Colby Kidd says, why are his shoulders inflating inside that suit coat? Or are you talking about this guy?
It's a superpower.
Someone said he had the Krause tidal wave. I don't think so. I think that's actually the suit fibers recoiling from the weight of the world that has been put on this man's shoulders. The burden of duty is heavy. Jessica Bird says, I think the new meaning of ASMR in this chat is always simping mommy Regina. Yes, I think so too. Celtic Commando Gaming says, in practice, would an attorney ever cut their cross short if they were being demolished like Frankie is? Also, happy birthday to you and happy belated birthday to Andrew. I mean, yeah.
Yeah, sometimes you have to cut your losses. I mean,
I don't know that what was happening on the stand was exactly Frank losing that bad. He certainly looked flustered. He wasn't getting the information he really wanted to get, but he wasn't getting absolutely destroyed on cross. And so I would say what happened to Binger and Krause on, well, was that on cross for them? Some of the big moments for them were actually on direct, I guess. But those types of destructions where you have Gage spoiling your entire case, but that happened on cross for the other side. Those could be it. But yes, I mean, if you're getting, you're in control of the questioning. That was the funny thing where Frank's like, we're spending an inordinate amount of time. Oh yeah, that happened, I think, before you were back on. It's like, we're spending a whole lot of time on this question. And it's like, you're asking the questions. Like,
the guy does 3-hour directs.
Yeah, you don't have to spend any time on any of this if you don't want to. You're asking the questions. And
yeah, I saw that part of the cross.
Oh, okay. Yeah. This is just Mike the Dad Crosby says answers are easy when you're being truthful. Chain Breaking Sage says, you beautiful saint of a man, is it true that you're destroying my case? Happy birthday and love the show. And that's the other funny thing about this. When these trials involving a police officer are so awkward for the state, because in all other cases, they're arguing in favor of the state's activities, right? Like normally you're going to come up with this as someone in the middle of a case trying to use the officer's unreasonable use of force as justification for something, for having a case dismissed or whatever. And they're going to be typically in favor of the use of force by a police officer. If Dante Wright had been arrested after Kim Potter tasered him, they would absolutely support her use of the taser in this scenario. There's no question that Matthew Frank's not going to get Dante Wright there and be like, oh, well, actually her use of force against Dante Wright and deploying a taser was objectively unreasonable. And therefore, he should be let go because his constitutional rights were violated. And I'm actually going to charge her with excessive force. No way in hell that happens. This entire team of prosecutors would fully support her use of force of a taser, even though they've just brought an expert to say it was unreasonable.
Now it reminds me of the Freddie Gray trial in Baltimore, where they arrest Freddie Gray, throw him in the back of the van, and then he arrives at the hospital with a broken neck, dies a few days later, and they charge 6 officers with murders, with crimes as serious as murder in that case, even though there's zero evidence that any of them used any excessive force, ever touched his neck. All the facts suggested that he was cuffed in the back of the van, stood up in the van slowed down or stopped for a stop sign or something, and he fell forward and hit his head on the bulkhead of the the passenger compartment, broke his neck that way. But one of the reasons they had for arresting him, the probable cause, was they found a pocket knife, an assisted opening pocket knife in his pocket. And that's unlawful under at least Baltimore city ordinance. And of course, these cops are now being prosecuted by the state's attorney, and the state's attorney is mocking the notion that there was probable cause to arrest Freddie Gray because he had a assisted opening knife in his pocket. Her office routinely prosecutes people for being in possession of a assisted opening knife until it's inconvenient for the case she wants to bring, and then it's an inconsequential offense that shouldn't warrant arrest.
Yeah, and the backwards notion of these prosecutions and how they work out, especially when they're probably justified, right? Like as you've gotten this Kim Potter case, it's different if there's a rogue cop who goes up and shoots someone in the face or who kills his ex-wife or something. You see something like that. That's a whole different case. But an officer involved in a use of force question in the line of duty just comes as strikingly disparate from their normal practice. And it's like in any other event, this Stephen I. James guy is a hero for prosecutors like Matthew Frank. I mean, he's exactly who the state would want. And that's why he has 3 criminal cases right now where he's testifying on behalf of the state against other officers, because he seems to be a completely upstanding officer of excellent training, good service record, and committed to doing his duty effectively. He comes across as like, if you're writing a story about a bygone era of officers, right? When you think about current day officers leaving a precinct or whatever because of riots or what, you can't imagine that this guy would be in support of any of that stuff. That this guy would say, yes, we should surrender our city because there are people demanding different behavior from us. You picture this guy as the guy who would do his duty no matter what.
Right. When Kenosha's on fire, they need to put up the Imes light on the clouds.
Right. He comes in with just a riot shield in one hand, a baton in the other. He says, time to clean the streets.
I'm here to kick ass and chew gum, and I'm out of gum.
Lieutenant Heavy Metal says, if Stephen I. James testified that he had beers with God himself last week, I'd believe him. But yeah, he comes across extremely credibly. Mike the Dad Crosby says, vehicular homicide is a thing because a vehicle can be a deadly weapon when operated. If he'd been stopped for jaywalking and reached down to pick up an axe on the ground, would you let him run off? Depends on the axe, I suppose, and the circumstances.
Depends on ability, opportunity, and jeopardy.
Yeah.
Is he presenting as someone who intends to use that axe in an unlawful manner?
Right.
If so, yeah, then he's committing a crime. He's committing assault or threatening.
If he's a guy jaywalking after leaving a hardware store and he dropped his axe and turns around to pick it up when you say, hey, you're jaywalking, and then he runs off, I don't think you can shoot that guy. But it's all about that. Like, why is there an axe on the ground? Why is he grabbing it? Is he threatening? Are there other people immediately in the vicinity? Do you have knowledge that he's got an order for protection, right? Like if there's a protective order against him and he's grabbing an axe.
You think when they did Ames open heart surgery, they had like a RoboCop suit there on the side just in case the surgery didn't go well? They just shove him into that suit.
We'll inter you. Your service can continue, brother. I imagine actually instead of anesthesia, what they did was they just had a video on loop of use of force encounters, and he just focused heavily and deeply meditated on those while they did his open heart surgery. Mike the Dad Crosby.
We're just going to use a local for you, sir.
He also says, I'd suggest to the trolls in chat to go shout outside the courtroom with your buddies and leave the chat alone. Ray K says, happy birthday, Nick. Found you through the comment section of the conservativetreehouse.com during Rittenhouse. Watching ever since. Loved your state versus compelled action rant last night. Please, please, please clip it. I think if it hasn't been clipped, I think my editor is working on clipping it. I know that there's a new video for me to upload from him, so I have to check it out. I'm not sure if it's that clip specifically, but yeah, that was good stuff. By the way, F the state. there's my ultimate conclusion of that. If you need a summary, F the state, screw them. But yeah. So all right. What I think that's the super chats I have to get to right away. Oh, except there were some on Odyssey. Let me check on those real quick. Yes. Neff says, happy birthday, Rackets. I'll have some bookers for you over here. Ooh, thank you. Thank you. Enjoy. Radicalized Ryan says, happy birthday, Nick. Thank you. Mark Gee says, man, this expert witness is making me feel like a lazy bum. Yeah, that was as they were going through his CV. He's just like, so you spoke, and he went month by month. In January of 2002, you spoke at a police officers union in Canada. Yeah. And then in February of 2002, you were in Britain. Yes.
It's just so, he's like the Alexander the Great of law enforcement, except he didn't die young. He's still going.
Yeah. It's like it keeps going through, and it's like, Frank, you're raising the accolades to this man. Every law enforcement center in the entire planet, at like Tunisia, Tanzania, whatever, all of them apparently want to have this guy come speak because he's so well regarded. You're sitting here just showing the jury that it was very. We couldn't really figure out why specifically he was doing that, but maybe it was to show bias, I guess, was the idea.
Yeah, that's right.
You're biased towards cops, but it came across very hollow because you're training the cops. And this is training is not a bias. Training is a desire for those people to act reasonably, to act in the appropriate way, and to try and instill that into them. So, I think that failed spectacularly.
Somebody asked about the red book over my shoulder. I guess it's this shoulder. I can't figure the camera out. That's not the Communist Manifesto,
got a fist
folks.
on it.
That's a novel called Control Alt Delete by the author Nick Cole. I'm a big Nick Cole fan. Check him out. I don't get anything from this except I like him. NickCole.
Sure. You check out that book called #Resist by Nicole on Andrew's shelf there. And yeah, it's with the forward written by BLM and Ben Crumb. I'm guessing. No, I'm just kidding. It is funny because it is like a giant red book with the resist fist on the cover. It's like, what are you reading back there in your time off? But yeah. So I'll read some of these other super chats as we're waiting. We are on break. We'll be on break for another probably 15 to 20 minutes before before Mommy Judge comes back and allows everybody back into the courtroom.
Probably more.
You think?
I thought we broke about 33 minutes ago. It usually takes an hour or a little more for lunch.
Okay, I thought we broke a little earlier than that. I thought we broke around 12:15, but I'm very likely incorrect.
I can't swear to it. Sorry.
So, isn't it true that you don't know when we broke for lunch?
That is true.
Wouldn't you agree that you have no knowledge of clocks? Yeah, no, we'll see. I wonder if they're gonna now coast into the character witnesses that they have, or if they're gonna go straight for the next use of force or the next expert.
I would do the whatever they call that, slip and catch, or
yeah.
I would back up this testimony with his testimony, then go to the character stuff, then Kim, and then close. Yeah,
it really shouldn't be long. It should be 2 days, 2.5 days most on these witnesses. This witness took a little longer, but it's really up to the prosecution. The defense's direct examination was relatively concise. They got what they wanted out of him. But the state took a long time on cross, as they're going to, and on Kim Potter, that's where they're going to spend probably the most time on cross. Really just try and punish her for taking the stand. And fish for anything they can get. But
that's their last gasp opportunity, right? To try to get something decisive.
Yeah, and I think having Kim testify last is, if you're going to have her go, it's probably a good idea. Finish it up. Unless they want to. Oh wait, they do have the police chief, who's
Gannon, right?
Right. And I think they have they may have another fact witness. I'm not
They had
sure.
Johnson on their list. Are they
Yeah,
going to
they-
recall Johnson?
They had Lucky and Johnson. I don't know that they need to. Personally, I don't see that it would be overly beneficial to give the state the opportunity to cross and re-impeach their own witness. But I just don't see the benefit. They got what they wanted out of him. They got what they wanted out of basically all of the state's witnesses that were favorable to Kim. So, but they could recall them. Yeah. Tall Skinny Geek says that singing was almost cringe. So close to the line. Big Irish Jim says, so according to the expert, the car wasn't about to move, so Johnson wasn't in danger, but the taser wasn't appropriate because the car could move. Yeah, that's what the state's expert argued.
Right.
Which again makes no sense. If the car is not in motion, then a taser is appropriate to effect arrest. And if the car has the potential to be in motion, taser or deadly force is appropriate at that point. Because the interesting difference here is that, and I think this is a difference between. I hate to always go back to this, but Chad Reed and Kyle Kareth, right? In your opinion, in the Kyle Kareth Chad Reed situation, the danger has occurred and then ended. And in the Kim Potter situation, even though the amounts of time between the events, between the danger and the shooting are similar, in the Potter situation, the danger is still manifestly present. It hasn't actually materialized.
And other
so-
people are being threatened. There
Right.
hasn't been an abrupt increase in distance from an unarmed person who's not in a car they're about to operate, doesn't have a woman in the seat with them who may be the subject of a restraining order. I mean, the facts are just distinguishable between those two cases in an almost infinite number of ways.
Right. But some people brought up in my chat last night that they're close in time, right? Kim
Sure.
Potter is firing within about a second of the danger question and being potential to manifest. And then in Kyle and Chad Reed, he fires within a second after the danger is over. And so you've got, but you have even ignoring everything else, you have a very distinct difference there. In one, the danger is ended. The other, the danger is still potential. If she doesn't pull that trigger right now, there's still the potential that he will shift that car into drive and put the police officers at significant risk.
If Johnson's hand slips off the gear shift, that's it. The car's gone.
Right. And so that danger, the state is trying to walk the line that the danger hasn't actually manifested. Therefore, the deadly force isn't warranted. But they're also saying that once the danger does manifest, the deadly force can't be warranted either because it is now a moving vehicle, which is completely untrue, by the way. Officers fire into moving vehicles all the time and do so justifiably. It's recommended against it. It sometimes goes against training, but as I think this guy testified, and as the Taser guy testified, and others have testified, it's all up to the officer's totality of the circumstances. If there's a guy driving towards a bunch of school children going in a crosswalk, and he's fleeing the police or whatever, and they think they have a shot on that guy to maybe get him to stop driving, they're going to probably take the shot to try and get him to not run over the school children.
Yep.
And you'll see that a lot. In fact, they'll even take shots into a car when they're trying to protect the person in the car from the danger that the driver is posing. And those are often justified shootings, even though they go against the general policy, because police work can't be summarized into a general policy. B.A. Krim says, can we get the judge to sing for you instead of uncivil? Also, another important person growing 1 year older, my wife. Happy birthday to both you and my wife. Hey, B.A. Krim, happy birthday to her. I hope you guys have a wonderful day. Generations Woodcraft says, got my LSAT study guide and looking to go to law school so I can fight the fight. Once the state shows you who they are, believe them. That's scary. Linfinity, well, good luck with that, buddy. Linfinity says, happy birthday for some Earl Grey tea. Thank you. Nicholas Burns says, happy birthday, you beautiful bastard. Matthew Self says, happy birthday. Luke Pearson says, maybe they chose to limit cross so they could get the professor off the stand early and begin their case in chief first thing today without the sympathetic witness like Dante's dad prefacing it. Yeah, that is possible. Again, while I think they could have elicited more on cross of the state's expert, I don't know that it would have done them much good. They did enough to make him look weaselly on the stand.
And they know they have this guy coming.
Right. James G says, happy birthday. Could you explain the no speaking objections? Wouldn't the lawyer need to state the reason for the objection for the judge to rule? Is this common? It's up to the judges entirely in how they run their courtrooms. But the no speaking objections just means you make your objection, and this judge seems to want a one-word explanation. Objection, hearsay. Objection, irrelevant. Objection, lack of foundation. One word.
What they really mean is that they don't want an arguing objection. They don't want an objection with a lengthy reason why, because that's essentially a kind of testimony in front of the jury, right?
Right.
So you give your one-word reason or two-word reason, whatever the minimal is that you need to communicate to the judge why you're objecting. She knows what hearsay is. She knows what outside the scope is. The other party, whatever. I mean, everybody knows what they're talking about. Most of the time, I mean, there are circumstances in which an objection can get complicated and you do kind of need to explain it. But if you let lawyers get away with it, they'll explain every objection because it's just their chance to get more of their view, their perspective in front of the jury.
Yeah. And think about this way. So the expert witness is up on being examined by the state, right? And the defense objects to what he says. And you have two options. The defense says objection, foundation, or objection. This guy doesn't know anything about what he's talking about. One of those being heard by the jury is specifically intended to discredit the witness's knowledge or experience, which can be influential on the jury listening to that opinion and subsequent opinions. Whereas the objection to lack of foundation says the same thing. You haven't established that this guy knows this, and that's what the lawyers and the judge know, but that doesn't clearly communicate that to the jury in a prejudicial way. And then if you need to go and say this guy doesn't know anything, that's when they put on the headphones and the headset and they make arguments over the law. This guy doesn't know what he's talking about. They've not qualified him on this. Right. And that's how she wants it handled. Not all judges do it that way. Most of the hearings that I've been to here in small town Minnesota, the judges want you to object, and then they ask you for a short explanation of the objection. They don't say one word objections, but they ask for basically a speaking objection. But I'm not prosecuting cases like this or defending cases like this. So that's just my experience. But it is common to see that because you don't want a lawyer testifying about a witness to prejudice a jury. Free Matter for the Blind says, did you see the Project Veritas's video today? No. I woke up and immediately got on the show. Another CNN producer wants to do illegal things to his own stepdaughter. Gross. Very, very gross. Drew says, your editor, ? You pretentious dick. Happy birthday. Yeah, well, I was trying to produce all the videos myself, and I just could not keep up. I couldn't keep up with my own production. So I have finally outsourced some of that. And I hope you guys are liking the videos that he's putting together. I think they're swell. Colin Archer says, happy birthday, Nikki. Wish you all the best and hope you will be as badass as L. James is Iams. Iams, I think is his name. Iams is at 64. Also, check Twitter DMs. I'll get to it eventually. Don Pedro says, Bronca, if we take the course, the state will use it against us because we should have known the law. But if we don't take the course, we are ignorant of the law. Bottom line, we should all take the course to understand the law.
Yeah, I get that sometimes. If I take your course, can it be used against me in court? Well, folks, the answer is yes. Anything can be used against you in court. The prosecutor might talk about that. But the bottom line is, so what's the alternative? To stay ignorant of what the legal boundaries are? Because I can assure you, if you are ignorant of the law and you violate it, well, as they say, that's no excuse. Nobody cares.
Right. The question is not whether you specifically know the law. The question is, do you have the opportunity to understand the law intelligibly as a reasonable person? We saw this in the Rittenhouse case again, with the judge eventually saying, how is a normal human being supposed to understand this law? The statutes are presumed to be reasonably written, and that's how they're upheld. That statute, the judge was suggesting, was a little more complicated than that. But typically speaking, you're supposed to be able to pick up a statute, read it, and go, okay, I know how to comply with this. Whether or not you've done that is irrelevant. Nathaniel Hyde says in Mark Richards' voice, Your Honor, it's my birthday and I object to being 40. Your Honor, going to need a ruling on that one. Raptor C1LL says, happy birthday. Hey, thank you. Thank you. Very much appreciated. Leon McGilcuddy says, happy birthday. This has become one of my favorite channels. Mystery Law Theater 3000 vibe. When the panel is on, I learn something every day. You can learn new insults and curse words if you watch the nighttime show as well. It's perfect.
Hey, Nick, I just had somebody ask in the comments, isn't the law, self-defense law, different in every state? And the answer is kind of yes and no. So, of course, every state has their own statutes and case law and jury instructions, but the underlying legal principles are essentially the same across all 50 states. The biggest variance is whether it's a state that imposes a legal duty to retreat. There's only 11 of those. That's for defense of persons, defense of yourself, and defense of others. There's a lot of variance in defense of property. It's a completely different space. We cover all of that in the course. And when we get to an area where there's substantive difference among the states, I'll point out the states that fall into each of the relevant buckets. So that's why we say the course covers all 50 states.
So there you go. But yeah, and that's critical. The way statutes are worded can typically add some privilege to various states, right? You can add this idea of privilege, or you can limit a particular privilege that is kind of presumed. But the underlying principles of self-defense is the objectively reasonable person in reasonable fear of imminent death or bodily harm, and then the follow-up is subjectively is the person in that situation in the same fear of imminent death or bodily harm. And that's the underlying principle of self-defense law. And the rest of it is various spices and flavors that get added in.
And if you're prudent, which is what we suggest you be, and you stay well within the legal boundaries, then those spices and salts shouldn't make any difference to your case.
Right. Yeah, and that's another aspect of these cases, and really all. You can always be technically within the law. You never want to be technically within the law in front of a jury. Right. That's not where you want to end up, because juries are not lawyers or judges, and so being technically within the law, you may be right, but they don't have to agree with you, and spending 6 figures to explain how you're technically right, even though other people are opposed to you, is not a fun place to be. So, and that's the value of a class like Andrew's, is it teaches you how to be well within the law, know your rights, act appropriately. Same thing when you take a concealed carry class, and they're like, only draw your gun if you intend to shoot it. Never just draw it and wave it around. Don't threaten people with it. Don't do anything like that. And ultimately, the main advice that they give you is, if you have any opportunity to leave the situation, leave the situation. Don't be the tough guy. Don't be the hero, because that's not the best legal advice for use of force. Now, I mean, sometimes you might be compelled to defend someone else, but if you have an opportunity to safely leaving is your best defense.
There aren't many things that are worse than being a felony defendant in front of a jury, folks. That's a very, very bad place to be. There are things that are worse, but there's not many of them.
BG Willia says, just to say how beautiful, how brilliant, how wonderful you are. Wait, you're not Andrew. But here's something for black balloons and candles for your 40th, you old crotch. Oh, thank you. Eugene says, Lordy, look who's 40. By the way, what's the actual legal difference between shall and should in the United States? I was under an impression shall is not a thing in American legal language, i.e. Brits would use shall and Americans use must. No, shall is occasionally used. It is synonymous with must. Should is not synonymous with shall. Should is lesser. Should is a suggestion. Shall is a command. So may and must would be comparable to should and shall, respectively. An officer may do this, or they must do this. But yeah,
I mean, in criminal law, you'll usually see the mandatory because they're trying to establish a black line test for whether
Right.
you violated the law. In policy, you generally don't see the mandatory; you'll see the optional.
right, because it's easier to just leave the flexibility in the policy rather than to write the mandatory and then write out the exceptions that you may not be able to anticipate. The officer shall spark test their taser. Well, what if they get a roll call and they immediately have a shooting? Then they can't spark test their taser. They're in violation of the policy now? That doesn't make sense. Well, then you write that in. Well, then you come up with another reason why maybe they couldn't. Maybe they're grabbing the taser from someone else or something like that. There's an officer down. They retrieve someone else's taser. They're supposed to spark test it before using it. Then you got to write another exception. So again, in policy situations, yeah, you're absolutely right. And that's of course a distinction that's present in this case and very, very relevant. They're trying to make the policy an element of the negligence and then subsequently the recklessness. And while a policy this is part of your argument with Natalie the other day, while a policy can be in violation of the policy can be indicative of negligence, it isn't per se indicative of negligence.
Right.
You have to establish that they were
one factor.
Right. You have to establish that they were under an obligation, that they had a duty, and then they violated that duty to establish negligence.
Without good reason.
Right. Let's see. V. Rivera says, how can one know they are acting reckless while also not knowing and being reckless? WTF. Beats me. Again, the state is trying to show that because she was drawing a taser, she would know that some harm would occur. Therefore, drawing the gun put her in knowledge that harm might occur. Therefore, she acted in reckless disregard or in conscious disregard of the danger of causing harm. But again, she's not charged with causing harm. She's charged.
I mean, when they had the motion for dismissal or whatever we want to call it this morning, Frank was actually arguing recklessness in the colloquial sense. Clearly, she screwed up. We can all see that, she grabbed the gun when she meant to grab a taser. So obviously the recklessness is there. You can't dismiss because there's no demonstration of recklessness. But that's not what recklessness means in the legal context. In the legal context, it doesn't mean you just screwed up. It means you knew you were creating a risk of death and you did it anyway.
Yeah, a mistake, an honest, true mistake almost negates recklessness out of hand. Because if you're making a mistake of fact, then you can't consciously disregard a risk.
Yeah, imagine a scenario where she forgot her taser at home that day, so she only had her gun, and she sees this situation go down. She goes, you know what? I'm going to scare the guy into thinking I'm going to tase him. I'm going to pull out my gun, pretend it's the taser. I know it's a gun, but I'm going to pull it out, pretend it's a taser. I'm going to shout taser, taser, taser. And then the gun goes off by accident or whatever, reflex. In that circumstance, she knows she's creating a deadly force risk by pointing the gun. She's disregarding that risk. If it goes sideways, that's reckless conduct. But that's not what happened here.
Absolutely. That's a great explanation. Thank you for that. Z. Michael Gelke says, who had over on 4 digits of exhibits? Yep, we are into the 1000s of exhibits that have
By the way, for people who are wondering, because I see people in the comments asking, is my class different than the book? I guess thinking if they have the book, maybe they don't need the class. Well, that's a decision only you can make. But that illustration I just gave is the kind of stuff we do throughout the entire class that you can't possibly get from a written book because the book's obviously not dynamic.
Exactly. Not applicable says 6 sentences equals no information. Brilliant mind math. Yeah, that was, man, Frank was really trying to keep out this guy's testimony or severely limit it. It didn't work for him.
I think they were hoping he was going to die in surgery and they wouldn't have to deal with him. And then they finally took a look at his resume this morning and were like, holy shit.
I can't imagine. Again, that's the lunacy of what happened here. They've got this report that they're saying is facially and wholly inadequate. And compared to our much bigger report, I'll throw my report out on the table. You've had this report for months. You never objected to its reasonableness then. And he talk about his little grandstanding on litigating by surprise. If you're going to spring an objection on a report that you know necessarily will come in because it's being offered in support of an expert that will be called to the stand, and you're gonna bring an objection the day that that expert is going to testify, and you're gonna complain about trying to litigate by surprise. You could have objected to this thing 2-3 months ago. You could have had a motion in limine to restrict his testimony. You could have
that
had
would have been perfectly appropriate. I mean,
Right.
this report is completely inadequate because, folks, there should be no evidentiary surprises during the trial. In a perfect trial, everybody knows exactly what the evidence is, what the testimony will be, what the reports say, and they're not trying to get surprise evidence. They're not. Well,
Hey,
of course, you'd like to if you can.
I'll be right
but
back.
Sure. But the goal is not to ambush the other side with surprise evidence. It's not like in TV or the movies. Everyone's supposed to know what all the evidence and all the testimony is going to be to the greatest extent possible. The purpose of the trial is not to develop evidence. The purpose of the trial is for each side to build a narrative of guilt or innocence with that body of evidence that they both know exists. And then the jury decides which particular facts they deem to be proven or disproven and apply the law to those facts as they're instructed by the judge to do. But both sides are privileged not to be surprised by evidence during the trial. The issue here for the state is they knew this report was only 2 or 3 pages long for months. And if they thought that was inadequate disclosure, inadequate notice to them to be able to effectively prepare for trial, they should have said so then. You don't get to say it the morning the witness is about to testify, because that's in effect ambushing the other side. Well, I can't see super chats, but if questions stroll through the normal, I don't think I can. Is there a way for me to do that? Oh, there is, but then Nick won't know which ones I did. So let's see. What? Well, I'm not going to read the dirty ones, folks. Oh, can you have only juries made of lawyers? I don't think you would like that at all. I've never been on a jury. I've been called for jury duty several times, never seated. Seated once, and then they settled the case just before it went live. But lawyers, when they're watching a trial, as you might imagine, see a lot of things and know a lot of things that are happening that the court does not want a normal jury to know. Things like what's going on in sidebars or why an objection might have been made. So normally a court would not want juries on the juror. Although, like I said, I was seated once in a civil case, and then they settled just before we went live. So it does happen. Someone here comments, if there's new evidence in a case that could kind of get around the notice beforehand. So if a witness were to testify for the state early on while the state's presenting their case in chief, unexpected testimony or explore an area that no one had expected, that could open the door to then the defense being able to counter that unexpected evidence. And in that case, both sides were surprised, but fairness would, extend the opportunity to the opposing side to counter the surprise evidence with their own testimony. Do I like pineapple on pizza? No. I like my pizza very traditional, very New York. Unfortunately, you can pretty much only get it in New York, New Jersey, and one pizza shop in Massachusetts. How do we get people to stop resisting arrest? Well, not by rewarding and incentivizing flight and resistance. That's for sure. Yeah, I don't know why all the super chats aren't coming to me right now. Do I ever take a self-defense case that I think I can't win? First of all, I don't represent clients directly, so it's not really me winning or losing the case. I consult on the case. Generally, if the case looks like a dog when it comes in, when they're asking for a consult, we can generally tell the really bad ones right away. And then I just tell them that, they can retain me and I'll do my consult, but they're not going to like the report at the end. And of course, those clients don't retain you. They're not going to pay you for something that they don't want, or that would be harmful to their case. So we have a very, very high success rate at trial, just like prosecutors have, by the way, in convictions at trial, in part because it's kind of a cherry-picked pool. We would do the bad cases, but I'm going to tell people it's bad before I take their money, and then they tend not to pay us the money. So we end up not doing the consult. Ben asks, what's my go-to gun for concealed carry? My current gun is a SIG 320, but I'm about to buy a SIG 365 XL. I just haven't decided yet on the red dot I want on the gun, if it's going to be one of the Romeo ones from SIG or an alternative. I'm still trying to make up my mind. But a 365 XL is in my future. As soon as these trials are done and I can free up a few days to go to the gun store, I'll be picking one up. What's the standard for acquittal? A unanimous jury decision? Well, that comment went away before I could finish it. Yeah, either a guilty verdict or a not guilty verdict requires a unanimous jury verdict. There have been a couple of states, I think they've both come to the majority position now. There were a couple states that could convict on a felony with a super majority, like 10 out of 12 or 5 out of 6. But I believe those states, I think it was Washington or Oregon and Louisiana. But I think they've both changed their criminal procedure now to require unanimous verdicts in felony cases. But don't hold me to that. I'd have to check. They're such outliers. Yeah, so someone mentions Hollow Sun and SIG Optics. I'm looking at both of those. I don't know if they're the same or not, really.
Bring its case. Here's
Oops.
Judge Chu.
I don't know how to control. Oh, you're back. Okay.
The judge is back, but I'll still be right back. But I wanted to make sure the court feed was live. So I'll be right back, chat.
Would you please come forward,
Okay, the state's next witness.
Ms. Chair?
Sorry, defense next witness. Defense.
Raise your right hand. Do you swear under penalty of perjury that you will truthfully
Is this Gannon?
have a seat?
It doesn't look like the slip and capture guy.
Would you remove your mask, please? And then state your full name and spell it.
Sure. My name is Timothy, Timothy, Patrick, Patrick, Gannon, Gannon.
Former police chief.
All right, a couple things to keep in mind.
Left the same day as Potter, 2 days after the shooting.
He's taking down everything, so. you
That's
have
why
to
they currently have an acting
yes or
chief.
no, instead of shaking your head or saying uh-huh or if you don't understand a question, please.
I expect this testimony to be very favorable to
An objection is made.
Potter.
Stop talking immediately. Don't answer unless I.
He'd initially characterized this as a
Please
accident,
don't.
had no intention to bring any charges against her,
Wait until the.
which is probably why he lost his job.
Answer. Okay,
Thank you.
counsel.
We know your name is Timothy Gannon, correct?
Yes,
How old are you, Mr. Gannon?
I'm 53.
And I'm going to trace your history. Where did you go to school, high school?
High school, I went to Fridley High School.
And after Fridley, where did you go to school?
I did.
Where did you go to?
I initially enrolled in North Hennepin Community College in Brooklyn Park.
And how long were you there?
I was there about 3 years.
For those who asked, I do build my own ARs. Not all my ARs, but I built
Originally, my
several.
major was criminal justice or law enforcement.
And after 3 years, what did you do, if anything?
Well, within that 3 years, I had a break. So after my first year of college, I figured I was a 2-year track, so I could become a police officer, but I was nowhere mature enough or able to become a police officer. So I thought I would do something different. So I did enlist in the Marine Corps. And in between my college, I was a Marine Corps military policeman.
I have a Trigicon on my current SIG 320, but I hear there's issues, questions about their current quality. Mine is several years old, so it's one of the reasons I can't decide.
Marine Corps. The
So
first time.
my original duty time was just during training, so the boot camp and also the MP school, and then I served out the rest of my time. It was supposed
Hollow
to
Sun 507 fits the
and,
365
served
XL.
duty
I'm
back
told.
here in Minnesota.
Who's
So this is former Chief Gannon,
okay?
In
Perfect.
directed by Gray.
1990 and 91, I was called to active duty. And
So I had
the
a
Gulf
I had a
War,
dear
first
friend
Gulf War.
visit to say happy
And did
birthday.
you see combat in that war?
I did.
And how long were you there again? I'm sorry.
We were activated for approximately 6 months of duty.
Did you then return home?
I did.
And did you start school again?
Yes, I had then transferred down to Mankato State University, and I was in direction of getting my 4-year college degree, again in law enforcement and criminal justice.
And how long did it take you down at Mankato to get your degree?
It took me a little bit longer because of those interruptions.
10 years.
Also because of the active duty. So I graduated in 1993.
After you after you graduated in 1993, I take it you went and looked for a job?
I did.
And was that in police enforcement, law enforcement?
Yes, I chose to be in law enforcement, correct.
And that was your major?
It was.
Did you, after applying for jobs, did you get a job at the Brooklyn Center Police Department?
I did in 1994.
And was Kimberly Potter there already, or was that after you came?
She came after I was already there, so I believe in 1995.
All right. And so once she arrived there, you met her and worked with her on occasion?
I did.
Was she on the same shift that you once she started there?
No, we had basically gone to different shifts. I would see her in some of the shift work that we would do, but we were not on the same rotation or shifts.
Okay. Let's talk about your career there for a while. After you started there, you were a patrol officer, correct?
Correct.
And tell the jury about your rise up to the top.
Sure. I think my track was basically, my career track was similar to a lot of officers when they first start. I wanted to be exposed to everything. I wanted to be a trainer. I wanted to be a firearms instructor, a use of force instructor, a field training officer.
This guy should shave off
And
the
of course, as
goatee.
most people wanted,
Just
they
keep
wanted to
the
be on the SWAT
mustache.
team. I was on the emergency operations team. So I basically soaked in everything that I could early on in my career in Brooklyn Center, and I was given the opportunity to do so.
All right. And you have to slow down a little bit because the court reporter's looking at me in a strange way. Okay. So how about your promotions at the Brooklyn Center Police Department? Why don't you tell the jury about those?
Sure. So my rise within the Brooklyn Center Police Department, the rank structure is you can become a sergeant or a detective. And then above that rank, you can become, at that time, a lieutenant, which later would be called a commander. So my rise basically through the ranks was in about 2004, I was promoted to a sergeant position. And I was a sergeant for a very, very short period of time, about a year, a little bit over a year. And then a commander position or lieutenant position became available. And I tested for that, applied for that, and I was able to get that position. And I was a commander for quite a long time within the police department.
And when you say you tested for it, it was a written test, is that right?
No, it was an application process, and you had to have prerequisites such as a 4-year degree.
All right. So now you're a commander. And what year was that?
2005.
As a commander, I believe we heard in this case that there's 3 commanders and 1 chief, and the commanders answer to the chief. Is that right?
Yes,
And below the commanders are the sergeants. Is that?
correct.
So what division were you a commander in?
Sure. So within the police department, there's 3 different divisions. There's the investigative division, the patrol division, and also the community engagement or community services, which is the kind of the outreach department within the agency. I was able to rotate through all those positions. In each position, I was there for 2 to 3 years. I did serve a little bit longer as a patrol commander, and I went through that rotation twice.
And Kimberly Potter was in the patrol division. Is that right?
Yes.
And how long were you the commander in the patrol division?
Sure. I think my first tenure within the patrol was a lengthy time. It was either 5 to 6 years. And then when I rotated through, it was shorter. But it was the first one was 5 to 6 years. The second one was probably 2 to 3 years. So a total of 8 years as a commander.
And Kimberly Potter worked under you during that time? She was a patrol officer?
Correct.
And what kind of a police officer was she based on how she worked with you?
She was a fine officer. She
Preserve the objection that previously made.
Okay, the objection is overruled, but the state's objection is noted.
Go ahead. I believe you were interrupted when you said she was a fine officer.
She was a fine officer, and there's certain things within the department that you get known for. Are you handling your calls? Are you professional when you talk with people? Are you doing good police reports? She was known for doing all those things.
What about her volunteer work? Are you familiar with that?
I am familiar with that. Early on in her career, she did volunteer and began working for LIMA.
What's that?
LIMA is a law enforcement memorial association,
Slow down just a little bit.
Sure. It's a law enforcement memorial association, and basically what they do is they lend support to fallen officers and their families. They are at funerals. They extensively help the families go through this process, which can be very traumatic and tragic.
And that would be law enforcement that was killed on duty, correct?
In the line of duty, yes.
In the line of duty. Was she also on a DART committee?
Sure. DART is our domestic abuse response team. So one of the initiatives that I had brought forward with the help of my command staff was a follow-up for we'd have domestic abuse survivors. And a lot of times they wouldn't get all the resources they need at the original time of call. And what the DART team would do is they'd follow up afterwards, even the next day, to make sure that that survivor has all the benefits that they need, that they're talking to an advocate, that if they have any questions about the upcoming trial, they supply them with that. So a select group of officers would do that.
And she was one of them?
She was one of the original members.
Also, was she an FTO when you worked there?
She was a field training officer for a long time. One of the things related to that is we don't get very many senior officers to do the field training officer program because they're basically they've had a lot. They've done a lot over their careers and they leave that up to other officers. We have a few senior officers that still do that, and she was one of them.
And did you continue to be the chief of Brooklyn Center Police Department up until April of this year?
I was promoted to the chief position in September of 2015, and I served in that position until April of this year.
Yeah, and what happened in April of this year?
Officer Potter, or Kim Potter, was involved in the shooting incident, and the aftermath of that related to the political pressures within the city. I was no longer allowed to stay as the chief of police.
And was that because you would not terminate her until she had a due process hearing?
The objection is overruled on that ground. You may answer.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Did Kim Potter leave voluntarily after that? Quit her job?
She did resign her position to me while I was still the chief.
Let's go to April 11th of this year. You were still chief at that time?
I was.
And that was the day that a critical incident happened, is that correct?
Correct.
You weren't at the critical incident at any time, were you?
I was off duty at the time.
And however, you did look at BWC body worn cameras afterwards, is that correct?
I did.
The objection is overruled.
I'm trying to lead you into that, sir. Did you observe body worn cameras after the incident?
Yes, I did.
And what body worn cameras, if any, did you observe?
So on the night of the incident, I had been called in and I was at the police station, triaging the situation, working through the incident. I was advised by a BCA agent to take a look at the body worn camera footage from Kim Potter's camera. And that's what I did.
Later on, at some time later, did you look at more body worn camera?
I looked at one other camera angle much later, and that was the squad cameras. So within the police department, our officers carry it and have on their person a body worn camera, but also early on in the process, we had mounted squad cameras that can watch and can monitor outside of the car directly.
So you're able to see inside the car before the stop, is that right?
Yes.
And you saw the stop, and you saw the arrest, and you saw the aftermath, correct?
I did.
And after viewing all of those incidents and the body-worn cameras, did you see anything based on your knowledge and experience that her conduct was consistent with her training at the Brooklyn Center Police Department?
When I viewed both camera angles and had all the data in front of me, I saw no violation
No violation of what?
of policy, procedure, or law.
And the policy and procedure at Brooklyn Center Police Department, to your knowledge, since you're the chief, followed the law of use of force, is that right?
Yes, it does.
Now, in a critical incident, there are there's shooting, sometimes violence, chaos. In your experience, going back your years of being a law enforcement officer, had you in the past, before April 11th, been involved in critical incidents?
Yes, I have.
Was there one that stands up in your mind as memorable?
Yes.
Was that a critical incident where you were almost dragged in a car, or you were actually dragged for a while?
That is correct.
Trying to get to the issue, Your Honor.
Okay. The objection is overruled. You may answer, or I'll let the answer stand. Officer, could you please remember to pause a little bit and stop talking when there's an objection, okay?
Yes, Your Honor.
The objection was overruled, so you can answer my question.
I was involved in a situation where I was dragged by a car.
And what went through your mind when you were dragged by that car?
Sheer terror, trying to recall my training, what I had been exposed to before that, and simply trying to survive.
That one incident after you were dragged by that car, I take
Great
it
stuff
you did,
here.
but did you remember the aftermath of that? What happened immediately after you were dragged?
Objection, Your Honor.
Lydia,
It goes to her testimony, Your Honor.
Also, we need to sidebar.
Okay.
All right. While we're in sidebar, I see a few comments asking someone to post the link to the class. I don't know how to do that. I don't think I have that ability, but it's pretty easy. lawofselfdefense.com/advanced. The class is Saturday, January 8th, 2022. We only do these classes once a year, once every year and a half. So if you missed this one, it is gone. It is a live class taught by me over Zoom to your computer. Plenty of opportunity for Q&A. We make sure all the questions are answered. And so if you have variations or don't understand something or would like an illustration of how something works, that's something we can do in the live class that we obviously can't duplicate in a book or a DVD or a recorded streamed class. We have all of those too, of course, but the live class is the one opportunity to engage with me on a personal level while taking this content. Someone asked, what's the craziest legal proceeding I've ever been involved in? It was probably my own divorce. Let's see. Yeah, I'll mention that too. We have the hardcover of our book, Law of Self-Defense Principles, hardcover. And the URL for this is lawofselfdefense.com/gethard. I thought the Nakaida crew audience would appreciate that URL, lawofselfdefense.com/gethard. It will not arrive before Christmas. Sorry.
Okay, the objection is sustained on relevance.
Now let's back up to what you viewed in the body-worn camera and the squad camera. You viewed that after Officer Lucky stopped, my hair is all messed up because of that thing. I'm told that Officer Lucky, he stopped the vehicle. He was the trainee at the time, is that right?
Yes.
And did you notice anything about his procedure in doing that was an error?
Yes.
What was that?
I think when he made the decision to make a custodial arrest, I think at that time, when he got Mr. Wright out of the vehicle, what training tells us to do is to move him to the rear of the car, away from the open door, or close the door behind him. That would be something that you would learn later that you would do as a procedural issue as far as a
And an
traffic arrest.
FTO, unless it was some type of an emergency situation, would not interfere at the time he was performing the arrest to correct that. Is that a fair statement?
Objection needed.
I'll let you answer. You may answer.
As a field training officer, I would not have corrected that action until afterwards during a debrief.
After Mr. Wright was asked to come out of the car and he was being handcuffed, he broke away, correct?
Yes, it appeared that way on the video.
Anything about what Officer Lucky did or Officer Potter did, or in fact, what Sergeant Johnson did and the chaos that happened after that, any violation of policy that you saw in that?
I did not.
In your opinion, could a taser be used to stop him from fleeing?
Objection, Your Honor.
Yeah, there's some heavy breathing, Nick, on the
Objection is
audio.
overruled.
On
That
mine?
us? I don't know where it's coming
Could be
from.
used in that situation?
A taser could have been used in that situation.
And also, as a result of
Might be me. I'll try not to.
Officer Johnson
I'll stop breathing.
being partway in the car and Officer
That's what a
Lucky
reasonable officer would do.
standing by the other side of the car and both car doors open, they could have been seriously injured if the car would have went reverse. Is that right?
Yes,
And that would be a great bodily harm. Is that correct?
correct.
So is it your opinion that not only could a taser be used in this chaotic situation, but also a gun? Is that right?
That is correct.
And that's based on your viewing of the videos, correct?
Yes,
And your experience. How many years are your experience as a law enforcement officer?
just about 27 years.
And you know you're under oath.
Yes, I am.
And you're not doing any favors for Miss Potter, are you?
Objection needed.
Well, are you doing any favors for her by saying this?
I am not.
And that's your opinion based on your experience as a law enforcement officer
Yes,
and an ex-chief. Is that correct?
yes, sir.
Are you presently
Okay, hopefully
employed?
that fixes my audio. I hear
I
it's
am.
boosted
And
heavily.
what is your job?
I'm a business agent for Law Enforcement Labor Services, or LELS.
And law enforcement labor services negotiates contracts for various police departments,
Yes,
and you negotiate contracts.
I've just started doing that. Yes,
Okay, and you have no more connection with being a law enforcement officer. Is that right?
correct.
Thank you, sir. That's all I have.
Dean Cross.
I missed all of it. It's okay. I had another friend show up. It's like it's my birthday.
Hey, actually, your birthday?
Yes.
Oh, happy birthday. For some reason,
Thank
I thought
you.
it was yesterday, but yes, the 16th.
Good afternoon, Mr. Gannon.
No.
Thank you for coming in. Your entire law enforcement career, I was going to say was at Brooklyn Center, but you also worked as a military police officer in the Marines, correct?
Correct.
But outside of the Marines, it was entirely with Brooklyn Center, correct?
Yes, sir.
And total of 27 years on that job.
Just about 27 years. Yes, sir.
And it's a difficult job, isn't it?
Yes,
Rewarding job,
certainly.
but it's a dangerous job sometimes, correct?
Yes,
And when you're out there, you have to rely on the other officers around you to help keep you safe.
yes,
And you have to rely on other officers. Well, other officers rely on you to keep them safe.
correct.
common to back up other officers on even just traffic stops.
Yes.
And it builds sort of a camaraderie, doesn't it, among officers?
Yes, it does.
And
My water. I didn't mean to.
Water's over here.
I lost my gas.
not my day to keep track of
I think I left my bourbon over here.
it. COVID has affected us in many ways, hasn't it? Sorry about the interruption.
Maybe for you and your weak immune system, Frank.
And Kim Potter became a part of that camaraderie aspect of your life, your professional life.
Yes.
And did you know her personally at all, in personal context?
Yes.
And what kinds of stuff did you do outside of work?
Social gatherings, friends getting together, different anniversaries, things that would come up. But there'd be time to time that we would get together on a personal basis with her family.
So also personal friends.
Yes.
And you actually did work shifts with her?
Yes, we did.
And that matter that she did for, well, I call it the honor guard, but I think you had a different term for it. Lima, maybe?
I'm sorry.
Okay, I've been referring to it as the honor guard. Is that the same thing that you were talking about?
Yes. Honor Guard is, I guess, a subset of Lima. Yeah.
And that's really an important support service for law enforcement families, isn't it?
I'd agree with that.
You really admired her for doing that.
I did.
It's hard to impeach someone like
When
this.
she was working for the guard
Yep.
program, she was no longer really out on the street every day.
I mean, unless he was sleeping with her or something.
No, that's incorrect.
Okay, tell me.
So the DART team was basically an offshoot of the patrol. So basically you'd still be in patrol operations and be a patrol officer, but you would make time in your shift to go back and do the follow-up with the survivor and make sure that they have the services. So they do both duties.
Got it. Thank you. And then on April 11th of this year, when you learned about this incident, you learned about it that night, correct?
Basically early in the afternoon, yes.
Okay. And at some point, did you learn that it was Miss Potter who had fired a gun and caused the death of that young man?
Yes.
Did that surprise you?
Yes, it did.
And at that point that evening, you watched her body cam video, correct?
Yes, I did.
And I was a little unclear. You said at some point you watched the squad camera sometime after that, but I wasn't sure about when after that you also watched the dashboard cam.
Within the last 2 to 3 weeks, I've watched the dash cam. I have not had access to that camera footage other than the initial camera that I saw, which was her body cam after I resigned.
And so at the time, on April 11th, you only watched that dashboard, or I'm sorry, Officer Potter's body cam.
Correct.
And at the time, when you watched that, you concluded that she did not mean to fire her firearm.
Correct.
And you decided that night to release the video to the public, to show the public that.
Yes, I did.
And it's your understanding that because you refused to fire her, you were not going to be allowed to stay as the chief of police.
I believe there were multiple situations or reasons that I was given. That was one of them. I believe the other reason was my handling of the riots that occurred that night and the next night in front of the police department. Those were things that were pointed out to me that that was in conflict with the elected body.
And you disagreed with those reasons.
Yes, I did.
And particularly with what the shall we say, suggestion to fire her, the request to fire her?
Yes, I would agree with that.
And
with the
that's
elected
because
body,
you thought
it was
she should be
political.
entitled to some due process, right, before she were to be fired.
We have a policy in place to do administrative investigations, and they entail being thorough, being impartial, and being fair. And I don't think I could have done any one of those three things if I were to make that decision that day.
And so you essentially felt that you were being forced out of the job.
Correct.
And, but instead you resigned, right?
Resigned in lieu of termination.
And were allowed then to keep all the benefits, that retirement benefits that come with the job.
Correct.
Now you work for the agency, the Law Enforcement Legal Services, that also provides legal services to officers for on-duty incidents.
Yes, I was unemployed for about 6 months, and I've just recently been employed.
Your agency, well, shouldn't call it that, should I? Where you previously worked at Brooklyn Center, had a policy about officer-involved shooting incidents.
Correct.
And the policy required that the investigation of that kind of incident be referred to an outside agency.
Yes.
And that day, even April 11th, you made the decision to authorize the BCA to do the investigation.
Correct.
And the purpose of that is to avoid any potential bias in the investigation, correct?
That is the intent.
It's also to provide some transparency so that people see that that bias is not going to play, the potential bias is going to play a part in the decision, correct?
Correct.
But today you think you have none of that bias in order to offer the opinions that Mr. Gray asked you to offer.
With the video evidence that I've seen today or within the last 6 months, I believe I can make that decision.
You did an interview with the media on November 14th of 2021. Do you recall that?
Yes, I do.
And that was really about the aspect of how you lost your job there at Brooklyn Center.
It was about the inner workings of working with the political ramifications of decision-making, yes.
And in that interview, you refused to discuss the actual killing of Mr. Wright because you thought you might be a witness in the case.
Correct.
What made you think on November 14th that you might be a witness in the case?
I had the belief that either the prosecution or the defense would call me as a witness in some capacity. I was a police chief.
And had the defense contacted you at that point?
I believe at that point they had contacted me.
So at that point in time, when you were contacted by the defense, you had only reviewed Ms. Potter's body-worn camera, correct?
Correct.
And so the only aspect of the case that you had at the time was from Ms. Potter's body-worn camera, correct?
Yes.
And at that time, you did not see any danger for the other officers that would have justified the use of deadly force, as you've said today.
I did see some danger on the driver's side in case the vehicle went in reverse, but I did not see the situation of Michael Johnson on the other side of the car.
So you've been involved in a lot of traffic stops, I assume?
Yes, sir.
Have you had some people flee from you at a traffic stop?
Yes, I have.
Did any of them drive in reverse to the squad car when they fled from you?
No, they have not.
Does it make any sense for somebody to put it in reverse when there are two squad cars behind them to flee?
No.
Prior to that media interview, you had actually had sat down and talked with the defense attorneys on November 8th, correct?
Yes.
And in that interview at that time, you were of the opinion that Sergeant Johnson was leaning into the passenger side of the car when Mr. Wright tried to drive away, correct?
Correct.
So that's something you felt you knew at that time to offer an opinion on, correct?
I need to stand corrected because I have to remember exactly when I saw the video that was reflected on the squad camera. Once I saw the squad camera angle, I believe that Mr. Johnson was hanging inside the car at the time of the incident.
Well, hanging inside the car was not the word you used in the interview with the defense attorneys, is it?
I don't recall.
Would it help to refresh your recollection if I showed it to you?
Yes.
All right. May I approach, Your Honor?
Yes, you may.
Yeah, it's He's going to have to work for this one. The reverse thing, hopefully they'll bring up on redirect that he could unintentionally go in reverse, right? Because
Just because it hasn't happened to him personally doesn't mean it's not a risk.
Right.
Has he ever been shot in the face? No.
Well, I mean, is it really a risk?
That one time in college.
Whoa. Don't talk about Binger's college days.
Yeah.
Someone in the chat brought up that they can, you know, hit it into reverse to disable the police car that would pursue them.
It would actually. It would bang out the airbags, right?
Yeah.
That wasn't a quote. It was a report.
Oh, okay, council member. No speaking objections. Oh, my God. All right. Is there an objection? Yes.
Do you see Frank's body language there?
No.
Throws his pen. Oh, I got to go walk away. But you're asking the guy to testify to a summary of what he said.
It's right. And he didn't write that summary.
Yeah. That's
We had the same stuff in Rittenhouse where they had the FBI reports, but the FBI report's not a transcript of what somebody said. It's the officer writing down words based on what you tell him. The words he writes down would routinely be different.
right. It's
than
the
what was actually
officer's,
said. He's summarizing.
it's the officer's present sense impression of what
Right.
you're telling him, but it's not a transcript. And so if you're going to say, you know, you testified to this, it's like, but he didn't though. Well, in your witness report, it says this. Well, I didn't write it. I don't know what they heard. You never can know what someone else hears. And lawyers don't give the witness necessarily a copy of the witness report and say, please approve this. They may say, hey, can you verify this is what we talked about? Is this an accurate representation? But they don't have to. So, whew.
Yeah. Judge Mommy needs a vodka tonic.
No, she was a little salty on that speaking objection.
Objection is sustained.
Oh, Frank is pissed.
At the time of the interview in November 8th of 2021,
Did you just mutter bitch?
you believed is simply that Mr. Johnson, Sergeant Johnson, I'm sorry, was leaning into the car, correct?
Was in the car, yes, leaning in the car.
All right. And
All that over the word hanging?
the second time then you met with defense counsel was December 6th of this year, correct?
Correct.
So after the trial had begun.
Yes.
And you were then, from them, shown these other videos, correct?
The two videos.
Yeah, I think earlier you referenced the dash camera from Officer Lucky's squad. And then what else did you review?
The body-worn camera footage from Officer Potter at the time.
Right, but that you watched day one, right?
Yes.
And then, so the only other video you've watched since then has been Officer Lucky's dash camera.
Correct.
Okay. And that is what you did when you met with counsel on December 6th.
Yes.
So it was only upon looking at that you've arrived at this
Week ago.
opinion about deadly force.
Correct.
Have you watched Sergeant Johnson's body cam?
I have not.
Have you interviewed any of the witnesses?
I have not.
Have you ever in your career offered an opinion on whether an officer's conduct was reasonable for a use of force evaluation?
I have reviewed for IAs as a police chief. I've had to review a lot of internal affairs investigations, and I've had to make determinations based on the evidence that was presented to me.
And in making that determination, what you're determining, afternoon.
Determinating.
You're determining whether their conduct was consistent with what you said today, right? The policies and practices of the department.
Of the department, yes.
Because an officer could be disciplined by the department.
Correct.
You were not in those situations making a legal determination about the reasonable use of force.
I was not.
And your opinion today is solely that Officer Potter's conduct at the time was consistent with policies and practices of your department.
Correct.
Not even going to try to show it wasn't, because of course it so obviously was.
Yeah. Again, every cop in that situation is, even if they if they didn't choose to deploy the taser, is comfortable with another cop deploying the taser.
I'll make sure I got my numbers right. You became a commander.
So it's supposed to be a felony crime, even though it's within policy.
And a commander position is one that is largely administrative.
Yes, it's a variety of roles, but yes, administrative.
In the office, day hours.
Correct.
And have you carried a taser every day on your job since 2005?
I have not.
Is he trying to compare him to Stoughton? I mean, he was a chief
You
for all
have
those years,
offered,
commander in chief.
that Mr. Wright should not have been allowed to leave the scene, correct?
Correct.
And that's because there was a warrant for his arrest.
Correct.
And would officers, well, it's true, isn't it, that in making that arrest, officers still have to use reasonable force?
Correct.
You're not saying that anytime somebody tries to get in their vehicle and drive off during an arrest, an officer can shoot them.
That is correct. Not every time somebody gets in their car is an officer have the ability to shoot them. No.
Sometimes they try and miss.
They don't always have the ability, if you know what I mean.
We're actually not all that good with our
From
guns.
the dashboard camera, you were still able to determine that Sergeant Johnson's feet were planted on the ground during the incident, correct?
I believe he was still grounded, but a large portion of his body was inside the car.
And that's from the perspective of the dashboard camera.
That is correct.
Did not watch Sergeant Johnson's body-worn camera to get his first-person perspective, did you?
It's not his first-person perspective.
And it's irrelevant.
Did you?
Kim
Well,
Potter
so you
is
also,
not Officer Johnson.
Don't know.
And neither is Gannon, right?
Sergeant Johnson was able to prevent Mr. Wright from driving off by holding onto the shift knob.
I am not aware of that.
And you also do not know that Sergeant Johnson was able to prevent, whether Sergeant Johnson was able to prevent Mr. Wright from driving off by grabbing a hold of his right arm and pulling it towards the passenger door.
I do.
Object to that in the statement, testimony.
All right, members of the jury, you rely on your own memory as to what the evidence showed. Okay? You may continue.
So she overruled the objection, but without saying it, but offered a limiting instruction. Basically useless, in my opinion, limiting instructions.
Well, it reaffirms it could be a misstatement, right?
Yeah.
Before deploying a taser, officers should consider the surroundings of the person they intend to tase, correct?
Correct.
As the police chief, as a fellow police officer, you would not want an officer shooting their taser in the direction of other officers or civilians.
Correct.
And in the space, well, strike that. So then you would agree, wouldn't you, that Officer Potter's decision to try to use a taser put the passenger of the vehicle and Officer Johnson at risk of being struck by the taser?
I would not agree with that.
Why not?
At that distance that she was within Mr. Wright, the prongs and the distance that they travel apart is very concise and very close. So I think her target that she was looking at doing would have been center mass at the chest and area. I don't think those prongs would have had enough time because they have to travel farther to get the distance apart. So I don't think that was in any way a danger to the passenger or to Michael Johnson because the prongs would have been very close, a tight group.
In watching Officer Potter's body worn camera, you saw that Mr. Wright was moving around a bit as he was trying to
Get away.
Correct.
So it was a moving target.
Correct.
Could she have missed?
Could I object to that, his argumentative, and also the statement of what that body camera showed.
All right. Again, members of the jury, rely on your own memory, okay?
Not like he was running past the officer. He's squirming in a seat.
Yeah. Did she miss?
Incidentally,
Was there any question that she might have missed? She's firing from a foot away. I mean,
are
come
you
on.
certified to carry a taser?
I mean, now it would have been bad if she were further away and got probe
Training
spread,
over years.
right?
I
Right.
do.
You understand the need to get a good probe spread to get a good neuromuscular incapacitation.
If at all possible, yes.
And that the more distance you have, the better off, the more likely you are to get that.
Correct.
You're familiar with the type of taser cartridges that your department started using with the Taser 7 this year?
I'm somewhat familiar with it. I did go through the taser qualification, but I've not handled them since I resigned. It's been quite a while, and we did intro them into the department this year.
Your Honor, I'd like to put Exhibit 246 on the stand, please.
You may.
246.
246.
Do you see that in front of you then?
Oh,
Yes.
not this again.
Sometimes I know we get kind of a glare on that screen if you need to move it. Do you recognize what this is?
Yes.
And this is Ms. Potter's certification for the Taser 7 transition, correct?
Yes.
Below the 4 check marks in blue, there are 2 boxes and one has an X in it, correct?
Yes.
And so this is indicating that
Oh, look at that.
certification, the close quarters cartridge had not been used.
Correct.
That's not evidence of what she had on her. That's what that training was.
Yeah.
When you saw the video from Ms. Potter's body cam, she was quite upset, correct?
Yes, she was.
Did you feel bad for her at the time?
I did.
Still feel bad for her?
I do.
So the manner in which Officer Lucky brought Mr. Wright out of the car, you thought it would have been better for Officer Lucky to bring him back behind the car, correct?
One thing I hate to do as a police chief is Monday morning quarterback somebody's actions, but I do stand by what I said. It would have been preferable for him to move him back away from that open door frame. But again, I'm looking at it from a perspective many months later.
But not concerning enough for you to believe that an FTO at the time should have corrected that right at the time.
No, from what I watched, it looked as if Mr. Wright was going to cooperate. He initially got out of the vehicle, and sometimes that does put officers off, and they think that there's going to be a compliant individual, and then things change very drastically and quickly. I think it would have been a coaching moment for Kim Potter to have with her probationary after the call.
Why would she correct him while he's effecting arrest? That doesn't
Insane.
make any sense.
a guy with a gun warrant. Hey, let me pause this arrest before you got the guy cuffed and talk about your technique.
That a taser
Will
could
you
have been
comply
used
and just
in
pause
that
there for a second
situation,
so we can move you to the back?
and you agreed with that.
Yes.
And that situation is basically what you saw on the dash cam and her body worn camera.
Correct.
So when you offer the jury this opinion about using her taser was consistent with policy and practice in Brooklyn Center, it's because you believe that Mr. Wright was not in control of his vehicle when he was shot, so it was an acceptable decision to use the taser.
From the video images I saw, he was not in control of his vehicle at the time that she would be deploying the taser, if that's what the tool that she used.
And that's what you said, is that he wasn't, and you didn't see him in control of the vehicle, so it would be okay for her to use the taser.
Yes.
Because if he was in control of the vehicle, it would not have been a good idea to use the taser, correct?
Maybe.
Correct.
I
Because
should have said maybe.
he could have been incapacitated and the vehicle could have moved.
Yes.
If he was not in control of the motor vehicle at that time, as you believe, then there also was at that same time no threat of harm to Sergeant Johnson, correct?
Oh, I disagree with that.
Is it consistent with policy and practice for an officer, a police officer, to not know they have their gun in their hand when they shoot somebody?
Could you rephrase the question or repeat it, please?
Sure. Is it consistent, in your opinion, with policy and practice for an officer to not know they have their firearm in their hand when they shoot it?
Mistakes happen.
You are correct.
I'm sorry?
You are correct.
I have nothing.
But is it consistent? He says you are correct.
It's a redirect.
That was weird.
Ex-police chief Gannon,
Yes.
would you lie under oath to help a friend out?
Sir, there's a reason why I'm an ex-chief. Nobody gets me to say something or do something that I don't believe in. I wouldn't lie for anyone.
Thank you.
Nice.
Anything further?
Wait, what are you gonna? What's
Just
your
briefly, Your Honor. You're offering today your opinions.
That is correct.
Thank you.
Good recross,
Is there
Frank.
any further redirect? No? Is there any further redirect? Okay.
Did they try and
Thank you.
impeach his
You
credibility
sit
for
down.
truthfulness somewhere?
Oh, they certainly made implications. You like Potter, right? You're friendly
Yeah.
with Potter.
All right. Okay, the defense may call its next witness.
You call Colleen.
Colleen Fricky! Yeah, they did not. That cross was not very good of Gannon there. I mean, I don't know what you do to this guy. 26 years or whatever, former police chief.
Strong finish.
There's a reason I'm a former chief.
Nobody tells me what to do. Nobody tells me what to say. I tell them what to say.
Especially not a bunch of woke politicians.
Bunch of Nancy boys never seen a field in their entire life.
And they don't have the upper body strength to lift my balls.
Sorry, I don't drink Soylent and I don't speak bullshit. Jay says, happy birthday from the Salty Army. Have a salty scotch. Hey, thank you, brother. Eugene says, I take back everything I ever told against mommy ASMR judge. I can still listen to her on 1X with 88 Frank. I'm always looking to turn on 2X speed.
Can you stand behind the witness chair?
Alex McCartney says, what they aren't talking about are the electrodes on the taser cartridge. You can shoot the darts with very close spread, then apply the taser cartridge to another part of the body to get NMI,
Remove your
neuromuscular
mask, please,
incapacitation.
and state your full name and spell it.
Colleen, Colleen. Michael, Mychal. Fricky, Fricke.
The court reporter is taking down everything that's being said. Please answer with a yes or a no instead of shaking your head. And don't say uh-huh and only one person can talk at a time. Wait until the question's finished before you answer. If you don't understand a question, let the lawyer know. And finally, if an objection is made, please stop talking immediately and don't answer the question unless I tell you to. Okay. Counsel?
Thank you, Your Honor. Officer Fricky, you're employed by which police department?
The City of Brooklyn Park Police Department
How long have you been employed there?
since May of 2021.
How old are you?
40 years old.
A little slower.
40 years old.
Okay. Give us your educational background, please.
I have a bachelor's degree in criminal justice and public administration and a master's degree in criminal justice.
What institutions did you graduate from?
St. Cloud State University.
For both.
Correct.
Were you formerly employed with another police department before your current employment?
I was previously employed with the Brooklyn Center Police Department
When did you start there?
in March of 2008.
What were your initial roles and duties there?
I was hired as a patrol officer.
And did you stay in that capacity throughout your work there?
I had different
I didn't
assignments.
hear.
I filled
Sorry.
a role as a juvenile officer for a few years. I was a sergeant for 3 years.
She's a fast talker.
Well, you worked there. Did you come to know
She's like the anti-Frank.
Potter?
I did.
How did you come to know her?
We worked on the same shift together for several years.
Did she become for you a mentor and friend?
Yes.
And did you spend quite a bit of time with her?
Yes, I did.
Did you have a chance to observe her working in the community?
Yes, I did.
Did you have a chance to observe her with suspects of crime, for example?
Yes,
Did you find her to be patient?
I did.
Polite.
Your Honor, prior court ruling.
Yes, counsel, the objection is sustained.
Was she a, I'm sorry about that. Was she a good police officer?
Yes, she was.
Was she an FTO?
Yes,
Did you work on the DART program with her?
I did.
What is DART again?
It's a domestic abuse response team.
What was your role in that?
I led the team, supervised the team.
What did you do with respect to Officer Potter in terms of the DART team?
She was a member of the team, so I would assign cases to her and follow up with her to, check in on the work that she was doing with the victims and families.
And you've supervised her work, did you not?
Yes.
Were you aware of whether or not during your employment at Brooklyn Center that Officer Potter had fired her weapon?
No.
Were you aware that she had ever fired a taser?
No.
As a matter of policy, are you familiar with the policies of Brooklyn Center Police Department?
Yes.
As a matter of policy, would an officer be allowed to ignore a bench warrant for a gun charge and let an individual leave the scene instead of making an arrest?
No, that wouldn't be typical.
You would have to make the arrest.
Yes.
You were summoned to the scene on April 11th, were you not?
I was.
And you were assigned to Officer Potter to be with her. Am I right about that?
Yes.
And stayed with her from the scene and into the Brooklyn Park Police Department. Is that right?
Brooklyn Center Police
Brooklyn
Department.
Center, I'm sorry. I know there is a distinction. Did you have a chance to observe Officer Potter while she was at the Brooklyn Center Police Department in a room by herself?
I did.
What did you observe in that regard?
I saw her curled up in the corner of the room.
What room was she in?
It was a meeting room.
Please don't cry.
I was going to say she sounds like she's about to cry from the beginning, but I thought that was just the way she spoke. Clearly, she's about to break down.
Yeah.
Yes.
In all the years of working with her in Brooklyn Center, do you have an opinion as to her reputation for peacefulness?
Yeah, I think she's a remarkable.
Objection, Your Honor.
Well, excuse me, I'll let you finish your answer.
I think she was a remarkable police officer because she was a remarkable person. And
Okay, the objection is sustained at that
I
point.
wanted to ask you,
The jury will disregard that last statement, okay?
I wanted to ask you to focus
He
on,
asked the right
her
question. She gave the
reputation
wrong
for being
answer.
peaceful in the community. Do you have an opinion as to whether or not she has a reputation for being peaceful?
yeah, I think she has a positive reputation.
And do you have a reputation? Do you have an opinion as to her reputation in the community for being law-abiding?
Yeah,
What's your opinion?
that she is law abiding.
I have no further questions.
Is there any cross?
Oh, Larson is going to.
All right. That's going to look good. They should have had the woman cross-examine her. Well, maybe they did.
You're going to have to call Dart after this.
Is it a true your line?
You began a law enforcement career in 2008,
Correct.
and you remained with Brooklyn Center through April of 2021.
Through May of 2021.
May.
Yes.
Okay. And during your entire career, the defendant was a coworker up until obviously April 11th.
Correct.
And you worked alongside her as a patrol officer,
Correct.
shift after shift, year after year.
Not from the day I was hired until the day I left there.
Okay. In addition to those years, though, that you did work with patrol and in the DART program, you developed a relationship with her beyond a professional relationship.
Yes.
You talked on the phone.
Yes.
You texted with each other.
Yes.
You got together a few times a year outside of work.
This
Yeah.
is completely the wrong tone.
You were friends.
Yes.
Yep.
Right. You'd say that you and the defendant communicated a lot during your career, both inside and outside of work.
Primarily inside of work. Yes.
And you were contacted by the defense to provide a statement on November 8th of this year?
Yes.
Okay. And you've talked to the defendant herself on the phone after this incident multiple times, correct?
I wouldn't say multiple.
Do you remember saying multiple times back on November 5th of 2021?
I don't remember the verbiage that I used then.
Okay. Now, I do want to talk about your actions on April 11th.
You became friends with a coworker?
On that day, you were
How dare you?
Working a patrol shift, 6 a.m. to 6 p.m. That's the same shift that Officer Potter was working at that day.
Correct.
And as part of your duties, you paid attention to the radio communications.
Correct.
And around 2 p.m., you knew that Officer Potter and Officer Lucky had initiated a traffic stop, correct?
Yes.
And you were at the police station at that time.
Correct.
You heard a further report about a crash and then a report of shots fired, correct?
Correct.
And you drove to the scene
Yes.
and you knew that a shots fired call is perhaps the most serious call you can respond to as a police officer, correct?
It's serious.
Yep. But even at that time, you did not know who was shot, why they were shot, where they were shot.
Correct.
But nonetheless, use of a firearm could seriously injure and kill someone, correct?
The objection is sustained.
I'd like to talk to you about the response that you had to the scene, which was discussed on direct examination.
Also be honest.
Sidebar, Your Honor.
Oh, look at his body language. Look at how mad he is.
Yeah.
Terrible, terrible approach to this witness. She was almost crying 2 seconds ago. Note the difference between how Earl Grey handled the mom of Dante Wright and how this guy's handling her. Now, obviously different situations, but
You can impeach her with if he said the same words in a kindly tone, it would be completely different.
Right. And it's just never, like, no matter how progressive or whatever our society has become, it is never a good look to have a male badgering a female on the brink of an emotional breakdown. It just doesn't, like, you have to walk on eggshells, or in the state's case, have the woman do it. Like, because she can be as cruel as she wants. That's the jury's not going to look at that with that preconceived, quote unquote, patriarchal bias. You have the opportunity to have the female attorney ask the female officer questions, and it's a great approach. And it gives you a lot more leeway in how you do this. He
Looks
has
like
to
he's finally getting to act out his junior high school years on somebody else.
That was just 2 years ago. Actually, I think he's probably about my age, frankly. He graduated a long time before me, but I went to law school late, so who knows? No, so he graduated 08. Yeah, that means he would have started law school in about 05.
Someone in the comments says he's used to making women cry. Yeah, but maybe for different reasons.
I'm a comedian. Women laugh at me all the time. Sure, buddy. But yeah, it's just it just doesn't.
I mean, this is
right.
good for the defense.
Yep.
Because it'll shade everything he does. Everything he's done.
All he had to do was, and I don't know how you get to this, but go ahead and impeach that character of truth.
Just say you're your friends. You feel bad for her. You feel sympathetic. There's someone, you wish she was in a better place than this. And, I mean, you're just trying to show bias. It doesn't have to be malicious bias.
Right. Or you elicit any testimony about any time you saw her do the wrong thing on duty.
Which they don't have, apparently.
Right. But it's like, she's broken a policy here or there somewhere. She's done anything. Oh, she's law abiding.
It may not be documented. I mean, if it's not documented, she'll just say, I don't remember any of that.
Yeah.
I have no recollection of any of that happening.
All right. Let's see who.
The objection is still sustained.
Eventually, Officer Fricky, you did function on November 11th as Officer Potter's escort officer. Am I correct?
On April 11th, yes.
You encountered her at the scene and then you went back to the police station with her.
Yes.
You arrived with her at the same time?
Yes.
Do you recall when you walked into the police station, Officer Potter walking away from you?
Yes, she's walking in front of me.
And then she entered a conference room and closed the door.
I don't recall if she closed the door before I got in there behind her.
Sure, but you were actually only outside of her presence for several seconds and then you entered the room, correct?
I don't recall the sequence.
Okay. How long did you leave her alone as her escort officer on November 11th?
I wouldn't say I left her alone.
Okay, so she was just on the other side of the doorway and you walked in just as you entered the police station, correct?
The room that she went into, the entire front of the room is glass.
Mhm.
So if I was on the outside of that room, I would have still been able to see her.
Yeah. In other words, she wasn't in the room alone for a long period of time prior to you encountering her, correct?
Correct.
All right. And when you encountered her, you asked if you could sit with her, and she said no.
I don't recall specifically.
Do you recall when she asked you to take your body worn camera off?
I recall a similar conversation.
Okay. And you did, at her request, take your body worn camera off, correct?
I removed it from my clip and placed it on a table.
And then she did not want you to be your escort officer anymore. Is that correct?
That's correct.
Okay. And you stopped being her escort officer. Someone else was assigned to that role?
Somebody else assisted me in that role, yes.
Okay. Now, You agree you weren't present at the scene when the defendant shot Mr. Wright?
It is beyond the scope. The objection is sustained.
Sure. You testified that the defendant had a reputation for having a law-abiding character.
Yes.
Prior to April 11th, the defendant was a law enforcement officer, correct?
Yes.
All right. In terms of following the law, though, generally speaking, you'd agree that following the law on one day does not absolve you from accountability the next day, correct?
Okay. The objection is sustained.
That's like a reverse
You testified
prior
that the
act.
defendant had a character for peacefulness.
Yes.
You'd agree that as a police officer, though, she was specifically trained in how to use force, correct?
He's a bad actor for being a cop.
Weapons that would use force, including firearms and tasers.
Lawful force.
It is beyond the scope. The objection is sustained.
No further questions, right?
No kidding.
Oh,
Okay, is there-
Nice flailing.
that was
Okay.
too bad.
All right, you may step down.
Judge, can we have a sidebar here?
Yes.
You would agree that when she murdered that man in cold blood, that she would use force, and that's against her character for peacefulness, correct? Look, these are fluff character witnesses. There's not a ton you can do on cross because there's nothing to cross-examine them on that you wouldn't have already raised in your case in chief through other.
Except you can do this. You can just be mean.
Yeah.
I mean, it's so pointless. It's damaging to you.
Yep.
To be pointlessly mean to a woman who's about to cry. I mean, jeepers. Use some common sense.
Very, very silly. Eugene says, I swear I expected the line of questioning was going to, were you in a sexual relationship? Someone in the chat said, did you kiss? It's like, no, stop it, chat. Stop it. But I actually thought the way Larson was going with that he might try some weird stuff. Who knows? Nixx says, my biggest takeaway from the Vic case was Amazon Prime's deposition of Monica. She started off friendly and then completely broke her. It was masterfully done, and a similar approach should have been taken here. Yeah, again, if your only option is to be mean, don't have a man be mean to a woman. Understand? It's a bad look. It's a bad play. Contagion says, happy birthday, Mr. Noseman. You're officially my newest source for accurate and unbiased news and legal education. Question Bronca, official new co-host. He is
just a guest here, folks.
He's welcome to guest very, very frequently for sure. Ryu D says, happy birthday, Ricada. Thank you. Britt Cormeyer says, this feels like a classic Viva confession through projection. Have they used their witness to testify to anything and everything, but they are saying that the defense will do it? Or they have used their witnesses to testify to anything and everything, but they're saying that the defense will do that. Michael Schell, thank you for the pear sticker. Crimsoneer says, is it just me or is the judge absolutely pissed about a ruling being questioned in that manner? It's always a bold step, but sometimes you have to take it to tell the judge, I know you ruled on this, but let me tell you why you're wrong, and you need to change that ruling immediately before it prejudices our case. And they have to try it, but Frank has done that a couple times now. Well,
I wouldn't
Judge,
do it with that body language.
Yeah.
Okay,
Yeah.
please come forward. Would you stand?
Kathurga says, let's not forget the jury isn't well disposed to this guy who dragged them through excruciating days of direct testimony to begin with, and now he's yelling at a pretty woman in front of a jury.
In connection with this cause. Please take the witness.
Another character officer, I'm guessing.
Yeah.
Okay, please remove your mask. And would you please spell your full name, state and spell your full name?
Thomas Lauren Hall, ThomasLorenHall.
All right, the court reporter is taking down everything that's being said. So only one person can talk at a time. Wait until the question's finished before you answer. answer yes or no instead of shaking your head or saying.
Friend of mine
uh-huh
brought
or
me this
uh-uh.
for a birthday present.
If an
Basil
objection is
Hayden's
made,
toast.
stop talking immediately and don't answer the question
Very
unless I
excited to
tell
try
you
that
to.
later.
You can ask for clarification if you don't understand a question. Okay, counsel?
Thank you. Mr. Hall, how old a fellow are you?
23.
And where are you from?
Champlin, Minnesota.
Where'd you go to high school?
Champlin Park.
Do you have an occasion to know Kim Potter?
Yes.
How did you meet her?
I met her actually at my neighbor's house for the first time, probably about 11 years ago.
And did you become acquainted with her children as well?
Yes.
Are you friends with them?
Yes, I am.
How much time did you spend over the last 10 years with Ms. Potter, Kim Potter, former Officer Potter?
Just about every weekend.
Have you ever been in the military?
Yes, I was.
Which branch did you enroll in?
I was in the Army.
And what was your position in the Army?
I was a 25 uniform, which is a signal system support specialist.
Did you have what is called a security clearance in the Army?
Yes, I did.
What is that?
It pretty much gave me opportunity to be able to listen or tap into a lot of different things because I had a top secret security clearance, so I could be able to be briefed on different situations or scenarios that a lot of people aren't.
Were you eventually honorably discharged from the Army?
Yes, I was.
And what are you training to do right now?
I am training actually to be a diesel technician at the moment.
And when do you think you'll be done?
Good money there for a young man.
It's upcoming August.
And
Was
you
for
have a
me.
plan lined up, it sounds like.
Yes.
Okay. Well, during the time that you've spent with, well, I also wanted to ask you one thing. You wanted me to ask you, are you an Eagle Scout?
Yes, I am.
Okay. During the 10 years or so that you've known Officer Potter and her family, have you been able to obtain an opinion as to her reputation in the community for being law-abiding?
Yes, I have.
And what is that opinion?
Kim always looked at it as just because I'm an officer doesn't give me an opportunity to not have to abide the laws that I have to enforce. Everybody in this world is expected to obey the laws that are enforced by herself and anybody else.
Great answer.
Similarly, do you have an opinion based upon your 10 years or more of knowing her for her reputation in the community for being peaceful?
She has always been an extremely peaceful person. And no matter what was going on or what happened, she was always there to help you or help, de-escalate the situation to make it so both sides could understand where they were coming from. And she was always willing to help you out if you had a question on something regarding a situation you were in. She was a very peaceful person.
Kind of a second mother for you.
Yes.
Nice.
Eagle Scout, Army, hardworking diesel tech, known her forever. Nice young
After you,
man.
Mr. Hall. Just to clarify, your opinion is based on her reputation in the community, and that community would be Champlin, your block, your relationships with her children. Am I correct?
Yes.
All right. Not on the streets of Brooklyn Center.
No.
Thank you. No further questions.
There you go. That's I guess the best you can do with that.
He didn't want to be mean to a dude. I noticed that. An Army vet.
Yeah.
Might run across him someday in the future.
Thank you very much. You may step down.
Yeah, no further questions for him. I was kind of curious. Are you going to redirect on that one question? I mean,
Does the defense have any further witnesses? Okay.
2 more? Yeah, I think they're going to do the slip and capture witness tomorrow morning.
Hello, sir. Would you please come forward? And stand right
Oh, it'd
next
be
to me
great if they
behind
end
the
this
chair,
early today.
witness chair.
That'd make me so happy.
Yeah.
Go
Raise
spend
your
time
right
with my
hand.
kids for my birthday.
Do you swear on your penalty of perjury that you will truthfully
Is that Kyle Rittenhouse?
Got Rittenhouse in 20 years.
sit down, remove your mask, state your full name and spell it?
Frank, F-R-A-N-K, Roth, R-O-T-H.
Frank Dremen,
All
Police
right,
Squad.
a couple things. The court reporter is taking down everything that's being said. Therefore, you have to answer orally instead of shaking your head or saying uh-huh and uh-uh.
If the
Don't
chat
do that.
mentions the judge saying orally once, I will ban
Don't understand
you.
the question, ask for clarification. If an objection is made, you gotta stop talking immediately and don't answer the question unless I tell you to. And the final thing is, two people can't be talking at the same time, so you have to wait until the question is finished before you answer. Okay?
Very good.
All right, counsel.
Thank you, Your Honor. Mr. Roth, I understand you've had a career in law enforcement.
Yes, sir, I have.
Would you tell us where you first worked and then the part you ended your career in?
I started as a Robbinsdale police officer in December of 1982. I worked there for a little over 8 years, and then I was employed with the City of Brooklyn Center as a police officer from January of 1991 through August of 2015.
What rank did you achieve at the Brooklyn Center Police Department?
I achieved the rank of sergeant.
Do you know, in that capacity, former officer Kim Potter?
Yes, I do.
Were you her direct supervisor?
I was.
For how long?
Well, I met Kim when she first started in 2004, I believe, and I was an indirect supervisor for a number of years, and then I was her direct supervisor for approximately 10 years.
Do you have an estimate of how many hours you were her direct supervisor over those 10 years?
I do.
What would that be?
Well, it was a normal work year is 2,080, and it was about 1,800 hours a year for 10 years, so about 18,000 hours.
Nice.
And during that time, you got to know her pretty well.
I did.
You consider her a friend of yours.
I do.
Was she also involved in the DART program?
She was.
The Honor Guard?
She was a member of the Lima Honor Guard.
And the hostage negotiations team?
Yes, that's a unit that I supervised.
Volunteered for all of those?
Absolutely.
By the way, if you guys want me to try out this new Basil Hayden's toast, just
You
hit
had
that
a chance
like
to
button.
observe her in the community for
We'll
all
see
those
about
10
doing
years and have an understanding of what her reputation is in the community.
Yes, I did. We worked very close in Brooklyn Center. We're not a big agency by any means. So quite often the sergeants integrate with the officers many, many times during the course of a day on calls, the community type relations things, community outreach. I saw Kim in all those aspects.
So you work closely with her?
Very closely.
Well, I want to ask your opinion as to her reputation in the community.
I'm sorry, could you go again, please?
Given how long you worked with her, I wanted to ask you of your opinion as to her reputation in the community for being law-abiding.
It was sterling.
I wanted to also ask you, do you have a personal opinion as to whether she was law-abiding?
Yes, I do.
Same opinion?
It's the expectation that we have as being police officers. She was very good.
Do you have an opinion as to her reputation in the community for being peaceful?
Yes.
What is that opinion?
Kim was extremely peaceful through a lot of the stuff we did with the crisis negotiation, hostage negotiation unit. That was our goal, was peaceful ends to tragic situations.
Excellent.
And given the opportunity, Kim got peaceful resolutions.
And that's your personal opinion as well?
That's my personal and trained opinion as her supervisor.
Thank you very much.
All right, is there cross, Mr. Larson?
Her job was to get peaceful resolutions out of violent situations.
Mr. Roth, could you identify the year you retired? I didn't catch that.
2015.
2015. And I apologize if I said Mr. Roth. It's Sergeant Roth, correct?
You can call me Frank.
But during your career with Brooklyn Center, obviously Officer Potter was a coworker, a fellow police officer, and she worked for you.
Yes, I was her direct supervisor.
And, but in addition to that, though, you became friends.
Yes.
And you've been a strong supporter of her after this incident on April 11th, 2021.
Yes.
Indeed. Do you recall when the defendant sat down for an interview this fall with Star Tribune reporter Rochelle Olson, she had you right with her?
I was with her.
Yep. You were a witness to that interview.
Beyond the scope. The objection is sustained. It's beyond the scope.
She is someone that wanted you seated next to her for that interview.
Beyond the scope. It is beyond the scope.
No further questions.
Okay. All right. Thank you. You may step down.
Thank you, Your Honor.
Okay. Does the state have any further witnesses?
One more.
That's a good whiskey. Very light. It tastes cold. Maybe fruity.
Hi,
I'm not
sir.
good at this.
Please come forward, stand behind the witness chair, and raise your right hand. Do you swear under penalty of perjury that you will truthfully respond to questions related to this?
I do.
All right, please have a seat.
And would you please remove your mask? State your full name and spell it.
Samuel, Samuel, Ellsworth, Ellsworth, Smith, Smith, the second Roman numeral 2.
Seated in front of you is the court reporter. She's taking down everything that's being said in the courtroom. So we have to make a clear record. So answer questions with a yes or a no instead of shaking your head or saying uh-huh or uh-uh.
Yes, sir.
Only one person can talk at a time. Wait until the question's finished before you start answering. If an objection is made, stop talking immediately. Do not answer the question unless I tell you to. And if you don't understand a question, please ask for clarification.
Yes.
All right, counsel.
Officer Smith, you're in uniform today?
No, I'm not. I'm civilian clothes.
Is that a tie, I thought? No?
Yeah. Yes,
Okay, sorry. All right. You're originally from Burnsville, Minnesota.
correct.
I want to ask you about your law enforcement career. Did you start out in a city south of here?
Yes, sir. I started in Kansas City, Missouri in
And
2005.
about what year was that?
2005.
What were your initial duties and obligations down in Kansas City?
Patrol.
Was it for the city or a suburb down there?
No, for the city.
How long did you work in Kansas City?
I was sworn officer from 2006 till September of 2014.
And at that time, did you decide to make a move geographically in your life?
Yes.
And where did you move to?
First, we moved to Brooklyn Center and lived there for 1 year, and then we moved to outside suburb.
Did you find employment in Brooklyn Center?
Yes.
And when did you start with the Brooklyn Center Police Department?
September 1st of 2014.
Are you there right now?
Yes.
What were your initial duties with Brooklyn Center Police?
Patrol.
In the course of your employment with the Brooklyn Center Police Department, have you come in contact with former officer Kim Potter?
Yes.
And tell us about that.
When I started there, like I said, September 1st of 14, she was working, she was patrol, and I was actually starting my field training with other
Not that it should matter, but this is the world we live in. Prudent of the defense to have a couple character witnesses of color.
You did
Yep.
basic police work with
A
her
woman,
during these shifts, arrests, transport,
two
talk to her,
two of
interviews,
color.
all those things.
Yes.
And during the course of the 6 years or so, a little bit more than that, that you worked for her, did you
Also important to
gain
note,
an
The
opinion
state
as to her reputation in the community.
The state has not raised
Do you have an
race
opinion
in any
as
way,
to what
despite
her
the
reputation in
overwhelming
the
media
community is
narrative.
for the trait of being peaceful?
She is well respected and very peaceful, and she was very professional from when I worked with her.
Is that your personal opinion as well?
Yes.
Do you have an opinion as to her reputation in the community for being law-abiding?
Yes.
What is that?
And she's very law abiding.
Is that your personal opinion?
Yes.
Why?
Because in my time working with her, there are times where I was maybe upset with something, and she would counsel me or coach me that, policy says this, or, basically calm me down and instruct me that this is how policy is. So she was a calming force, with a lot of new officers.
No further questions. Thank you.
She's so law-abiding. She was correcting the cops.
Officer Smith, you mentioned that, in your opinion, Officer Fricky has a reputation for being peaceful and law-abiding. That's the law enforcement community?
I think you meant to say Officer Potter.
Officer Potter, you mean the reputation you're discussing is the reputation she had in the law enforcement community?
Can you restate the question?
You've testified that she had a reputation for being law-abiding and peaceful in the community. You're talking about the law enforcement community.
The law enforcement community and the city of Brooklyn Center.
Now, you worked patrol with her for 7 years?
I had been employed there for 7 years.
For 7 years, and you had worked on patrol with Officer Potter?
Directly and indirectly. I worked for the first few years. I worked from 6 p.m. to 6 a.m.
Okay.
I also worked what we refer to as power shift, 2 p.m. to 2 a.m. or 4 p.m. to 4 a.m. and early power cars from 8 a.m. to 8 p.m.
Did you have any other professional interaction with Officer Potter?
Just working, going on calls, and assisting when she was primary on calls.
Did you have any interaction with her with any other leadership roles that she had within the Brooklyn Center Police Department?
It is beyond the scope. The objection is sustained.
No further questions.
Okay, thank you. You may step down.
Defense was all over the scope on these witnesses.
We're trying to get to the union thing. Kick the door open on that.
I think so. I think we may have
Might be it for the day, huh?
Early adjournment. They probably don't want to bring in their expert to start. It's going to take longer than an hour. To
Oh,
get
they
through
said this is
direct
the last
cross.
witness.
Yeah. I mean, I think defense carries the day today pretty handily. The minor issues with their expert aside, I mean, overwhelmingly beneficial testimony for Kim. Nothing particularly harmful that I saw.
Okay, members of the jury, we're going to stop right now. We're almost done, okay? So we're going to have, the defense will have 2 witnesses on tomorrow. So I'm going to let you go tonight, and
Great.
we will start up at 9 o'clock, all right? Have a good night.
Slip and capture, and then Kim Potter
Yep.
to close out the trial. The defense will rest. Closing arguments will think they're going to wait till those till Friday. I don't know. They're probably only going to have 30 to 40 minute closing arguments. They could probably do it tomorrow. Depends on how.
That would be
long they're on the
awesome.
stand, but or wait, no, today's Thursday, so they may do closing on Monday. But they probably can.
2
do it
witnesses. They
tomorrow.
ought to be able to get 2. I mean, they ought to be able to get it done tomorrow.
They should be. But the judge also wanted a day, but like a complete day off between jury selection and opening argument. So who knows if she'll want the weekend before
Okay,
close.
Mr. Ng, you wanted to make a record.
Oh, he's going to do his offer of proof on Dante's fleeing.
Thank you, Your Honor. we would move for admission as a court exhibit the video of Colleen Fricky that you've, in your discretion, not allowed us to put it in, but I would like to, we object to your ruling, and I would like to make that a court exhibit, and I'll have Ms. Montgomery give it to your clerk. I assume without objection, just for the court's record.
Yes, we'll make it a court exhibit. Do you have a number? Okay, we do have it.
Oh, yeah, okay. Well, then the second reason I wanted to take a moment of your time is that yesterday we had extensive discussions about the parameters of Rule 703, and the court ruled that we could not cross-examine Seth Stoughton on his opinion that Mr. Wright would be peacefully arrested in a short order. I'm paraphrasing, but that's the way I heard it anyway. And the court declined our effort to cross-examine him on specific instances where Mr. Wright failed to appear or would run away or escape and be difficult to find. And at the time, I asked to leave the court to make an offer of proof so the record is complete as to what we would have asked him about had we been able to do that. And we do object to your ruling in all due respect. But I do want to make an offer of proof. The offer of proof is that Mr. Wright has repeatedly failed to appear in court. Therefore, he was difficult to find. There have been bench warrants for his arrest in a number of cases for failing to appear. The cases are 27 CR 19, 2754. The next case is 27 CR 19, 22959. Next case is 27 CR 19.
27 is the court, CR is criminal, 19 is
Another
the
one is
year,
27
and then the
CR
case number.
19-23818. Another one is 27 CR 19-24205. The primary case that we're relying on is that only a month before his death, Mr. Wright was charged with a complaint of carrying a pistol without a permit. And the incident happened on June 30th of 2020 at 16:04 hours, according to the police reports. The police responded to, I'll just quote it, it responded to a person with a gun call near 51st and Bryant Avenue North, Minneapolis, Hennepin County. The caller indicated that a light complexed 17-year-old black male wearing black shirt and shorts and white shoes was waving a black handgun. The male then got into a white Toyota Camry occupied by 4 people, with the driver wearing a red shirt. Officers located the car nearby with a person defendant herein, Dante Demetrius Wright, matching the person with the gun's description, sitting in the back seat. Once out of the vehicle, defendant took off running with officers in pursuit and managed to evade officers. Officers at the scene positively identified defendant from prior interactions. A loaded Ruger .45 caliber handgun matching the caller's description was found on the floor of the vehicle where the defendant had been sitting. Another occupant of the vehicle verified it was defendant's gun. Defendant does not have a permit to carry the firearm. This evidence would have been used in cross-examination to refute the expert's opinion that Mr. Wright would have been easily captured or found when his behavior in this instance was to run away. We have other instances of crimes of violence from him that would rebut Mr. Stoughton's thought that he was going to be peacefully arrested. He was charged, Mr. Wright was, with aggravated robbery in the first degree on December 4th, 2019. The case number is 27 CR 19-29850.
Probably robbery with a gun.
Pending when he was stopped by Officer Lucky. And that again shows that he had a motive to flee to avoid arrest on that particular charge. The facts of that case are rather gruesome, and that is the one where he stayed overnight at a young woman's house and robbed her at gunpoint in the morning after that. This is recounted in my defendant's response to the state's memorandum in opposition to its pretrial motions, I incorporate by reference my brief, which outlines all the instances that I've referenced here.
That's a thick brief.
We also have instances of violence for Mr. Wright, and that he's been charged in 2 civil complaints, one in 27 CV 216193, where he shot an individual in the leg and assaulted that individual's face and robbed him. And then there was another complaint where he shot someone in the head. I believe that complaint is 27 CV 217390. And the reason we wanted
I thought he was a good boy.
is that we needed to rebut.
It's only 2 shootings.
Inference that Mr. Wright has been a peaceful individual, and that we appreciate the loss of him by his family and the loss of anybody. But the image of him as being somehow law-abiding and in all ways terrific is undercut by some of his criminal behavior. And so to give the jury a fair image of him and a picture of the facts as we know them today, we would have cross-examined Mr. Stoughton on all of these, and he would have either admitted that he never saw any of it, and he should have, or if he saw it, it never got in his report. So that is the offer of proof. And again, we respectfully disagree with your ruling. I'm not here to grandstand, but I do want to make the record, and I have.
Okay. And you have made the record, and I stand by my original ruling. Any bad acts by Mr. Wright that Officer Potter was aware of, I allowed in, but she was not aware of all these other matters.
That's
The
not the
issue in
question.
this case is Officer Potter's mens rea, or state of mind, when she approached Dante Wright.
But
at
the
that
expert
stop.
testified to what her state of mind should have
And
been.
logically, anything she knew about him,
Also testified that Wright would be easily recaptured at a later date.
how to approach it. These things were not within her knowledge. Okay. All right. Is there anything else we need to put on the record? Oh, one other thing. I'm going to finalize the jury instructions this afternoon, and when I get them done, I'll have Zach email them to you tonight. Okay. I should probably
What up,
take
Zach?
about an hour. I do want you to know, just so you're thinking.
Going to finalize them before deliberations, huh?
that I believe a definition of reasonable force that incorporates the definitions that the experts have acknowledged are controlling a reasonable officer, given the totality of the circumstances, something to that effect. I'll send it to you, and we can debate it tomorrow. I also want to.
If anybody in
alert
that
you
courthouse is watching this channel,
I
it's
have
Zach.
thought about Mr. Ng's request for an additional instruction on authorized use of force, in addition to the authorized use of deadly force that both parties submitted. And I am going to allow an instruction to that effect, because there's been so much discussion about this taser.
Yep.
Had the state not disputed Officer Potter's intended use of the taser, this wouldn't be a problem. But the state's expert was of the opinion that even a taser was not appropriate or reasonable under
Good
the
job, Stoughton.
circumstances. Obviously, the reasonable use of force
Whoops.
instruction would only relate to the taser, not the gun. So it won't constitute a complete defense to the charge, because here a person was killed by a gun. So I just want to alert that issue, and if anybody has any comments about that now, I can hear them, or I can hear more detailed argument after.
Like the state won't have comment. Frank, of course, has to say something.
Yeah.
Okay.
Oh, no, he'll
All
wait
right.
to see the
Is
draft.
there anything else we need to put on the record? All right, thank you.
All right. Well, you're in luck, birthday boy.
Yeah. What a day. What a day. That there is actually, so she said it wouldn't be a complete defense, but I mean, of course, the jury is going to read that they're going to read that instruction likely and see if she reasonably would have used the taser, then they can find not guilty. I mean, that's
authorized use of force.
Yeah, that's what it's going to come down to. Good move by the defense, bringing that up. Bad move by the state for focusing literally days on the taser. I mean, they spent so much time on that testimony.
It was
that
so
that's
weird
bringing it up.
the way they left nothing on the table, right? There was no use of force by Kim Potter that could be reasonable in the circumstances. What you want to do is you want to leave one option that you say would have been reasonable. She just didn't pick that one. If only she had done this, it would have been okay, but she didn't choose to do that. Instead, they left with the only option is, well, you can let him run.
And even if the only option is that she could have used the taser, and she'll say it was a mistake, but, and you make this on close, she'll say it was a mistake, but who makes that mistake? It's on the opposite side of her body. She's trained to draw it with her other hand. It's a taser. It's not a gun. It doesn't look like a gun. It doesn't feel like a gun. It's lighter than a gun. She knows she's not pulling that taser, or she should have known she's not pulling that taser. But they didn't make that case now. Now they're going to have to argue on the jury instructions that she couldn't even draw the taser. And the jury's going to be sitting there going, wait a minute, then what's she supposed to do? Which they've never provided that alternative. Of course, they couldn't say she should have pepper sprayed him because that would have been ludicrous. I guess their best bet would have been to say she should have stayed in that car, or she should have helped in the struggle, right? She could have grabbed his leg. She could have helped pull him out of the car with two officers. They definitely could have gotten him. Officer Johnson could have pushed or whatever, like he's in labor. Whatever they have to do, they could have crafted a narrative for the jury to believe, and they have not done so through testimony here. And they likely won't be able to do that on cross because they haven't gotten it out of an expert or even a lay witness who has training and experience commensurate with the activity. So they've got the state has a real problem in proving their case based on the jury instructions that are to come. And I think, I mean, while I think justification of deadly force is there, I think it's easy for a jury to say, no, she should not have used deadly force. And since she used deadly force, therefore she's guilty. They could have done that. Now they have to consider the other force in addition to the deadly force.
Yeah, I mean, the difficulty with the deadly force, of course, is that it was unintentional. And as far as they're concerned, a young man with a clean record who was a nice son and father of a new baby died. So someone should be held accountable for that, right? They don't know all this stuff about his criminal record and so forth.
Yep.
So that can be a sticking point unless you give them some other option to arrive at a not guilty verdict, which appears to now be in place.
Yeah. So I thought the defense's case was better than the state's going into this. After a day of state defense witness testimony, I'm thoroughly reinforced in that fact. The state's expert, as much as he was mildly damaging to the defense's case, but that has been completely, in my opinion, undone by the defense's expert.
And who do we have left? We have slip and capture guy, and the state had no expert of their own against slip and capture, right? Stoughton was a police policy guy, not a psychologist. And then we have Kim Potter herself. So as long as those two don't, poop the bed, the defense should be in pretty good condition going into closing and deliberations.
Yeah, and to put in perspective the slip and capture guy to the chat, the jury is going to basically be under the impression that there's a guy who's an expert on making mistakes in high intensity situations. And he's going to testify that Kim Potter's mistake was not only was trained against specifically, but still happens. That's the likely testimony here, that this is why they spend a bunch of time training against it, because the only thing departments can try and do is mitigate instances like this, because it's knowable that this will eventually happen. Given a timeline someone is going to make this type of mistake and tragedy will occur. It's never that person's fault. It's a math equation. However they present this testimony, that's the gist of it.
You have
And
enough police interactions with the public. This is going to happen X number of times, no matter how much you train.
And it's always tragic, but we can't put police behind bars for mistakes because that would be ridiculous. And the jury's going to be sitting there going, and the state doesn't have anyone to say anything opposed to that. All they're going to try and do is have him impeach himself on cross. They could have gotten a slip and capture expert to say this isn't that type of mistake. There are factors here. Her training overrides that sort of thing. She had such recent training. I mean, her training on this was March 26th. This is April 11th. I mean, they could make the claim that she so recently went through 8 hours of training, a full day of this. Normally she gets a 1 hour refresher course every year, but a full day of training. There's no way a reasonable person makes this mistake. It had to be something else. It had to be her consciously creating this environment in which she would draw the gun instead of a taser. They didn't do it. They didn't do that. And so that's that. And then Potter is going to be the closeout, and Potter's going to offer probably very emotional testimony about how much she regrets everything, how it was a mistake, how in 26 years she's never had anything even close to this happen, and it's the blister on an otherwise solid career of good service to the community, and she wishes anything else but what have happened that day. And the jury's going to just sit there and go, yeah. And the state's going to what? Like try and be mean to her? Good luck.
Oh my God. Are they going to put Larson on cross?
Oh, I hope so. Please put Larson on cross. If they have any brains at all, they put, I don't remember the female attorney's name.
Erin Eldridge.
If they have any brains at all, they put Erin Eldridge on cross to immediately sympathize with her. Right. Like, this is, you endured a hard thing, but this isn't about you, is it?
Yeah. And then she'll ramp up. By the end, she'll be saying, but you killed him, right? You killed him. Your bullet from your gun. You killed him. You killed his 20-year-old father of a newborn baby. Isn't that what happened?
You had an obligation to the community to protect them, and you failed in that obligation, didn't you?
Right. Is your legal duty to not shoot people that don't need to be shot?
Wouldn't you agree that serving and protecting people doesn't include killing them? I mean, that's where they should go with it if they have any brains, I guess. But if they have Larson do it, I'm just going to laugh. That would be terrific. What a mess. Okay. Well, I am going to read super chats, finish this up, and then we're going to wrap up the stream. If you want to hang out for super chats, you're certainly welcome to.
I'd like to. Could I pitch the class and book one more time so we can exit quick at the end of Super Chats? So
100%.
Law of Self-Defense Advanced class happening Saturday, January 8th, 2022. We do this class once every year and a half. It's a full day live class on self-defense law taught in plain English by me. If self-defense law is something you'd like to have a mastery of, this would be the time to do it in a single day. You can learn more about that at lawofselfdefense.com/advanced. And you can also get hard. That is our hardcover book, The Law of Self-Defense Principles, at lawofselfdefense.com/get-hard. And these are autographed.
Now, the other night you mentioned something, and if possible, I'm gonna hold you to it. If you think this is feasible, I'm going to give you the opportunity to say, well,
the other night was it an adult beverage night?
Yes.
Okay. God knows what I might have said. All right.
I am going to be ordering 25, I think it's 25 prosecutors in the Kenosha County office. I'm going to be ordering a book, a Law of Self-Defense book for every single prosecutor in the Kenosha County office. And I would love the opportunity to deliver them in person. And you mentioned that you may be willing to actually travel out to Wisconsin for the delivery of those books.
We're going to film it or capture it somehow?
Yeah,
okay.
This would be a buddy cop stream.
Okay. All right.
We do it live, likely.
Yeah. Okay. All right. Yeah, I'm in.
Okay. It's going to be after the new year, right? Like this is not going to happen prior to Christmas. You have to get the books in. We have to schedule it. But that's the plan right now. And we'll make this happen. And of course, just one final plug for the Law of Self-Defense course, the lawofselfdefense.com/advanced. you have a unique opportunity because both Thomas Claire Binger and James Krause are registered participants of the class. I have gifted each of them a registration to the class, and I believe that they need a refresher on the principles of self-defense. So it is possible if you take this class that you will be on the same call as Thomas Claire Binger and James Krause. So if that is some encouragement for you guys enrolling in the class, I would strongly recommend it. Plus, it's Andrew. You've heard him on the show several times, and nothing but expertise coming out about self-defense matters, and that's who you want to hear from on these issues. So, all right, let's kick it into overdrive on these super chats, and then we'll wrap up the show early today. B.A. Krim says, Krause suit jacket alert. Fran Moore says, is the defense always required to give so much disclosure to the prosecution? Yes. Why does the DA need that info if they have a solid case? Good question. But it's some weird notion of fair play, despite the fact that the state is never playing fair. By nature of being the state, they cannot play fair. But they have determined that they need some fairness rules, and that's how it goes. Elizabeth,
folks, my class is interactive. There's live Q&A. It's on Zoom, so you're not on camera, but you can send me questions in real time. I'll answer them. Every hour we take a 10-minute break. I'll answer questions during those breaks.
Perfect. Elizabeth Stoddard, thank you for the donation. Rose Bibe says, for the Bronca book scheme, also happy birthday, Andrew and Nick. Andrew, prayers for your wife.
Thank you.
Yes, that's going into next week. You will probably not be present for this stuff because you'll be spending some time with her.
Definitely not Monday. After that, I just have to play it by ear.
Right. Well, you are welcome here, but please give my thoughts and well wishes to your wife.
I appreciate that. It doesn't appear to be a dire situation. We're confident of a good outcome. So
absolutely. Zin Cicada says, in my spare time, I'm Batman. Oh, that's for the defense expert. Steve C says, just Chad. James G says, prosecution will need to check their depends on the break. David Delsberger says, not only drove, but drove through the wind and rain that went through Missouri and Iowa and caused fires in Kansas.
Drove through the tornado. That's why the tornadoes happened.
Yeah, the tornadoes happened as he was driving through in the wake of His Majesty. Brian says the best day to be stuck having an infusion is while expert Chad is on the stand. As always, thanks for the panel. Hey, thank you, Brian. Jay Griff says defense expert, local man, too base to retire. Tall Skinny Geek says start every question with over the 10,600 days you've done police work. ... Teach says this dude is based 64, just had heart surgery last week and drove for free to this trial. But my 54 pages. Blue-eyed Roof Curry in the base says, use of force expert is Wyatt Earp reincarnated. Chryson says, please ask him if he skipped to do some training. Mandy says, damn, the defense came out swinging hard. Open heart Chad whipping his resume out on the table for all to see. The funny thing is they made a big deal out of the one guy's statement being 54 pages and this guy's statement being whatever. I wonder how many pages were dedicated to the CV of the state's expert. Because we saw in the Rittenhouse trial, the John Black CV was included in his report. It was the first 13 pages of his report. So I wonder if the state's expert dropped, a 10-page resume at the beginning of his 54-page report, whereas this guy didn't even include it in his report itself.
Right.
Warren Lee says, have you ever consulted for Portland PD? No, sir. Have you seen that cesspool? Toby Jean Almy says, base James Bond from Missouri. Oh my God, it's Dana. Welcome to Paralegal Status. Thank you for joining. Webb says, you had surgery recently? Yep, open heart last week. Still open, by the way. Did it myself on the walk up here to Minnesota. Next question. Hannah Sanders says, this man is 100% Missouri. Oh my God, it's Dana says, please cut his qualifications into a short. This dude is the cop of all cops. Again, I'm sitting there thinking, how do you squeeze this into a mere 44 years? I mean, you're going to, maybe that's, I think that's part of what the state strategy was in the cross-examination is, wait, so you were in Uganda, then the UK, then Tunisia, then Tanzania, then Belarus or whatever. Like they're going through. It's like, how did you have the time to do police work? Is what they're wanting to ask. And he's probably thinking, well, those were my weekends, right? I just shot across the pond after a 24-hour shift going into Thursday morning, and then got back ready to do my shift for Monday. Squizgar says this guy's the definition of Chad. Nicholas Gay says this guy's most importantly keeping the jury awake and engaged. I agree. Stuff and Stuff says I bet he can believe it's not butter. Not applicable says shot the bad guy through the hostage. Same bullet. Broken Glass says Chuck Norris fears this expert witness. Eric Nervik says, do you teach classes on report writing? No, sir. I prefer women. Chad Rorick says Daily Wire should make a movie about this guy's life. Loretta Silvermember says this is the first time the jury is probably interested in what's being said in this case. He definitely has their attention. JK the Slacker says Stephen Iams is a hero, even if he does pronounce Missouri wrong. Evan Bouchon says, I object to this witness annihilating my entire case and making me and my expert look like complete morons in the process, quoting Frank. Evan Bouchon says, I'm going to write a buddy cop show about Detective Chad and Officer Bay. Ubi1 says, can I just highlight this comment? My dumb movie said, this guy has chunks of Chuck Norris in his poo. Oh, gross. Jonas While the Fourth says, Chuck Norris, never heard of her. Neighbor, no, come on, man. Look, Chuck Norris is here with me. I got to meet him when I was like 5-6 years old. And I got to meet him again a couple years ago at Bubba Fest. It was great. And I had him sign again my picture of us meeting when I was a little tyke. Nabor says, while watching this first guy at testimony, I saw a bald eagle fly over me and I shed a single tear. What a legendary beast of a man. Wilder's Honey says, I guess Nick's nose judgment was correct. That's right. I correctly predicted you could trust that man due to the slope of his nose. Matt says, Daddy Cop and Mommy Judge in Kim Potter and the Terrifying Taser, The Trial Before Christmas, Right Through the Heart, Chinatown 2, Whispers of Seduction, Kama Sutra, Day in the Life of Earl Grey. Nabor 605 says, this dude drove through December tornado damage and winter storms to give free testimony for the justified right to freedom. Feels patriotic, man. Oh my God, Trey says, happy birthday, Nose. Thank you. Travis Delaney says, do you think they put this guy on first because the jury isn't bored yet and will actually pay attention to his experience and opinion? I didn't think they came out swinging. I mean, I think that's the strategy here. The defense or the state led with the mom. They led with this emotional play. They put their best, and frankly, that's their best foot. They put their best foot forward, and then they tried to sandwich in the expert and then the dad at the end. And they put a whole bunch of filler crap in the middle to get statements that they can use on closing argument. But, the defense comes out swinging. We've got an expert that's better than yours right after yours. And then we're going to bring in the police chief who has more experience than your expert will ever have. And then finally, they pad out with some character witnesses. Wham, bam, bam. By the way, those 3 witnesses took a combined 30 minutes.
Right.
And then they're going to close out with another expert and the officer. Contrast it with bringing in the actual fluffery that was going on in the state's case. The defense is going to be done in 2 days. The state took 5 days of testimony.
DNA analysis and ballistics and car crash testimony.
Yeah, as if anybody is contesting that she's the one who fired the shot that's on video. Just insane. Jonas Weil, the 4th says Cross is going to be so awesome. Johnny Osprey says the difference between a bullshitter and a professional is obvious here. Dirty Wop Bastard says you need to cover Daniel Perry case in Texas. Dan C says pie or cake. I go apple pie personally. I love apple pie. Bucky Cat says happy birthday and Merry Christmas, raccoon killer. Yes. I live in the country and I have outdoor cats. I have put to rest many raccoons. I would prefer not to, but they can be a menace. Don't worry, there are plenty more where they came from. Shinobi Assault says the other expert gave off a slimy vibe even before the pay amount came up. This expert comes across genuine and informative.
Yeah, I'd be wondering what people think about that guy who haven't seen him before, because I've seen him before, so I already don't like him. So when I see he's the expert, I have a kind of a visceral negative response. But it's always hard to tell how the jury who's seeing him for the first time, how he comes across.
I can tell you how I felt. I've never seen him before. I haven't analyzed any cases he's done. He looked like someone you would see on TikTok offering their opinion on the case, right? Like he's like weirdly dressed. He looks too young, and I think it's not fair, but it's a detriment to expert testimony if you look really young, unless you're testifying on computers or high technology issues. He doesn't look like a guy who can tell me about use of force in a police situation. He's small, and he came across weaselly or slimy. So, and again, most of that is unfair, but it doesn't mean I didn't see it. Like if I show up, right, to testify on police use of force, and I could do a whole bunch of training and certification, become an expert on it. But if I show up, I'm a slender guy. I've got small, weak, frail baby arms. If I'm there, and then you get this 64-year-old mountain of a man coming in right behind me, like there's no comparison. I wouldn't purport to show up as an expert because I don't look like an expert on use of force in police situations. I don't look like a cop. I've never been in the military. I don't have that build, and it would be detrimental to the analysis as it's being conveyed to the jury. And that's how I felt immediately with that guy. And then when his CV came in, it's like, wait, you spent 5 years doing some police work, and then the rest of your career has been just writing academic papers, and basically all of them against the use of force entirely. How am I supposed to take you seriously? C. Neal says, prosecutors, I object, Your Honor. The witness is devastating to our case. Matthew Self says, police god Chad. Jason Dalen says, this guy would save your life if the prosecutor save your life. The prosecution's expert would get you killed. Legitimately, yes.
Yep.
John Williams says, turns out I wrote the textbook since you asked.
It's like that meme, who would you have rescue you? You know, and they have John Wick and all these various action characters. This guy's picture should be in that mix.
Yeah, and then or your other option is a list of CNBC journalists or whatever. On-screen talent, Joe Scarborough. John Williams says, turns out I wrote the textbook. Job for 9 says, may health and wealth continue in the coming years. God bless and congrats. Thank you. Tyler Whale says, this witness's strength is speaking in lay terms for people and not lofty academic jargon for the cameras. Cough, stot, and cough. Kenneth Reese says, I had a partner officer who shot OC in his clam chowder and quickly that OC isn't the same as hot sauce. So pepper spray, I guess, right?
Right.
Lol, he learned quickly that it is not the same as hot sauce. He never did that again. Whew. Greg Palmer says, my opinion is having the defendant masked dehumanizes them to a degree. Is that significant? It's a significant thing. Agree? Yeah, I don't agree with masks in the courtroom at all. I think they're terrible. I don't think they should be allowed personally. Ma N says, this expert is impeccable, but if the jury is distrusting of police, they will really distrust this guy. He is uber cop. Fran Moore says, was Nate saying the witness isn't smart enough to be a house mouse? Lol. No, he's just saying when they identify particular, people call it intelligence or smart, but what they mean is a particular manner of thinking. For example, in a completely different context, when I worked overnights at Target early on in my post-college life, they quickly identified people who would be able to categorize things in a more complex way for the stocking of shelves. And so they took them off of the main floor where the stocking was pretty obvious with merchandising the way it is. And they moved them into the back where the stocking was more convoluted. It doesn't mean that you're particularly smarter than anyone. It means that you think in a different and more organized way that's suited to the task. I think that's what Nate is saying here. There's some people who are more suited to writing reports. They're good at writing. They're good at organizing and collating information in that way. And then there are other people who are good at practical applications of the same concepts.
There's another dynamic too. I mean, a lot of people get hired as cops who, only a small portion of a cop's job involves potential violence. So there's a lot of aspects of a cop's job that don't involve potential violence, and there are people who are not good or comfortable with violence, but they may have been hired by a department anyway. So you put them in kind of an administrative or community role where they're not going to be getting into fistfights with people in the street because they're not well suited to that. And then you take the guys who don't mind getting into a fistfight and you make them your patrol officers.
Kim Potter is probably an example of the former, right?
Yeah, right.
That's kind of the evidence we have. She's a smaller built woman. She's not like rail thin or anything, but she's short. She's not high body mass. She's not going to be able to topple over a 200-pound guy very easily. And she has a reputation for peacefulness.
Ideally, Major Johnson is who you have as your street cop.
Right. William Barnes says, if you flee or resist, you waive your right to a fair trial and sentencing. You consent to cop being judge, jury, and executioner. They should bury you. I don't go quite that far, but I get the perspective. Bane Man says, the guy yesterday was someone who's only read The Art of War by Sun Tzu. This guy today is just Sun Tzu. 200 Watt Studio says, this use of force guy is basically Dirty Harry and Magnum Force. The Reddit Silver member says his heart attacked him and lost. John Ridgway says, IAMS also volunteers in Haiti. He does. He literally does in Haitian orphanages. The worst response the state could have gotten on. Well, you also do stuff for this charity. That's security, right? No, I just help. I help orphans, and that's not charity related, or that's not security related. That's just me helping orphans. God. Ryan Ropke says that expert is Chuck Norris's fraternal twin. Brian Edwards says, happy birthday and welcome to the Old Man Club. Joined in June myself. Hey, thank you, Brian. Happy to be here, honestly. TLJ Screwjob says, happy birthday, Nick. Thanks for entertaining all the way back since the Vic stuff. Sorry if that makes you feel older, realizing that was 2 years ago. Almost 3. It was almost 3 years ago. John Burton says, this issue, in my opinion, is we manage by metrics. A criminal prosecutor is considered successful based on number of convictions. Any case prosecuted with no conviction is a loss in their mind. And the reason it is that way is because so often they're correct in their convictions. As we've discussed, the overwhelming majority of criminal defendants are guilty. And that's why the conviction rate is what it is, upward north of 80%, something like that.
They have a lot of cases to pick from, folks. They have a lot of cases. There's a lot of crime in America. And they got a big stack of files on their desk, and they can just, the weaker ones, they can plea out or not charge at all if they feel like it. They still got plenty of easy wins in that stack.
Yep. They as discussed before, they're controlling all of this. They're in control of the system, the pace, the process, all of that. The only objections that show up are the defense's minor right to plead for a speedy trial. But a speedy trial is presumed to be something like 60 days from the time it's raised. And then it can easily extend to 180 to 365 days based on the court's circumstances and calendar. So there's not much they can do to control it. But the other aspect of that is, and that's why the defense is not measured by their success, because again, in the same way, the overwhelming majority of your clients are going to be guilty. So success could be a guilty plea with a mitigating sentence. I mean, that could be very, very successful and beneficial to your client. For example, briefly, the case where I did the guilty plea for the criminal sexual conduct charge, that guy pled guilty to 12 years in prison. The alternative to that guy was 48 years or more in prison. They easily had aggravating factors to double the 24-year sentence, and they could have gone as high as tripling, and probably gotten it, especially from the judge that was in that case. The judge had determined that guy was guilty at his first hearing, which I thought was improper, even though the guy was ultimately guilty. The judge's entire demeanor in that case was wholly prejudicial to the guy. He almost certainly would have tripled the charge if given the opportunity. So pleading it down to 12 years was a big benefit to that guy.
I see people commenting here that maybe Kim Potter went to the taser, went to the gun because she's not a man the size and strength of a Major Johnson. And that could be true, folks. It may well be that if all our police officers were large, muscular men who were not afraid of getting it on in a fight on the streets, that we'd actually have a lot less use of weapons and guns in these confrontations. They would just physically overpower the suspects. But the fact that that may be true doesn't matter because we don't live in that world. We don't. When I was a kid, most of the cops looked like that. And if a cop was smaller, it was because he was even tougher than the big guys. But we live in a world where, as far as the authorities are concerned, the government's concerned, anybody can be a cop if they can pass the test and some kind of modified physical. And we end up with the, dare I say, diversity of officers that we have in the real world.
Right. And again, the other interesting point you brought up is there's lots of police work that can be done by people who can't pass the same type of physical stature as you would want a patrol or beat cop, right? You want an Officer Johnson. You want a guy who's 6'2", 215 pounds, in decent shape, out there handling himself and handling other people. There's plenty of other police activities that can be done by these people, but that's not the world we live in anymore. That's not fair, apparently. Abe Eckstein says the defense expert witness should become the next CBP chief boss of a next CBP chief boss of a dude. I don't know what CBP is.
Border Control? Is that
Customs and Border Patrol? Oh yeah, it could be Customs and Border Patrol. NB Watke says, why has nobody asked experts from either side the danger presented by Wright putting the car in reverse and hitting the gas with both doors open? That ended up happening, and it was objected to as outside the scope, I think, of the expert's testimony. But it was brought up by to the police chief later on. So that was good. DD says, thank you, Nick. Thank you, Andrea. Love all the knowledge you share. Hey, thank you, buddy. Conserva Knitter says, happy birthday. Welcome to the club. Hey, thank you. John Ridgway says, this guy should be running the FBI. Decaf Geek says, happy birthday, Nick. Welcome to the Boomer Club from an older boomer than you. Michael Waldner says, happy birthday, Nick. Loving the new daytime content. Please keep it coming. Like I said, when I'm doing trials, it will be this format. When I'm doing non-trials, it'll still be like 1 to 4, 3 hour daytime show. Z. Michael Gelke says, is the witness crossing the lawyer? Yes, that actually happened. That was great. Mike P says, this expert witness is basically the equivalent of the God Emperor of that Space Marine behind you. Nabor says, this dude is the literal Team America World Police. He was. Razor 390 says, Nick, you are right. However, most, if not all, PDs require anyone in a law enforcement capacity to, quote, pay their dues as best / patrol cops, beat / patrol cops before going into other specialized units, unless you're talking about civilian employees of PD. Just because it is a way doesn't mean it needs to be a way. The only reason it is that way is because of sentiments about discrimination. D. What says, happy birthday, Nose. Thank you. America Float says, could the state lose simply by going for 2 weeks? If I was on the jury, I'd think it wasn't concise and succinct enough for a case to be strong. Yes.
No respect for the jury at all.
Yep.
State.
And some interesting and maybe controversial opinion I saw on Twitter from another attorney, a criminal defense attorney who's retired now, said no respect for the jury by the judge, that the judge should have limited the cumulative testimony that was going on. And I agree.
Yep.
I
100%.
agree with that. Jay Griff says, in Frank's defense, geography is dumb. I only need to know where the USA is, baby. NB Watke says, I'm trying to make him seem derelict as police chief while doing all these external things is not being top cop. Yeah, except it falls flat. That just did not come across from their cross. Rick Van Luvender says, ADA Frank's internal thoughts. I'm going to impeach the defense expert witness by showing the jury how much of an expert he actually is. Evan Bouchong says, Frank to Detective Chad, you want to go out sometime? Wilder's Honey says, there better be memes of Super Chad. Dermy Wormy says, this expert perfectly exemplifies the Plains states, even though he is from the lesser state of Missouri and not Kansas. Yes, I spelled it that way. Jefferson C. Post says, Frank, what qualifies you? Stephen Iams, I am the law. Pride or Honesty says, I really hope I'm not the only one who can't stop pronouncing it Rakisha law. Lee Nicholas says, older age didn't give this expert witness a receding hairline. He chose it. He also says, the state, what are your qualifications? Iams, yes. Mathiadon says, good grief, the state is slimy scum. Dan the Lion says, I'm a 15-year veteran with LAPD, almost all of it working in the streets. I would love to give you my insights on uses of force. Where can I DM you? You can DM me on Twitter, or you can go ahead and email me. That I've had a couple use of force trainers and police officers express interest, and I'd be happy to put that show together at some point. So you can email me if you want to do that, Dan. Thank you for reaching out. Email's in the description if you scroll down. Red Dragon 412 says it was smart of the defense to call IAMS first. Prosecution just said that he didn't see the report until 10 p.m. He's either exhausted or unprepared. Unknown says, I love how they define tasing someone as energizing them. Distro 32 says, I really like this expert because I, as a layman, can understand exactly what he is saying. In Time says, great panel. Love when you have Nate on, but I learned from all of them. Thank you so much for this. Bogey 34 says, between Fluster and Fluffer, I'm really starting to develop an anti-prosecutor bias. Scully says, this is making him look like an ass to the jury. Dreamcast Hub says, happy birthday to your nose and the human attached that makes trials fun. Griff Time, got a Dreamcast YouTube channel where I review obscure games and hardware. Always love to listen while I edit. That's Dreamcast Hub, guys. Check him out. Jason Wengler says, I heard this expert guy had a beard, shaved it, and Chuck Norris popped out and said, teach me your ways, master. Brian Sitka says, I knew the state's use of force expert was a farce when he said he was slower than the average bear. First of all, he's more of a weasel. Am I right? Mark Ramirez says, hey, Nick, can you ask Natalie to come back on and talk about what she thought about the testimony of the weasel? I think it would be interesting. Natalie is a practicing defense attorney with apparently a very active practice. She is client meetings, trials, and hearings and motion practice all the time. You guys may not know that, but she's stated that in our private chat. She has the invitation to come on to any of these panels. And, but she is extremely, extremely busy doing real defense work out there. So she'd be welcome to, but I can't impose on her actual day job career. Crimsoneer says, just ask what is the extension of the car to the officer's right, and what would happen if Dante puts the car in reverse. Dapper Dave says, let's compare credentials of experts, shall we? Charles Argo says, on the gear shift, reverse is the next down from park, so he could easily have gone backwards. The doors were open and would have injured the officers. I think they could have made that clear to the judge and said, hey, we're not saying he was necessarily going to do that, but that he could do that.
It's a risk.
It is a risk that that Officer Potter needed to consider. It's in her state of mind, and that should be allowable as evidence. But again, they ended up getting it in anyway, so it didn't matter. But Adam Riley says, legend is the expert witness and Kyle's judge wrote the first laws for Moses atop Mount Sinai. Jeffrey Grajic, a suggestion for the state's crossed. First law of hole, stop digging. Ortelio says, Recato Law, Your Honor, this expert witness does not say what I want him to as a prosecutor, so I don't like him. Ben Cheever says, I'm way late, but Stephen Iams seems like a really good person. He could command way more than that prof prick, and he's interested in the truth. Brad Hobbs says, prosecution missed opportunity to ask about post-operative drugs from major procedure. That's true. They did miss that. You just had a major medical procedure.
Well, don't ask the question you don't know the answer to. He might have said, well, I didn't need any.
Yeah. They offered me anesthetic, but I wanted to be clear-headed for this trial. Wasn't concerned about it. So instead I just played online slot machines on my phone while I was in the hospital. Andrew Rohn says, I was always excited to share a birthday with Billy Gibbons. Now I find out I share a birthday with the distinguished Nick Recato. Happy birthday, good sir. Happy birthday to you, Andrew Rohn. Very cool. Crimson Ear says, Nate, your camera keeps dropping frames harder than this prosecution is dropping the ball in their own case. We are limited by the love of the internet. Bogey says, created decades ago in secret Apple lab. He is James. Glenn Kirk, welcome to Paralegal Status. Thank you. Robert Gorchianas says, all of this could have been avoided with a quick, please turn the vehicle off and put the keys on the dashboard from the arresting officer. Maybe, or maybe he would have floored it. Maybe he would have thrown it into gear and run the officers over or harm them in some other way. You don't know. hindsight is 2020. I think the best criticism of Officer Lucky is that he should have closed the door. That is practical. It's doable at the time without much intervention or loss of control of the person, or even technically Kim Potter maybe could have come around and closed the door when they started to affect the arrest, but they didn't, and we're outside of that sort of analysis. Sil Scharfrichter says, "Excuse me, did you ask a question?" Mike the Dad Crosby says, "Vehicular homicide." Read that one. Next, not applicable says string bean and dump truck. Oh shoot, where do we go? YouTube just reset my chats, so oh goodness. Oh my, here we go. Not applicable. Says string bean and dump truck are going to be there. I hope so. I hope they show up. Larry and Christelle says it's hard to get a suit tailored to fit over my Archangel wings. KFG says this witness is politely making the DA look like a jerk ass. PS says, Nick, did you appear on local radio a few years ago? Like 93X or K-Fan? Only been here a couple months, but your name sounded familiar. Maybe a commercial for your practice? Probably not to any of those. I don't know if they may have mentioned. It's theoretically possible they mentioned something that I said, but I'm not aware of that. Sorry. Jameson Gross says, does Earl Grey remind you of Matt Foley when he does the van down by the river skit on Saturday Night Live? Found you during the Rittenhouse trial. Love the content. Yes, lots of that. KFG says, love how these witnesses always the witness always asks the DA to repeat his sarcasm. I'm sorry, I didn't hear you. Lol. Tyranna Cygnus says, happy birthday, little Nikki. How does it work with your nose in a different time zone? Well, it just got older faster. Ryan Shaw says, opinion on tasers being designed not like pistols. Positives and negatives. I mean, the reason it's designed to function like a pistol is because pistols are exceedingly functional, intuitively functional. If you had like a straight handle on it and you had this weird grip, it wouldn't be as secure in your hand. You might not be as accurate, and it's just not a natural thing. Your hand is this way is natural, this way is not.
Yeah,
so,
they've been out for 30 years. Believe me, if Taser could come up with an effective design that didn't look like a pistol, we'd have it on the marketplace.
Yeah. Bishop Craig said, I think they initially did have that sort of horizontal handle on them. If I remember from the expert movie 3 Ninjas, when they confronted Mr. Tanaka, I believe they tried to tase him, and they had one of those horizontal tasers with a big box in front that would shoot out the prongs. But I might be wrong on that, or there could have been a movie prop. Bishop Craig says, did you get my email about the Pete Sharp case? Maybe, man, but I have not, I've not gone meticulously through my email recently because I've been covering this case and it takes up most of my time. Was that 3 Ninjas Knuckle Up? I think it was. Volpe Fox says, I love when Frank was trying to say he was wrong because IAMS didn't mention the reasonable officer standard that his expert used. IAMS doesn't need the standard because he is the standard. and he was trying to get him to say magic. Oh, you didn't say magic words, therefore you're wrong. And of course, the worst part is he knew that he had used the magic words in discussing Graham in a different context and then brought that up later. I thought that was a backfire. Mr. Armageddon says, happy birthday, Nick. Thank you. DJ Mannix, welcome to Paralegal. Jesus Davia says, hey, Nick, happy birthday. I just wanted to thank you for the coverage on the Kyle Rittenhouse case. Keep doing what you do. Hey, thanks, brother. Best Mom says, Detective Gumshoe voice. I don't understand your question. Can you repeat it without sounding like a chuckle fuck? Nathan Marty says, yo, happy birthday, homie. Shout out to Scott at Marty Auto. Hey, thanks, Nathan Marty. And shout out to Scott. You get it, guys. Gordo Fabulous says, congrats, Nick, on your 5th annual 40th birthday. This is my first one. DJ Mannix, thank you for upgrading to lawyer status. Corey Boatwright says, I'm on a delay, but I can't believe they haven't pointed out Potter moved her thumb to flip the taser switch on her gun as another indicator of intent. Is that clear somewhere? I haven't seen that. Kurzixa says, happy birthday, Nick. I love your streams. I know more about Wisconsin, Texas, and Minnesota law than I do in my own state of Louisiana as a result of them. Brutus says, Andrew, how many NFA tax stamps do you have? And how is the NFA not unconstitutional, knowing it taxes a constitutional right?
It's all unconstitutional. All the gun laws preemptively applied to law-abiding, mentally sound American citizens are unconstitutional. But no one's made me king yet, so there's nothing I can do about it.
So you say you're not a gun law guy, but I agree with that opinion so thoroughly that you must be.
I'm so much not a gun law guy, I don't want there to be any gun laws because I think they're completely pointless.
You didn't answer the first question. You don't have to, but he asked how many tax stamps do you have?
Yeah, I decline to answer that question.
That's the smartest answer possible. Carl Lennon says, happy birthday to US. To us, not US. I too was born on this day in 1981. Hey, awesome. Congrats on sharing a birthday with me. Cheers to a new decade of life. Get it, Carl. Thank you, brother. Daniel Gray says, can a juror be held in contempt for yelling out boring? The prosecutor speaks. Potentially. Brian Schell says, P365XL, best choice. Good taste, Mr. Branca. Rizuno Kairu says, but we need you to read dirty things in a naughty voice. Hughley said, why would you not object at this point? Happy to let him dig his own grave. None Your Business says, Nick, give this super chat to Branca for taking over the stream for you. Trooper says, happy birthday, King. Does that mean we got to put up with stories of you walking in the snow now? Yes. Branca is definitely the best co-pilot. Here's 5 for 4, some insure.
Hey, Nick, can I mention one thing? Because I saw a few comments here from people saying, what if they can't make the January 8th class date because they have some conflict? On that same registration page, there is an option for an upgraded package that includes a 4 DVD set of essentially the same class. Not this one, of course, that's in the future, but the course we've recorded on DVD, plus the specific state law for your individual state. You pull from a pull-down list. It's a little more money, but it's still less expensive to buy it as that package for this class, even if you can't make the actual class, than if you bought those items separately. So if you're interested in the content, but you can't make the class date, I would still send you to that same URL, lawofselfdefense.com/advanced, and you can see that DVD option there.
Very, very cool. O'Reef, by the way, if you ever want, you can always say something. So anytime. Says, I suggest non-Romeo had to fail on 365.
That's what I hear. Yeah, that's why I'm looking at I hear the Holosun 507K is a good fit for the 365 XL.
Are these red dots you're talking
Yeah.
about? Okay. Nicholas Gay says, happy birthday, Nick. I'm channeling my inner Iams and driving from Nebraska to Alabama today. Listening to y'all is what's keeping me going. Thanks. Hey, good, brother. Drive safe. Scott Bain says, happy birthday. Hey, thank you. Nudge says, happy birthday, Nick. More power to your elbow. Thank you. I don't know what that means. George Michael says, Andrew, I swear I've seen you at Tony's Meats before.
Yeah, we have a couple of those around. I'm sure I've been in.
Matt Langdale, thank you for the donation. Mike Doherty says, happy birthday, Nick. Don't cross the streams. Poseidon says, been watching for a while. Good stuff. Also, I have had a suspect reverse into my vehicle to flee. Thank you. Thank you for sharing. Jennifer B says, Nick, happy birthday. Just crawled over the hill too. Andrew, happy belated. You silver fox also. We'll be praying for you and the missus on Monday.
Thank you.
Yeetwood Max says, this is Missouri country. Missouri country. New dislike button says, I don't know why, but every time I hear a witness say correct, I keep getting Grosskreutz flashbacks when he snitched on himself and his smug face. I hate it. Michael Harris says, MSP police chase Kalamazoo dash cam video on YouTube. Fleeing suspect puts his vehicle in reverse, attempting to strike officer and patrol car behind. The Sherry 19. That was such a disingenuous question. Well, it's not really reasonable for them to put their car in reverse if they're trying to flee, is it?
It's not reasonable to not comply with arrest. I mean,
right.
You're
It's
criminals.
not reasonable to flee. The flee itself is unreasonable. What they do during it. Phew. Oh, here we go. Alex McCamey, I think I missed this one earlier, says, what they aren't talking about are the electrodes on the Taser cartridge. You can shoot the darts with very close spread, then apply the Taser cartridge to another part of the body to get neuromuscular incapacitation. The Sherry 1955 says, FYI, you can get some amazing personalized whiskey glasses on Etsy. Some will make a deal for larger order. Really very nice stuff. Happy birthday. Thank you. Corey Boatwright says, Schrodinger's driver can't tase him because he's operating a vehicle, can't shoot him because he's not operating the vehicle. Ghost of Aces says the police chief was a more credible witness and, in my opinion, judge of use of force since he was active longer than Mr. Organic Whole Wheat yesterday. New dislike button says she don't need a taser gun. She could just use that forehead. Jay Sizzle says, Simpin' ain't easy. Thanks for the coverage, Nick and panel. Rumply Dipu says, Your Honor, I make a motion that we relocate the trial to Kenosha, Wisconsin, where the police women are hotter. Jared Vatrat says, every time Gray gives up the podium, he leaves his water. Forgetful, focused, professional, or alpha power move. He does always get to go in and remember to grab his water in the middle of the state's testimony.
Sorry, I forgot my vodka.
Sorry, I wouldn't want my voice to sound raspy. I need my water. 200 Watt Studio says, Andrew, how can you be ambivalent about being on Megyn Kelly? Nick should send her the link.
Yeah, that was today's show where I had to duck out.
John O'Brien says, this is 2D chess. Throw them the witness and let him make himself look awful. Let's see. Lisa Beck says, I had 3 margaritas on my lunch break, and now I'm drunk at work, all to celebrate my son and Nick's birthday. Happy birthday. Awesome, Lisa. Get it. Within the confines of your company's policy, of course. Rice Jones says, happy fetus day from the Australian gulag. Also, you have made me a Ricada addict. I'm watching you and not playing Skyrim. What? Far be it from me to, to suggest otherwise, but you could do both. Get a second monitor and you could do both. Kyle Bogue says, I love Minnesota. We have interesting weather, culture, entertainment, etc. But good Lord, these Democrats that Minneapolis and St. Paul keep putting in charge make me want to bolt for Texas so bad. Kyle, brother, these taxes. Kirill Ragazin says, happy birthday from the land of the rising sun. It's 5 a.m. and instead of getting ready for the day, here I am watching this. What have you done? Hopefully ruined several people in the best way. Revenant says, any chance of a stream showing the bar, the depositions from the Vic case? Could be funny. That would be really long. Those were long depositions already. I don't know if that would practically work out. Sorensen Farm says, Mommy Judge looks at Earl like Nick looks at those Ritz Reese's cookies. Really now says, Mommy Judge, I think, is losing her patience. Aaron Feist says, go Pack, go. And thanks for all the legal coverage. That is all. Thank you, brother. Nathaniel Hyde says, if I were to need a defense lawyer, I would want the voice of Mark Richards in The Passion of Earl Grey. G-Man says, Mr. Gannon, while you were chief of police, did your department have a track record of hiring hysterical women? The state rests. Loretta Silver member says, Paul looks wholesome, like an old guy in a Disney movie with glasses and rosy cheeks. S. Asp says, cause the dude would puck him up. Angry Bainling says, orally. Judge Chu said orally. Mr. Judge says, when is Earl Grey going to tell everyone I live in a van down by the river? He's obviously Chris Farley reincarnated playing an attorney. Terry Van Veldhuizen says, happy birthday, Nick. My birthday is tomorrow, the 17th. Thank you for being on top of this case. I appreciate your input. Thank you, Terry. Ron Mexico says, Judge Chu is trolling the chat by telling him to answer orally. Flamethrower says, would it get you off the jury or the stand if you can convince the court you're a complete idiot? Yeah. I mean, you don't have to go that far, but yeah, that could get you off a jury. Venray Lull says, I was listening while working and thought they got Vince McMahon as a witness for a moment. Sublime and Slime says, happy 40th. Here's $40 from Save America, established 2017 Discord. Because we all know it only goes downhill from here. Thanks for keeping us entertained while we work from home. Enjoy a cheap bottle on us. Hey, thank you. MB says, how big is your liquor collection? I'm impressed with the variety. You consume plenty too, but I'd watch a late night whiskey tour stream. Happy birthday. Right now I have 1, 2, 3, 4, 5, 6 bottles is all. I don't keep a lot. I just go through a bottle at a time. And I try to keep buying different stuff. Elena Danner says, Kyle testified on day 8 of his trial. I wonder if Kim will testify on day 8 of her trial as well. Happy birthday, Nick. Thank you. No, she'll testify. Yeah, tomorrow's day 8.
Is it?
Day
yes,
8
it
of
is.
testimony. Yeah,
that's right.
Steve says publicaccess.courts.state.mn.us. Gregory Master says, happy birthday, Nick. My wife's birthday was yesterday and mine is Saturday the 18th. Happy belated birthday, Andrew. Love watching these live streams. My mom loves watching too. Shout her out, Paula Balu. Hey, Paula, how's it going? Thanks for watching, joining us on this half pseudo degeneracy. We appreciate you. Matthew Self says, you need to appear on the Iced Coffee Hour podcast and speak about your YouTube success and what you cover to raise awareness. It is a finance channel, but could reach a reasonable, open-minded viewers. Be happy to do. I'm happy to do all sorts of appearances so long as scheduling permits. Leftover Liz. No, Leaf Lover Liz. Sorry. So, welcome to Paralegal Status. Chris Kelly says, Judge Schroeder, the Asian food is here. Ninjudge says, the food is here. Thanks for the hours of entertainment, Nick and company. Tyler Wales says, imagine being on the jury and being on the fence and sending someone to prison, and then you find out the truth of Wright's criminal past after the verdict. Music and Fiction says, you dared us, so we respond orally. Anthony Garda says, I live here. I'll definitely help. And B says, do the book delivery stream during the Zeminski trial. Happy says, if Potter was found guilty, how much time will she serve? I think it depends, first or second degree manslaughter, but I think on first degree manslaughter, it's 10 years. Something like that.
That sounds pretty typical. I wrote about it, but I can't remember now off the top of my head. But 10 years would be pretty typical for a manslaughter conviction.
Yeah, and she will likely there are aggravating factors. Whether or not the judge will use them for an upward departure will depend on the judge, but it could be it could really honestly be anywhere between 6 and 20 years when considering aggravating factors, I would think. Shelly DeLuca says, watch how much they will hammer Kim on her statement, I'm going to prison. Yep. They're going to spend time on that, but she'll just simply say, in the environment we were in, I was worried that people would think I did it on purpose when I didn't, something like that. Power Keg Greg says, happy birthday, Nick. Thanks for what you do. That nose conslutes. Thank you, Power Keg. Black Tiger 001 says, happy birthdays, both present and belated. Prayers and well wishes to Andrew. Can Binger pull a harassment crap for the gifts? I don't know how he could.
I'm only going once.
Yeah. What they could do is when we show up with the books, they could ask us to leave, which of course we would do because, that's just how that works. Not really interested in any criminal charges, but it would be a hard call to say it's harassment to bring somebody a book. Ace of Spades says, oh yes, mommy judge, keep sustaining those objections. Oh yes, sultry mommy, I'm going to go Kermit a felony just to see you. And happy birthday, Nikki. Once she said orally, my BGC shot faster than Kim Potter's pistol. Oh, come on. No. Project's Done Poorly says, Andrew, if I take your class, can I show Binger all my AR-15s?
It's up to you.
James G says, you should deliver the books prior to the class so you can remind Fluffer and Fat Boy not to miss a class on the 6th. I don't think that's going to be possible. Galaxy Express Media says, with this trial, the state is reinforcing my principle of taxation is theft. Correct. Marksman says, baby arms Ricada. That's right. TLJ Screwjob says, Iam's bullets can shoot through the law of self-defense by Andrew Bronca. Perihelion says, happy birthday, Nick. The most terrifying thought is you're now counting down to your 50s. I'll be in your place in 5 years. Where did all those years go? They just vanish, but it's okay. It's a good vanishing. Vincent says 52 pages trying to convince us he's not T. Claire with his drawn on chin strap. Batman sunned him today. Happy birthday, bigot. Renal Ryan says that Binger can get guard from a Major Johnson. Thermasius says, yeah, you're old, but are you just walking down steps hurts your knee, so now you have to wear a knee brace? Old. By the way, I'm 1 year older than you. No, yesterday I was doing an activity with my kids at the church, and we had to jump over this thing. My heel still hurts. I feel like I smashed my heel with a hammer today. So yes, I am. Cora M says, happy birthday, Nick. Known you since 2019. I'll do your birth chat for free. Birth chat. Specialist Chad made me stop my skincare regimen to see if his skin is better than mine. Thank you, Cora. Silo 101 says, I'll energize you. I'll energize you. Aaron Catron says, happy birthday. I've got no Lagavulin handy to toast you, but I'll have some Hadazaki small batch tonight in your honor. Try it if you haven't. Japanese whiskey is where it's at. I'm a big fan of Japanese whiskey when I can find it around here. It's tough. We're almost there. Stephen Oglesby says, is it me or does that young prosecutor look like one of the elves on Rudolph the Redness Reindeer? That guy in the purple says, all hail King Grifter, who should now be known as Griffmas Prime. Happy birthday and way to reach level 40. Hey, thank you. Stephen Oglesby says, happy birthday. You're getting old. Tim Doucette says, Gray, Mr. Stoughton, is this the paper that you published? Yes, sir, it is. Did your mom put it on her fridge? Tim Doucette says, when Iams was born, the doctor said, congratulations, it's a man. Daniel Aaron says Dante Wright was mostly peaceful. Blue-eyed Roof Korean says prosecution use of force expert is a communist parrot doing Ellison's bidding on new policing. Potter not guilty, but I have no faith in communist jury. Jeff Patriot says we don't believe the lie no more. Forget about 2024 because 2020 was fluid and it's still broken. I think you mean fixed. Bobcat says based on the prosecutors we've seen so far, I doubt that the U.S.'s North Korea as conviction rate is legitimate. Well, there's lots of pleas in there. Alexei Sabayshev says, any objection is overruled. You will proceed orally. 11 Bravo Crunchy says, YouTube sucks. Sub to you, and it hasn't listed the stream at the top of any of my lists at all today. Yeah, that's the story of my life. The Don Natty, welcome to Paralegal. Thank you. AA Ron says ATC makes good red dots too. Plus, they're made in Minnesota. 2D Harem King Jack says nothing like listening to my favorite grifter and playing Doom Eternal. Happy birthday, Nikki. And I'm sorry to hear about your wife, Andrew. Black Tiger says, can you give Binger a bottle of Rittenhouse Rye? I accept that I'm not buying Rittenhouse Rye anymore after their ludicrous statement. Otherwise, yeah, I could. 200 Watt Studio says, love seeing Dollar Store Jeremy Renner get BTFO'd on his cross to the female cop. Phantasmagorical says, happy birthday, youngish. Where's that fabulous sweater? Ravenclaw rules. It's in the dirty clothes now. Rabbi Sheckelstein says, did you ever see the video of someone kneeling on Steven Crowder's neck for 9 minutes? He was able to talk and breathe for the whole 9 minutes. I didn't watch that video, no. Phantasmagorical says, youngin, stupid autocorrect. And then Isaac Bowles says, Mr. Bronca, why always have a look on his face like he's in the middle of engineering a new model of Tesla? It's because you're working, right? You're live tweeting what's going on in the trial while you're here on the show.
That's right.
So this man is pulling double duty so he can be here and hang out with us. With that, we're done. We're done. So I'm going to play the outro. Again, thanks for hanging out as always. It makes these streams a whole lot more fun.
Sure. Fun here too. I got a couple more hours of work to do my my end of day write up of the day's events, but then I'll be done soon. Yeah.
I will, guys. I believe I will have a stream at 11 p.m. tonight. It will either be on YouTube or Twitch. I think YouTube, but it might be on Twitch just in case. I'm watching out for the Vic decision possibly to come down. Only if God likes me on my birthday. And by God, I mean the Second Court of Appeals of Texas. So we'll see if that happens. Otherwise, I will be back here tomorrow, 8:45-ish a.m. Central Time for the continuation of Kim Potter's trial. And tomorrow should be a very explosive day. Make sure you share it with anybody who's been following the case so that they know that that tomorrow is her testimony and the slip and capture testimony. Two of the most critical elements of the trial will happen tomorrow. Maybe more, but definitely those two. And thank you all for watching. Y'all have a great night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an odd bag of bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law